guys, what's up? It's Debbie, and we are back with day two or part two, I'm sorry, part two of the Darrell Brooks, Wisconsin v. Darrell Brooks, the Waukesha Christmas Parade Massacre. Is massacre the right word if you're using a car? Yeah, it was a massacre. I found some more pre-trial hearings that we didn't watch. I don't know if you guys want to do it. One's 3 hours, one's an hour and a half, two of them are 3 hours. We watched one yesterday, and then the other one we were going to watch today is 3 hours. So that's going to take us a while before we get to the actual trial. But I think we need to do them. Because I didn't see pretrial hearings. It might help understand some of the things that happened in the trial. Good morning, Judy. Sorry. Thank you, Judy. The week of giving continues. Thank you so much. I appreciate it so much, Judy. I don't know why you're doing this, but I appreciate it. Believe me, I appreciate it so much. She's gifted 15 memberships every day this week. And then Monday, she added a couple of super chats as well. Thank you so much, Judy. Thank you for supporting the channel. Thank you for always being here. You're my sidekick. You always help us by Googling stuff when we have questions and giving us lots of background and trivia. Mac Boy Fly was the rap name of Darrell Brooks. His most famous one is titled "Da Business." It is not the video we will see in the trial. Da Business. Math Boy, spelled Mathboi. Math Boy Fly. Hey, Jennifer. Hey, Marty. Hey, Wiggles. Thank you, Wiggles. Thank you, Jen. Thank you, Judy. Oh, Massacre's because the amount of people, not the weapon. Okay. Thank you, Marty. Everybody's saying bless you. Yes, pollen is stupid. So, is this your birthday week and that's why you're giving? I'm glad you're giving. I don't care why. Okay, so Do we want to watch all these pretrial hearings? Okay, so this is back when he still had attorneys. I push play. Why is nothing happening?
But I also promised the parties they'd have an opportunity to ask individual questions, both with all the jurors and through what we typically call individual voir dire, right? I mean, one-on-one outside the presence of the other jurors. But I want to know ahead of time what those requests are, because one, that may alter how I question them during jury selection, but also just to really form kind of a game plan on when would be the appropriate time to do that. Because what will need to happen is, and if I haven't made this clear, you'll learn this today. So obviously we'll be doing jury selection in this courtroom. The courtroom next door to us, which is normally occupied by one of my colleagues, will be available to us during jury selection. So if there is the need to do individual questioning of a juror, the jurors who aren't being questioned are going to go into that courtroom. They'll be monitored by court staff. And then we'll proceed in the courtroom with that individual jury selection. Now, the same will be true, but in a little bit different format, because jury selection will also involve some remote observation by the jurors. You all are in this courtroom. You can see I have 4 benches per on each side of the courtroom. I can't fit 105 jurors in this courtroom. I can fit a large amount of jurors. Probably what I was thinking is to do about 40 jurors, so that kind of gives me a little bit of a cushion.
Oh.
If there are strikes for cause, we know we need 36 in the box to get the 10 strikes each, and then down to 16. So I thought if I had 5 extra or so. And then the remainder of the jurors will be in room 215. That is where what will be our jury assembly room for this trial. And so
Bill.
they will be watching through but what they will, actually, I won't be live streaming voir dire. What they will be watching is I will be able to connect them through the room systems, Polycom to Polycom. And if there gets to be a point in time where we need individual voir dire, I can turn that off so they're not seeing it. But the entire 105 jurors who were called in the first day will be sworn in either in front of us or while they're in 215. Again, there will be ample staff there from the clerk's office monitoring them.
Because I found more pretrial hearings from before that I didn't find yesterday. So there's some pretrial hearings before he fired his lawyers that we didn't see. I just didn't find them yesterday. I found them this morning.
We'll be able to see some of them, and we have on our list of things to do some test, audiovisual tests with the system, since we're in the new tower, and that's in the existing courthouse, just to see how that looks. We're probably not going to see all of them, but they'll have a folder that the clerk's office prepares. It will have their jury questionnaire. it will have the additional questions that we approve here today that they fill out ahead of time. Then, of course, copies will need to be made and handed out to the parties. And then a pad of paper, a pen. My script will be, all the questions will be by number so they can follow along, and if they'll be instructed as the judge goes through jury selection. If question 1 you would have raised your hand to, you need to write that down, write some notes to yourself so you know what that answer is. And then ultimately, if any of those jurors from 215 are brought down here because we've had a number of strikes for cause, then I can very easily go through those questions with them and ask them some simple, you've heard questions 1 through, let's say I've gone through 25 at that point. Any of those questions would you have raised your hand to and answered? What would your answers have been? So that's how the jury selection process and really the staging of it will go, with about 40 here, the remainder in 215, functioning as the jury assembly room, but with that connection to us by means of the Polycom systems in each. So getting back to what was on my housekeeping list, before I get to, anyone have any questions about that? Everyone understand kind of conceptually what I have envisioned for jury selection from the state? Yes, thank you. From the defense.
I just want to clarify. Is it your request that the ultimate list we provide to you are only those items that we think need to be done outside of the presence of the rest of the jury pool, or is it all items that we intend to follow up with particular potential jurors?
Why did you stick your nose in my pocket? There's
I'd
nothing
say both
in my
with a
pocket,
caveat.
Belle.
Certainly the first part of that, any juror that you believe should
There's
be
nothing in my
subject to
pocket.
individual voir dire and what question, or end on what question. And then if there's any follow-up you want the court to do, as opposed to you asking that follow-up at the appropriate time, since both sides are going to be able to do follow-up as well.
So if there are items, from things that we objected to, that we brought up, that we think need following up, but are comfortable doing it in the presence of other people, like their answers wouldn't taint the rest of the jury pool.
Yeah, I think that's what she was doing.
We would like to do that ourselves. We don't need to have that all spelled out in advance.
Correct. It's only if you want the court to do it on your behalf.
I got no cookies in my pocket.
Thanks.
Since I'm doing the bulk of it, right, sometimes it just makes more sense, but yeah. Any questions on that from the state? No. Okay. So I was thinking then, let me look at a calendar. Oh, I did have I thought I wrote it in the email, by 9/26. So that's, so September 26th for that list. I think that's doable for everyone. I'm sorry, Judge. Just the due date for the parties to notify me of the jurors, and you can focus on, well, to you on whether it's all of the remaining jurors that we have, or focusing on the first 105 who will be called the first day.
Yeah, I see it. That's a cookie jar.
My thought is, if we end up needing to go above and beyond the 105, you might have a little homework on that Monday night to work and submit something to me by the morning, but that should limit your work a little bit. Anyone have any questions? I tried to describe it as best I could in the email about how the jurors, or when they will be re-randomized. And I can just explain it on the record if in any event. So we're not able to re-randomize the jurors until they check in. And so my intent, again, is to call 105 each day. And if need be, we would go to the remaining number on the fourth day. It's possible that a juror or two not show up have a family emergency or something. And so we don't want to re-randomize them until everyone's checked in that first day. So that 105 initially will be reshuffled, shall we say. And if you think about what we do in most trials, you get that list where, 1 through 26, maybe on a simpler case. Well, your list will have 1 through 105, and I can't pull out from the 300 and we're down to maybe 340 now. I can't randomize them yet, but I can do that when they come in, starting with 105. And then if we have to keep going successive days, I'm told the computer application program will keep adding to that without readjusting the first 105. So it kind of helps you in preparing. You can at least start with the first 105 for preparation for October 3rd. Any questions on that? I know it's not the most clear because it's a little bit different what we had to do in this case, but hopefully that makes sense. From the state?
We're good, thank you.
From the defense?
No questions on that.
Okay. All right, then, since we're on the topic of jury selection, I know the parties, this is number 6 on my email, have submitted some follow-up questions for the court to consider in a supplemental written questionnaire to give to the jurors as they enter in and check in for jury selection, fill out, and then the answers would be provided to the parties prior to the jurors being brought in to court and sworn in. So I have a list that the defense has filed, which are 8 questions. And then there's 2 questions. I think the state's questions, were those just to my general script to do during court-led voir dire, or were those for the supplemental?
That was for the supplemental.
Okay. All right, so just let me ask the state, have you had an opportunity to review the questions submitted by the defense?
I have,
Any position on those?
yes.
Okay, go ahead.
On question 1, which the question is, since you first completed the jury questionnaire in this case, what additional information have you learned about Darrell Brooks and the charges against him? Frankly, that's so general. I guess there's a little bit more specific in my question 1. I think it's trying to elicit the same types of responses. Again, what additional information have you learned about Darrell Brooks? I think the best way to go is to, here's your questionnaire, please review it. Would you change the answers? Now, some of those questions, as I have the jury questionnaire before me, is, what information, did you see any information about Mr. Brooks in his prior cases? Did you see any media coverage of the parade incident? So I think that I really want them to reference that questionnaire.
And I think that's what your question 1 on your supplement
Correct.
tries to do. It's really broad, says review it, look at it. Would any of your responses be different sitting here today?
Correct, because I think then that encompasses like question number 2. Have you attended any recent fundraisers or solidarity events for victims associated with the parade? And again, that was a question that was asked in the original questionnaire, and that would be encompassed in my question 1. Same thing with number 6. Would you describe the parade as a transformative event, either for yourself or surrounding community? And again, I think as it relates to themselves, that would be in the questionnaire. The surrounding community, I don't know really the relevance of that to a particular juror.
Can we hear all of your objections and I'll have the defense respond?
Again, I think number 3, have you read any recent media coverage of the case against Darrell Brooks? I think that's also encompassed in number 1. Have you spoken with anyone with direct knowledge of the November 21st parade? I'm assuming that the courts, again, I reviewed the sample questions. I think that's probably something the court's going to be including in the general voir dire initially, I would think. Number 5, the courts denied the other access motion, so I think that is irrelevant. Again, number 6, I already talked about. I think that's encompassed in my question number 1. Number 7, if you know someone who is directly affected by or is closely connected, again, that was addressed by the jury questionnaire. And then number 8, at this moment in time, is Darrell Brooks guilty or not guilty? Frankly, I thought it should be, and I think this is a question that oftentimes is asked by the court, as Mr. Brooks sits here today, he is innocent. Does anyone disagree with the state of the law with regarding that? I mean, I think that's just always been a question that a court has answered or is asked. So again, I thought the question in of itself, I don't think was probably worded from how I view it. I think they need to be shown, this is the law. He's innocent as he sits here today. Is there anyone that disagrees with that?
All right, thank you. For the defense, the response?
Well, we'd agree agree that number 5 of our proposed questions could be stricken, but I don't think that it has to be one or the other. They're going to be provided with the questionnaires. They're going to be asked to update it, but we are hoping to draw attention to certain things and cast a wide net. And it's one thing, I think, just from, we've all experienced being handed something that's, in this instance, it's, in excess of 100 questions, I think. And being asked to say, do you need to update anything in here in terms of the careful reading through versus the attention being drawn to a number of items and being asked about those number of items. So I think they should do both, frankly. I think they should be given their questionnaires, asked to update it if there are any. But the goal here, right, should be doing everything possible to ensure that we're not missing things that would result in a biased juror sitting on this case. And so if it's, it doesn't sound like, with the exception of the wording of that final question, it doesn't sound like there's an objection to finding out this information, just that there's an objection to them being asked update the questionnaire and then being asked the specific info. And so our request is that they be asked to do both so that we can cast a wide net, I guess, is the goal. And trying to phrase these things in ways that will result in a meaningful update, as opposed to review this lengthy questionnaire and say whether or not any of your answers would be different now, as opposed to, since you submitted this, what else have you learned, and so on. I think that eventually with instructions, and this is going to be part of it all in terms of an instruction on the presumption of innocence, but it is important, and it's a different question. It's one. The question that we worded, that we suggested, is to find out how people view Mr. Brooks right now.
What?
And it's a different question. It's also important to ask is, the law is X. Do you agree with that, and can you follow that instruction? But it's important to get answers to both in terms of the bias that some people have when they walk into this courtroom, and then if that answer is yes, that needs to be explored with further questions, as opposed to an answer of, I'll follow the court's instruction, or I will agree to follow the law in this case. So we're fine with number 5 being stricken, since the other X are not coming in.
What?
But we'd ask that the remainder of the questions be asked. I don't have any objection to the state's proposed follow-up questions.
Yeah, if I could have a brief.
Go ahead.
I'm sorry. Do you have any more? Go.
I'm right here.
Okay. I guess the only thing I would say is, I think all sides, including the court, worked very hard on this questionnaire to make sure that any concerns that either side had were addressed. And I think then to start picking out certain questions, and then we're saying that the other ones, don't bother looking at those, because these are the ones that we're focused on. The jury, how important this duty is. The other thing that came to my attention, I know it wasn't on the defense list of questions, but hopefully they would agree, after having reviewed hundreds of still shots and screenshots and videos that were taken, is I think the jury needs to be prepared for that. And one question I didn't have would be something to this effect, which are graphic photographs and videos will be shown during the course of this trial that can be described as shocking and highly disturbing and may cause trauma. Knowing this, and again, the verbiage on this I'm not saying is exactly right, but can you be a fair and impartial juror? Can you sit on this case and be a fair and impartial juror? Again, these videos that we've gone through as we've met with the victims are very graphic. They're very shocking. And I think that we probably want to prepare the jury for what they're going to see.
I think I have a similar question in one of the scripts that I provided to the parties.
Prison of sexual assault.
Might have been in both then. You know, in question 41 of the Benton script, it says, in this case, you are likely to hear and see graphic testimony. Is there anyone here who, because of squeamishness or unease, believes that they would not be able to sit through such testimony and evidence? Not quite the same as what you said, and I realize certainly not at the same magnitude, although having sat through that trial, there was some very disturbing video and testimony certainly about it.
Could be along those lines. I mean, like I said, they will be shown the video, they will be shown pictures. I don't think they could be categorized as anything other than shocking to the conscience.
If you able to type that up and maybe email that to, on that email chain that we have, I think it's appropriate to ask something like that. I actually thought of a question before I rule on what you all have proffered that was not in the jury questionnaire, and I'm not sure if it's because of the timing of it, was to ask anyone whether they have made a claim in any capacity related to the parade, because that would identify a financial interest. And so I'd like to put that in the, either ask it during my script. And again, we're talking about, there's going to be a lot of questions asked that are in open court. My purpose in asking the parties to supplement would be, frankly, along the lines of what the state has offered, and that's really to have an update to what's there, review it. Has anything changed? Has any of your answers changed since the time you filled it out until now? Because I think I would agree with what you said, Attorney Bates. We spent a lot of time crafting this questionnaire in an effort to uncover any potential for bias. And that's really what the jury selection process is all about. And I think we need to keep in mind. We all know what statutory bias is. Those are the relationships, people who are related by blood or marriage to a party, related by blood or marriage to an attorney appearing in the case, anyone who has a financial interest in the case. That's why, despite what the people have asked in or answered in the jury questionnaires, we go ahead and ask those questions in any event, in every case, to make sure we hit on statutory bias. What is subjective bias, though? Because that's really what the jury selection process, in addition to if there is any statutory bias, any relationship or financial interest that we seek to uncover, is whether a prospective juror has an opinion or feeling about the case that the juror is unwilling to set aside. Subjective bias refers to a juror's actual state of mind and is usually revealed by a prospective juror during voir dire. And this is quoting from State versus Oswald and a case of State versus Foucher. That is why the court, even on one of the scripts that was sent, and maybe even both of them, has this one question that I am guided by Special Material 20 to ask, and that is, are you able to put your feelings or opinions aside and decide this case based solely on the evidence presented and the law as the court defines it for you? We also know from all of the cases that were reviewed, at least by the court, related to the motion to change venue, is that jurors come in with a presumption that they are not biased, right? They don't have a presumed bias, even in certain relationships, right?
Hey,
We ask more
David.
probing questions. And so I think these questions for this supplement need to be geared toward what's already been asked as a general, meaning like what the state has in their proposed question one, a very general question. Please review your responses to the questions in the jury questionnaire. As you sit here today, would any of your responses be different than those you originally provided? And if so, please detail the question number and your response today. That covers every single question that is on there. I am not looking, other than that, to ask them or highlight specific questions from that questionnaire again. Frankly, the parties can do that through the adversarial process and ask any follow-up that is geared toward and directed toward uncovering subjective bias. And so looking at question 2, question 3, those are really already covered in the questionnaire, so they'll have an opportunity to update that just with the one question that I've already identified that I will include. Question 4, well, not a bad question. I know that in my script, I will ask the parties, I will cover similar topics, and I will do appropriate follow-up. And
Thank you, Wiggles, for supporting the channel for 5 months. Yay! Yay! I've not heard anything about his appeal. I don't think he's going to be granted one because Judge Darrow made dang sure that everything was done right. So I don't think he's going to get one. He wants to represent himself if he does.
Parties are going to have the opportunity to do appropriate follow-ups. I don't believe we need to ask that in this supplemental that's going to be given to the jurors as they are brought in on October 3rd. So I'm not going to include question 4. Question 5, there's already been agreement, it's not needed. Question 6, there's already a question in the
She
jury
cut
questionnaire
her
about
hair.
that. It's not going to be.
She cut it. She cut it off. She cut her hair off. I couldn't believe it. What was I watching, Judy? What were we watching where her hair was cut off? I don't remember what it was. But yeah, she cut it. It's not like super short, but it's like chin length now. I was like, what did she do? Because every woman wants hair like she has. I used to have hair like that, but then I got old and it started thinning. And I thought, that's not going to happen to me. Surprise. Because I had super, super thick hair, which I guess is a good thing. I had enough to lose.
Same thing with number 7.
Yeah, it could have been.
As far as question number 8, I mean, I go through a number of questions in my standard script about the presumption of innocence. But I also think it's an important topic, and I won't take any issue with including something in there on the supplemental that touches on this topic. I like the idea, though, of saying something to the effect of, as Mr. Brooks sits here today, has anyone formed an opinion as to whether he is guilty or not guilty? Because that's really what we're getting at. Anyone have any objection to that verbiage from the state?
So that's what I would recommend.
From the defense?
That's fine.
All right, so I'll include that. And then, of course, I'll include the one I've already identified that goes to financial interest, since that was not a question in the questionnaire. And I think that's important, given that there was a process by which people involved in the parade as a victim could make a claim. And I think that's important to know if any of our potential jurors were any of those people. I know the state also had a number 2 on their list. I already include a question like that on my script, so I'm not inclined to put that in there.
As long as it's included, that's all I think.
Okay, that's usually one of the very last questions that I have, or one very close to that. All right.
I should do one additional follow-up.
Go ahead.
You addressed uncovering statutory and subjective bias. I think that as it relates to a lot of the topics that we discussed before, when we were going through the jury pool, that objective bias is going to be something that we will be trying to keep a record of in terms of our belief in potential motions for strikes for cause. I do want to put, I want to alert the state and the court. It was my notes at that hearing when we did this that the state referred everyone to the case State v. Lindell in terms of defining the different types of bias, and provided the Court of Appeals citation of 238 with second 422, and the facts in that case involved a prospective juror that had just a lot of connections to the decedent in that case, and how the court had concluded that even under that circumstance, even under those circumstances with the person's answers, that they were not objectively biased. I guess I can see how this was missed, because Westlaw doesn't flag this as yellow or red, but that case actually was reviewed by the Wisconsin Supreme Court, and the Wisconsin Supreme Court said that the facts of that case demonstrated that juror was objectively biased and should have been struck. And so I'll just provide, this will matter more when we're in jury selection, but the Supreme Court citation is 245 with second 689. That's authored by Justice Prosser.
Can I have the last part of that? You said 245 with second?
2001. And then applying the standards above, we conclude that prospective juror was objectively biased and should have been struck for cause. And so that was affirmed on harmless error, because I think a peremptory strike had been used.
I would like the parties to prepare as best as they can exhibit lists in advance of trial. I can only imagine there's going to be quite a bit of evidence that will be offered. I would like the state to start at number 1 and use numbers and the defense with letters. I think that just keeps it simplest. And I'm happy if you just provide that leading up to trial, even the morning of, to Teresa. It's just so that we can keep track of everything as it comes in and someone anticipate if we have those lists provided ahead of time. Any objection from the parties from the state?
Just to clarify, that's not a ban on using other items that we didn't anticipate needing?
It's not a ban.
Oh.
Right, you know, and if you end up adding something later on, it'll just be at the end of your number.
Okay, thank you.
And if you don't use something, it's typical, it happens.
That's
you know.
what I'm afraid of, honestly. We'll mark way more than we need to, but I understand the concern you're trying to prevent, so.
I'm open to discussion if you think there's a better way. I just really want to know, you know, have a general idea of what you anticipate being offered so that Teresa and I can keep track of that.
Okay.
Right. Any objection from the defense?
No, we will do that as best as we can.
Sounds good, thank you. See, I said that was an easy one. Everyone had an opportunity to review the revised order governing trial administration. You'll see in that it does address some seating. Will be some reservation of rows throughout the trial, but yet some caveats to all of that. It does indicate to the media I will not be live streaming the jury selection process. I think that's for obvious reasons. It is in no way limiting their attendance. It just is providing, for example, that any audio visual recording actually be done of visual only, that it not capture the questions and answers. If it's not obvious, the jury selection may take more than a day, and while I respect the media's right to be present and to report on these events, what I'm trying to do is limit any exposure to potential jurors. What you should be aware of, though, is I am telling them in advance not to watch the proceedings. I had been working with Lauren in the clerk's office on a packet of information really that is going out to these jurors about things like where to park, what door to enter. But I'm also including a modified preliminary instruction 50, telling them to avoid to not watch any of the proceedings coverage, read any articles, do not, so that they're limited. I need to get the revised letter from Lauren, and I'll email that to the parties. You can look at that, and if there are any issues, we can do that offline. But
When did you think you were going to send that out, Judge?
it needs to go out, so I need to. I meant to give that to you all, and frankly, I gave her the revisions and then forgot to have her email it back to me. So I'll have Teresa message her now, and if she can email it to all of us, so you can see that maybe even while we're sitting here this morning or this afternoon. But again, at least this order touches upon some of that. That's obviously not necessarily, it's your concern, but the media may have a concern about that. But I try to balance everyone's right to be present. It's a very limited restriction, if you will, on just during the jury selection process. That they can't capture any audio. I'm allowing for them, I don't even want them recording other than, I think I put in there 30 minutes of B-roll, so they have appropriate coverage. Doesn't limit, they can take photographs, video of me, of all of you. They're not to, of course, capture any images of jurors. There's already in the order a prohibition on photographing and capturing victims. We'll need to get to your specific request in due course, but this is the general order. But anyone have any issues with that in the state?
Not on that topic. I did want to have some questions about the seating, the issues under the heading of seating.
Go ahead.
So I was a little unclear as to what you meant by, on the fourth sentence under that section, you wrote, the court will determine with counsel from both parties the number of seats they wish to have assigned to them in the public gallery, if any.
Were there any need, for example, are you going to ask that I reserve 2 spots for any additional support staff, for example? That can't fit at the 2 tables that I have here.
Okay. Okay.
That's what I meant by that.
Okay. And then could we just understand the reserved seating arrangement to make sure that I understood what the court was saying? So you have indicated the first and second row behind the prosecution table will be reserved for victims. First row behind the defense table will be reserved for the defendant's family. Last row in the gallery will be reserved for the media. So I assume that means both sides of the courtroom for that.
Correct.
And that would mean the benches in between, which I'm counting, we've got 4 on each side, right?
Correct.
So like on the defense side, benches 2 and 3 are just general seating, general admission, right? Okay. And row 3 on the prosecution side is general admission.
Correct.
If victims come and there's not room for them in rows 1 and 2 and there's space in those benches, may they sit there if there's space?
After 15 minutes,
Okay.
after the start of each session in the morning and the afternoon. I'm told that there are ample arrangements made for the victims to watch the proceedings in what was courtroom 115, that has completely been renovated for that purpose. So we can't fit every victim in this courtroom.
I certainly understand that, Judge. I just wanted to understand, if there is an open seat and there's a victim that wants to be present in the courtroom, they may sit there, assuming it's not being used by someone else.
Absolutely.
Okay, and then.
And let me also add, I have no idea how many media are going to want to watch. They're going to get the jury assembly room. They may all watch remotely. They have the media room that's in the back. If it becomes apparent that they only need 1 row or a portion of a row, I mean, we'll adjust.
Okay.
So, but at least wanted to do something so that when we come here on the day of trial, it's not chaotic.
I really appreciate that, Your Honor, and I understand you have a lot of interest and balance here, so thank you for doing that.
I appreciate that because I do have to balance victims, the right of the public, the right of the media, and the defendant's right, and anyone who's associated with those groups.
Sure.
And as you know, there are 8 rows that I am limited to in this courtroom, so.
I just also had to leave, but they will not be permitted to re-enter until there's a break.
I want to limit distractions in this trial for our jury. I understand people may need to get up and use the restroom, but they're going to have to wait to come
She
back. And
wants
that's
to
for everyone,
limit
media,
distractions.
otherwise.
Oh,
trying to
that's
avoid all the
hilarious.
coming and going.
I respect that, Your Honor, and that's certainly a legitimate goal. I think even the attorneys find that distracting when that door is opening and shutting all the time. My question is, and again, a lot of it depends on timing, right? But I mean, usually we'll be taking a break around 10 o'clock, 10:30 somewhere each morning, right?
Right.
If in the next sentence you wrote, the sheriff's department can use discretion in enforcing this. So obviously we don't want people jumping up every 5 minutes to get a drink of water, but if a victim or anybody would be upset by the testimony, and we've already told you there's going to be some very disturbing images shown, and they would choose to step out, because that's what we'll tell them also, right, is we don't want overt displays of emotion in the courtroom as well. And that happens at 8:45, and then we're not taking a break till 10:30, but by 9:15 they're feeling better. If there's a seat open and it's not disruptive, can they quietly come in and sit back down? I know I'm asking you hypotheticals basically, but I just want to, give that example of, we agree. We're not
We'll
going to
ask the
people-
sheriff to use common
Okay.
sense when allowing exceptions to this, if it's not going to be disruptive, if it's one person, if 5 people get up and leave and 5 people want to come back in, that's a different situation.
Sure,
It's a lot more noise,
Yes.
shall we say.
Yes.
So,
I agree. Just, I mean, with the nature of the testimony, like if we're talking about a particular victim's injuries and that family happens to be here and they want to step out, but then we move on to a different witness and a whole different area of testimony, then they may want to return if it's reasonable. And if it becomes burdensome or disruptive, then I'm sure the court will let us know, and we'll.
I presume you'll have staff, the victim witness room, that's the conference room attached to the courtroom as well. They always have that option as well.
Sure, okay.
So,
Thank you very much.
you're welcome. Attorney Perry, you had an opportunity, you and co-counsel, to review this.
We have, I would ask, this relates to something we just talked about in terms of the court determining the council number of seats which is assigned in the public gallery. I would ask that we do have a few, and that those people from our staff be permitted to use their computers. Since it would be, here at our request and doing notes and things like that, and that as it relates to electronic devices earlier on.
Will any of them be at the table behind you? Because we do have that option as well.
Yeah, it's possible that one person will be, but I'm anticipating in terms of other staff sort of being able to attend parts of it and assist us with parts of it, that I wouldn't want just like, different faces here throughout the trial. I want, some consistency with that.
Conceptually, I don't have an issue other than the computer. I'm really trying to limit in the gallery. As you can see, for example, the still photographer, there will literally be a chair on that end, like closest to Deputy Reinders, literally right behind him over the gallery, that says still photographer with credentials and an actual camera. No one else should have a camera in this courtroom. Okay, and that's to be very strategic on my part and make sure it's something that if need be, the sheriff can also enforce. I can make arrangements, Attorney Perry, if we have, the Zoom will be up because of the live stream, other than during jury selection. And if because of the staffing in your office, if you need someone remotely to be able to monitor, I can make arrangements on, they have to keep their camera off, stay muted, but they can do that and no one would be, other than me seeing who's in the Zoom, would be none the wiser. So I can make that accommodation. Otherwise, if they're on a computer, they're gonna have to be at the table behind you. Now, if there's other people from your office who would be taking notes or something, that's absolutely fine. I would just, because of the way I have this order drafted, I would need to reserve those spots somehow, probably with an X reserve for defense team, so that they're not taken by other people. Like, would 2 be sufficient?
Yeah, that'd be fine.
All right, think about it. I can always add to it. We'll put 2 reserve spots. At this point, we'll have to mark those somehow, Teresa. And then if you think there's more, otherwise, computer will have to be at the table or through remote.
Okay.
And if there is something we can do in terms of another conference room at the courthouse as well, so that that person's closer, let my staff know, and we can work with the clerk of the court's office to find you something if that would assist as well. All right, well, then I will finalize this, then there really were no changes to that, and we'll get that out so that the media can get that as well.
Your Honor, as part of that, did you want to consider my request about broadcasting victims and witnesses' faces on TV while they testify? Or would that be a separate order?
I would probably want to put something in, or at least supplement it at a later point in time. And you're solely talking about the broadcasting, right, of while a person is actually testifying.
Yes.
Anyone who's been named in the victim key.
Well,
Or-
and witnesses.
Well, what witnesses though? I mean,
Innocent witnesses that are not victims, but were present and observed.
I don't believe I have any grounds to do that unless they're named in the victim key and could address their privacy concerns that have been addressed right in Marcy's law. But
Well, there is a Supreme Court rule on point, Your Honor, 61.11, that says the judge may, for cause, prohibit a recording of a participant, and specifically talks about cases with, criminal cases with victims or police informants, other witnesses, things like that. It does give the court the discretion. It says the trial judge has broad discretion in deciding whether or not a prohibition is appropriate. For the victims, I think absolutely, Your Honor, their right to privacy, the victims that have to testify in this case, and we can identify who's a victim and who's not, that because of Marcy's law and Chapter 950, that order should be made by the court. As far as, again, citizen witnesses, we have been asked by a number of individuals for requests on their behalf for that order. They understand that there's a lot of media attention to this case, and they understand that the proceedings will be live streamed, and many of them have expressed concern about having their images, on the internet and made widely available to the public. So certainly their voices can be captured. I think even perhaps their names, they're going to have to state their name at the beginning of their testimony, but the request is that that their faces or their image should not be broadcast. So if the camera can focus on their hands or I don't know.
well, I'll
I'm not
take it
the
under
cameraman.
advisement, and here's why. I would like to know the legal authority you're relying upon. I think I owe it to the media that's reviewing this to weigh in if they so choose, right? There's a constitutional way to walking in is going to see these individuals.
Yeah.
And so I'll take it under advisement. We'll have some time before the start of testimony for me to rule on this. I certainly am interested in what the defense position is. There's a logistical issue because I am live streaming it through my platform and these 4 cameras. I am not going to be spending my time babysitting the cameras. I'm just going to be blunt. I need to focus my time and my energy on witnesses, on the evidence that's coming in, ruling on objections. And so I don't want to be tasked with that and then violate my own rules, shall we say.
Sure.
That's not to be insensitive. I understand. I think there could potentially be different categories if they are a victim. Or and a victim is a little bit broader than being in a victim key, because obviously certain victims are deceased, and under the statute and under the Constitution, if a family member needs to testify regarding that person, right, and what happened, they would be considered a victim under the statute. And so I think it would be best if you flesh out for me what exactly your request is, who these individuals are, even if you do it by category, and the legal basis for that. I'll give the defense can then see that, and I'll have to give you like a deadline for that so that they can file any response as well, and then we'll just have to decide it. I'll have to decide it before we take testimony.
Okay, thank you, I understand.
All right, thank you for your understanding. We got that. Were you able to get hold of more? Okay. All right, well, okay. So the letter did go out. You'll see what's in there. I did work pretty diligently on that to make it relevant and not change it. You'll see what's in there. There's a lot of, but at least you have that information so you know the jurors receive that. I've already talked about this. I don't have the voir dire script finalized yet, as is my standard practice. I will finalize that closer to the start of the trial and then email that to the parties. And then before going through that, you'll have an opportunity to tell me any objections or concerns that you have regarding it. I will be as thorough as I can, though. And if there are any specific follow-up type questions, even based on the questionnaires, we've already talked about that, but let me know, and I'll include that when I do that questioning. I'm going to save the motions and eliminate till the end and get through all the other issues that have been raised either in the email or by the parties here today. I think I've gotten through all of mine. Attorney Perry, I don't know how much I can give you in terms of the schedule. I think the state, given the stipulation, is going to revise its witness list, and I'll just rely on the parties to work offline to meet and confer, and maybe they'll give you a better estimation of when they start their case, how long they think it will last. I understand experts have limited schedules, but we need to avoid as best as we can any significant interruptions or delays when we're not taking testimony. So I don't need to know at this point what days your expert is not available. But I trust that he'll be available at the very close to when we need him, whenever that may be.
If I have those dates, I'm happy to share it, unless you just simply don't want to know.
I don't need to know at this point. We can touch on that when we start the trial, and as I'm sure as each day goes on, we'll get an update. I'm not going to ask you every single day, but Attorney Hopper tells me I think I can get this case on in 2 weeks, and we're at a week and a half, and I ask her, where are you at? And she goes, well, I'm going to wrap up tomorrow. I trust she'll tell us appropriately when you're getting close.
I absolutely will. I want Attorney Perry to have his experts present and available. I can tell the court, as we sit here right now, we think we can present our case in about 5 to 7 business days. So I was going to tell the court that as well for jury selection purposes. I know many potential jurors are concerned about the length of the case, especially with the stipulation we were able to reach that helps tremendously, cutting down on those foundational witnesses. So we're projecting 5 to 7 business days for the case in chief.
All right, that's helpful. I think I can answer one of your questions. I truly believe, based on the jury questionnaires, based on the script that I've utilized in past cases and what I am putting together for this case, and even with the follow-up that needs to be done, I truly believe we can have a jury the first day. And even if that means we go a little bit late that day, I'd rather go till 7, 8 o'clock at night on the first day and get a jury. That means we start a little bit later the next day to give the parties appropriate rest that they need and prepare their, or tweak, maybe finalize their opening statements. If we get done that day, we'll start the next day, even if we get done a little bit early, right? We'll either get done early, we'll come back the next day for opening statements. We get done late, we'll come back the next day for opening statements and obviously opening instructions ahead of that. So if we end up needing 2 days or 3 days, we could find ourselves in a position where it's the middle of a day and we finalize getting a jury. I think it's reasonable, either that we take a significant break at that point. If it's an early lunch, we take an early and extended lunch. I'm going to be mindful of everyone's time and energy, and the jurors who have just sat through jury selection, right, take a little bit of a break. It may be, given what the state's telling me now, I say, you know what, I'm going to give you guys the morning to prepare. We'll come in and we'll start at 1 o'clock. I'll be reasonable. I'll listen to your requests. I'll keep it moving along, but understanding there's going to be times, I think, where we need to take some breaks. Having done, presided over a number of cases, some of which have some really difficult testimony to sit through on all fronts. Sometimes we just need to take a break and come back. That's not to say we're going to do that every day, right? I mean, we have our typical breaks, our mid-morning break, our longer lunch break, our mid-afternoon break. That is what everyone should plan on doing, unless something unique happens that would require us to adjust. But we'll keep going within reason. I wish I could say something more. For example, if, we could play the what ifs all day long, but if the state gets done on a Friday morning, maybe it makes more sense to break and come back Monday fresh with a defense case, right? Things of that nature out. If we get behind in any way, then all bets are off. Then we're going to push forward. But I think from what I'm being told, the state's really been able to narrow some things down based upon the stipulations. I appreciate both sides working together, and we'll go from there best as I can.
No, that's helpful, Judge. That's the kind of thing I meant. It's like if we finish at 3 o'clock with jury selection, are you going to say, okay, openings, or are you going to say 8 a.m.?
I promise if we get done at 3 o'clock, I will tell you the next morning.
Okay.
You can hold me to that.
Okay, thank you.
All right. Any questions from the defense on any of that?
No.
Okay. I think that covers the defense issues. We just talked about scheduling. You said you'd work on the discovery issues. If there is anything that impacts this trial, please let me know sooner rather than later. I'm happy to get involved even off the record if need be. I don't know exactly what you are referring to, but I trust it's not anything that's going to hold up our trial.
I don't think it will.
Is anything you want me to know today?
I think we should first follow up with the state, and then, if necessary, we'll bring it to court's attention.
So nothing you want to bring up today? Okay, fair enough. Okay, so Attorney Opera, you referenced a couple of other issues, one of which I already took under advisement. I think I addressed the timing. I think that leaves the face mask issue that you wanted to bring up.
Yeah, there's a couple other things here on my checklist, Your Honor, but we can go to the face mask issue.
All right, go ahead.
It's appropriate. Your Honor, I have a request as to Mr. Brooks wearing a face mask at all times in the courtroom. Frankly, I'm not sure the reason behind that. I guess it really doesn't matter, other than to indicate there's certainly no court order requiring that, nor is there any requirement by the sheriff's office that he be required to wear a face mask in court. My concern is that identification of this defendant may be a significant issue in this case. The jury will be shown multiple videos and photographs of the driver of the SUV throughout the trial. They will hear testimony from eyewitnesses that we believe will identify the driver of the vehicle, but ultimately, that is a question they will have to be concerned with themselves and be convinced beyond a reasonable doubt that Mr. Brooks is the person who committed these crimes that he's accused of. And with the face mask that he's been wearing to court, I think almost every time, not every time.
Yeah, it
I
is.
think it keeps
It
that
is.
ability of the jury to reach that conclusion as to identification of the defendant. So my request is that he not wear one, but if there's some legitimate reason or medical reason or need for the mask, then at least there has to be appropriate lengthy occasions where the jury again can observe Mr. Brooks at the defense table and assist them in making that conclusion as to his identification. So, I mean, if this trial lasts 3 or 4 weeks, I don't think 5 minutes is a fair compromise there. I would be asked that he be required to be without the mask for some substantial period of time, again, so that the jurors can observe him. And many of the recordings and photographs are quick screenshots and very short in duration. So it's not as if, we have a portrait that we could say, here's the portrait of the driver and here's Mr. Brooks, and you could just have him take off his mask for 5 minutes and that would be sufficient in our opinion. So that's our request, is that he be ordered to remove the face mask for the whole trial. If the court won't go that far, then for at least sufficient amount of time for the jury to reach its own conclusions. And obviously, he'll have to do it temporarily when the witnesses are asked to identify him as well.
Look at him.
Attorney Perry, I know there's not
He's like a
written
little
motion
kid.
on this, so if you need some time to think about it, if you're prepared to address, great, I'll turn it over to you, but I
He
know I'm
can't
first hearing
even
this.
sit still.
Not a surprise, I would say. I had thought about some of the identification issues and how would we do that given the mask, but how would you like to handle that?
Well, I'm surprised at the request that he be not permitted to wear a mask at all during the course of the trial. It's one thing if it were tailored to a particular witness, their described ability to perhaps identify him.
Because
and
I
if
did
needed,
it in the wrong
for a
order,
moment,
Ken.
Take it up that way. But, I mean, surely this isn't, we aren't so far removed from.
I found
COVID that
this
it's a
one.
mystery as
This
to
is
why
a
somebody would wear
previous
a
one
mask.
that I found this morning that I
Mr. Brooks has
didn't
been
find
consistent,
yesterday.
You know,
But I
at the jail
think
report with
We're
big
gonna
masks.
skip all of these. I found several.
You know, it's not at all uncommon. I think when we walked into the
Yeah.
courthouse today, there was somebody, one of the security personnel
Oh,
wearing a
Spike,
face
what
mask.
now, baby?
That's
Blitz.
still,
I
it's
love you
less
too.
and less common, but that's still the world we find ourselves in. And for him to be taking those precautions,
Okay.
remain healthy, which frankly with decided not to have any delays,
I'm breaking my rule.
and assist with that.
I'm breaking my gavel to gavel rule because that's boring. Okay. So now we're going to watch the other pretrial hearing where he is not represented. As you guys are right, it is boring when he's not allowed to speak. Play.
Can maintain even the simplest of civility and not interrupt other individuals in a way that is disruptive and disrespectful. And I do want to initially confirm, I know I could hear him until I muted him. I can see him. Can we please get confirmation from the other courtroom that the audio and visual is working? All right, and we do have confirmation of that as well. Prior to the court ordering Mr. Brooks removed from this courtroom to the neighboring courtroom, there were 9 interruptions. So it was on the 10th that this court ordered him to be removed to appear remotely from that other courtroom. Cited repeatedly from Illinois provides this court with the authority to remove Mr. Brooks from the courtroom. Because it is a new day, I think it bears repeating much of the language that is directly on point in this decision. It is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. This is the Supreme Court stating, "We believe trial judges confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations.
We think there are at least 3 constitutionally permissible ways for a trial judge to handle an can't say that word all the time, obstreperous defendant like Mr. Brooks. In that case, they were talking about the defendant, Mr. Allen. And here are the 3 options, at least that the Supreme Court acknowledged. But I would note, as they just said in this prior quote, there are at least 3. 1, bind and gag, thereby keeping the defendant present. 2, cite the defendant for contempt. 3, take him out of the courtroom until he promises to conduct himself properly. This court has repeatedly utilized the neighboring courtroom because I believe that provides Mr. Brooks with an opportunity to meaningfully participate in these proceedings while this court maintains decorum, dignity, and respect. It is an elementary standard of proper conduct to not interrupt. Mr. Brooks repeatedly interrupts. I gave him 9 warnings before I removed him to the other courtroom.
Okay. Hang on. We gotta find this where he kept interrupting.
As the court did in Allen, this court decided that under the circumstances to remove Mr. Brooks from the courtroom and to continue the trial in his
Hang on. I gotta see where what he did. Well, dang it.
That this is the proper.
I'm sorry, y'all. I gotta see what he did. I need to see why he got banished. What was the date on that?
Response to his conduct. As
Is there a date?
The court stated we find nothing unconstitutional.
No, it just says streamed 3 years ago. That doesn't help me any.
This is now the 3rd day of the trial.
All right, Jennifer. Shush.
We struggled at times to.
I love you, but shush. This might be it. Does he have his orange like scrubs on and a mask? Well, that really narrows it down, Debbie. No, this is a different courtroom, isn't it? Is this it, Judy? This says pretrial hearing, and the one I just did said pretrial hearing. Good Lord, Darrell, were you thirsty?
I'll get to that momentarily. The record will reflect that the individual known to this court to be Darrell Brooks is appearing in person in custody We are, of course, outside the presence of the jury today. Since they are not here, we are dealing with some housekeeping type of issues and other legal matters. So he is appearing today in jail attire. He is in custody. And it's my understanding, Mr. Brooks, that you were offered to appear in the suit, but chose to come to court in jail attire, which is fine. We're not in the presence of the jury. I just wanted to make a record of that.
Seen or identified by the name that you stated earlier. I want the record to reflect that, if I may.
The record will reflect. Thank you. All right, I know there was some filings, and I want to make sure the parties have copies of everything. Mr. Brooks, I know there was an inmate communication form filed, I believe earlier this morning, requesting 6 subpoenas as soon as possible. I instructed my staff to make sure ample copies of the subpoena forms were provided to you. I did receive verification that those were hand delivered. Did you receive those, sir? We'll provide additional copies. Again, it's my understanding those were hand delivered to the jail, and that the jail took care of that in the event that that latter part did not take place. Mr. Brooks, I believe you were requesting 6 subpoena forms. I'm going to have my clerk print out 10 so that you have ample copies, and when that is done and those are handed to you, I'll make a record of that.
Will we address the inmate communication form I sent about
I have a number of issues I need to address, so yes, we'll get to that.
you don't believe that that's an important issue that should be taken up before we continue any further in the proceedings?
I just want to make sure the state has a copy of what was forwarded first before we take that up.
Will they?
I'm not seeing it in the record yet, so I did a F5, so it'll refresh.
So the prosecution will receive a copy?
I believe one was printed now for them. It is in the record. And then I'm going to print off something as well. I don't know if it was already.
Respectfully, would like to state for the record and would like the record to reflect that I believe that this is an issue that should be addressed at this point before we go
Sir,
any
I'm
further.
preparing to do that. I didn't say I wouldn't do that, so give me a minute. I have some documentation that I'd like to provide to the parties as well. I want to confirm with Attorney Opper that you have now received a copy of that inmate communication form.
Yes, I have one in front of me, Judge. It's dated today's date, October 5, 2022.
Yeah, it's dated today because I just learned of the protocol that I would be on as of today.
Can you print or make 2 copies, one for each party? All right, I'm going to provide a document to the parties. It's a 5-page document. It is a document that was forwarded to me at my request by Monica Paz, our clerk of court, after receiving the inmate communication form from Mr. Brooks requesting an adjournment. For the reasons stated in that document, I thought it important that we all have before us the current county protocol related to COVID-19. This will be provided to the parties.
I decline to accept that if I don't
Sir,
believe that
it will be placed on your table, but I will be referring to that today, so
Is
it's
it
been
law?
given to you.
Is it verified law, Your Honor?
Attorney Opper, do acknowledge that the COVID-19 illness reporting protocol was provided.
I respectfully object.
Yes, Judge.
Your Honor, I would like an answer to that question if I may. Because I have not consented to or agreed to accept any paperwork that.
Sir, it's been
It's not-
provided to you. It's
So are you
something I'm going to
making-
consider. You don't want
Are
to
you
read it.
making-
You
are
want
you
to
making a
disregard it. That's
judicial-
your choice.
Are you making the judicial determination that you don't have to answer?
Call's been placed in front of you. It is your choice whether you want to review it or not. So my understanding, just from the information Mr. Brooks has provided, which is part of the public record, is he is requesting an adjournment of all proceedings due to learning that he's on a COVID-19 protocol. I don't have any other information than that, sir, but based upon, and again, I did I was provided with the COVID-19 illness reporting protocol. I wanted to make sure that I had the most recent information that at least the county of Waukesha is operating under. I also verified with court staff that the location at which you are seated is not within 6 feet of any other individual in this courtroom. Is there any other information you think I should know as I consider your request for an adjournment today?
Yes, I find it hard to believe that you couldn't consult with jail staff to verify the protocol, to verify that I was seen by nurses that
I don't have that
specifically.
information, sir, and let me be clear, cannot be provided to me under HIPAA. The only information I have is what you put in the inmate communication form.
It could be verified because I was told when I was brought down here that everybody knew that I was on COVID protocol. That's why everybody
Because you advised us.
That's why, no, because the jail advised them. That's why they had to wear masks to bring me down. That's why I'm essentially on a protocol that doesn't allow me out of my cell until my results come back. So I'm not allowed out of my cell at the moment because of the protocol that the nurse himself placed me on, that the
But
jail
you're out of
confirmed.
your cell.
That is very easy information to obtain.
I don't think you're
So
right
I
about
have
that,
the,
Darrell.
an attorney for the
Excuse me,
county
Your Honor.
here
I
who will
don't wanna-
verify
I
that
don't
none
want
of
you to
that
think I'm trying to
information
argue
has
with
been
you, Your Honor.
provided to me due to
I don't
HIPAA
want you to think I'm
requirements.
arguing.
So I'm not
But I-
arguing it with you,
I
sir,
know, I
one
just
bit.
want you to know that I'm not arguing with you either, but I was right in the middle of finishing what I was saying.
So I need to stop you for a minute, Mr. Brooks,
I don't
because
consent to that, Your Honor, because
you don't have to consent,
I
but here we
don't
go. Let
consent or
me,
agree to being cut off right when I'm trying
all right,
to
I'm just
provide
gonna
the
talk
court with
over him for a
information.
minute. I do not have any other information regarding, the COVID-19 protocol, meaning anything specific about you, Mr. Brooks, other than what was put in the inmate communication, which reads, due to just learning I'm on COVID-19 protocol, I respectfully ask for all proceedings to be adjourned at this time, which is why I asked you if there was any other information you wanted to provide me as I consider your request, because the jail has not provided me with any specific information regarding the reason you were placed on protocol, whether you were exposed, whether you are showing symptoms. They cannot provide me with that information absent you giving them permission by signing an applicable authorization to do that. Without that, I have to rely upon you to provide that information to me if you so choose.
That is incorrect, because just yesterday, you were trying to obtain the witness list that was in my cell. You had no problem whatsoever having the JA come down here
That
to
has
have
nothing
me
to
verify
do
that
with
they
your
can go in my
health,
cell and search for
stupid.
that. So I find
That
it very hard to
HIPAA does
believe
not
that you can't
apply.
consult with jail staff for them to tell you what is going on in my situation, where they know that I've just been seen by a nurse that placed me on this protocol for having a loss of taste, fatigue, and I have to wait for the results of my test. And until then, I am on a protocol which restricts me to my cell. That is very easy information to obtain. And I find it very hard that Your Honor cannot obtain that information, but can obtain a way to communicate with jail
It's
staff
called
when there's a
HIPAA.
witness list involved. We're talking about someone's health that can affect not just you, but anybody else, not just officers, but also inmates. We're talking about health and we're talking about safety. That has a lot of merit. And frankly, Your Honor, I'm afraid. I'm fully vaccinated and I've never had COVID. I don't know what I'm looking at here. That was the last thing I was hoping I would be told today, Your Honor. So I'm afraid right now.
Oh, good gravy.
I'm not
Marie.
feeling well. I don't know what's going on with myself. That's the reason why I put in the sick call slip initially. I had been telling officers for days that I hadn't been feeling well, but I didn't know what it was. But I
It's
felt that I
just
had to
the
put in the
flu.
sick call slip because I was not able to taste anything. That is the reason why I was seen by nurses. That is
It's
the reason
just
why the COVID
flu.
test was administered, and that's why I'm on the protocol as we speak.
Are you willing to discuss with me what tests were done?
I
Again,
don't-
I cannot obtain that
I don't.
information on my own.
I'm not a nurse, Your Honor. I don't know the name of the test. I don't. Like I said, I've never
Did they
had
stick
this
a
happen.
Q-tip
That was
up your
that was a
nose? That's the
Pretty ambiguous
test.
question. So You reported symptoms as that's what you're telling me, right?
Correct.
And you're saying some tests were done?
I mean, that it's obvious. I mean, why can't it be verified with the nurse?
I have to verify it with you. The nurse will not provide me
It's
with this
called
information.
HIPAA.
But the jail can because they control the movement.
No.
They control all inmate movement. I can't just go from my cell to a HSU.
Inmate movement is not the issue at the
It's
moment.
not, but I'm saying, how can I tell you, how can I answer what you're asking me? It doesn't make sense. We all understand that the jail itself
Yes, it
controls the
does.
movement of the inmates. That's common sense, Your Honor.
I'm not here to talk
I
about
can't-
inmate
I can't
movement
just-
at the
I can't
moment.
just
What I'm
walk to
asking
the
you is,
HSU.
do you believe you were tested for COVID?
I obviously was tested for COVID. I would not be on the protocol if I was not.
Do you know
The
what
nurses-
type of test? Was it an oral swab, a nasal swab?
It was a nasal swab.
All right. Do you know when the results of that test will be back?
From my understanding, Friday. That's what I was told by the doctors. I would have to be at least on this protocol until the results come back,
Were
which
you-
he said the earliest would be Friday.
Were you offered a rapid test?
They said they do not do the rapid test.
So you weren't offered a rapid test?
They said they don't do them.
If one can be obtained, are you willing to submit to a rapid test?
I'm not willing to submit to anything right now until we take care of the issues that's at hand. I mean, I've already been placed on the protocol. Frankly, I'm very afraid right now because I don't know what's going on. This is new to me. Like I said, I'm fully vaccinated, Your Honor. I've been fully vaccinated since 2021. And so for this to just be sprung on me now to say this could possibly be a COVID thing, I've had people close to me that have passed away from COVID. I'm afraid as hell, Your Honor. That's the reason why I submitted the ICF for the adjournment. I was thinking at least until I can get the results at bare minimum. I don't think I'm asking something that's
Sir,
impossible for
if
Your
I
Honor,
can
right?
make arrangements to have a rapid test brought to you and administered, are you willing to submit to that test?
Not at this time.
Why not?
Not at this time.
Why not?
Why can't I get the results of the test I already took?
But you're telling me you're scared? You're
Yes,
fearful?
I am. I
But you
am
don't
very-
want to take a test that might
I
tell
took,
you today?
I took the test that he gave me.
And
if
you're
he
telling me
felt-
that test result won't be available to you until at least Friday?
At least Friday, that's what I was told. The results came back. The earliest that the results will be back would be Friday.
So that sounds like, to me, I think that's what they call a PCR test.
I have no idea, Your Honor. I
Okay.
have no idea what it's called. Like
Let
I
me
said,
ask
I've
you-
never had COVID. I don't know the test names. I don't know what they call them.
I'm generally familiar with some of the testing for COVID. There are tests that can be what we call rapid tests or what are called rapid tests that are available. And then there's these other tests which take a few days. Again, I'm not a scientist, but I think the
Rapid is
general
more
belief would be sometimes the
expensive.
rapid tests are accurate, sometimes
The
they're
jail's
not.
not gonna have the
Sometimes
rapid
people test
ones.
negative
They're too
when they're really
expensive.
positive. It just kind of depends on the circumstances. But it's my understanding a positive test would be pretty accurate. And then there's other tests that take a few days for the results to come back. It really depends on the lab that's being utilized, et cetera. I'm asking you once again, if a rapid test can be obtained, are you willing to take a rapid test?
How would that be obtained? How would it be obtained?
I would
was
work
told,
with-
I can only go by what was told to me because when I was brought in there and they told me that they had to test me for COVID, I was immediately like, what do you mean you have to even test me for this? What is this about?
Well,
I
did
had
you
a
report
lieutenant.
symptoms to them?
Excuse me, Your Honor. I had a lieutenant and 2 officers present when I was asking all these questions. Why do I need? What's going on with this? Why is this? Why is this? Why is that? Because I didn't understand. Immediately in my head, I started to get afraid when they said they had to even test for COVID.
Well, were you reporting being sick and symptoms prior to them asking you to test?
Yes, I've told multiple officers. I didn't know what it was at first because it started with fatigue, with me feeling very fatigued. And I said, man, I don't know if it's just me being tired or that's what I initially thought it was. Maybe I'm just a little exhausted. But I said, no, anybody knows their body. I said, this got to be something more because I'm really, I don't even have an appetite. Then when I'm trying to eat, I can't taste anything. That's what said, okay, now I need to put the medical sick
When did you
call
report these symptoms to the medical people or to even just a correctional officer?
a few days ago. Over the weekend is when I started to notice the fatigue. So I was telling officers, man, I don't feel good. I don't know if it's just I'm tired. Usually I don't just jump the gun and say something's wrong because it could be anything. So
When did you report the loss of taste?
I reported the loss of taste last night.
And was it after that that they told you they wanted to test you?
No, they didn't tell me till this morning that they wanted to test me.
What other symptoms are you reporting at this time?
That was it so far, just the fatigue
Hey, Terry.
and the loss of taste. Which is the reason why I was told that I had to take the test. Which I was told at that time also that the earliest my results would be back would be Friday.
And you said at this point you're not willing to take a rapid test.
Well, they said this is the test that they do. The nurse was very clear in what he was telling me when he told me how to test, because like I said, there was a lieutenant and 2 officers right there while the whole thing was going on.
I understand all of that. I have a very specific question to
I
you,
was
sir,
asking
though.
them questions, and he specifically told me that this jail, this is the test that this
They
was
have to
told.
rub it, it's too
And
expensive.
after he told me that, I said, okay, fine, just do the test, and I'll just sit on the protocol, because at first when he told me, you're gonna have to be on a protocol
That's
where you're
tax-
isolated.
Taxpayer money.
I said, okay, fine, just do the test. I'd rather you do the test and make sure that I'm healthy than to just refuse the test and just say, I'll just wait for it to see if I get better or something like that. So I said, yeah, just go ahead. And that's what I was informed. Friday would be the earliest that I would get the results back, and I would be placed on a protocol which is called isolation, where I'm not allowed out of my cell.
Except to go to court. Stupid.
Anything else, sir, you think I need to know about this issue as I consider your request?
Now, at this time, I'm just telling you what I know. Multiple officers were there. They can tell you the same thing that I'm telling you now. Like I said, a Lieutenant Chamberlain was there. 2 officers were there.
They
Any
can't.
objection if I talk to any of them to confirm what you're saying?
Absolutely not.
Any objection if I need to ask the jail administrator about, or anyone else at the jail about the protocols and what's available for testing?
Absolutely not.
Given any information about whether anyone else in the facility is experiencing COVID right now?
I wouldn't know that. I wouldn't know who. I'm in the mental health medical pod as it is. I'm
So no information's been provided to you that there's like either a lockdown or some type of a restriction due to any like concern over COVID at this time?
I would never have that information, because like I said, I'm limited in the pod that I'm in. I have no interaction with any other inmates, and my interaction with staff is pretty limited.
All right, thank you. I appreciate that additional information. I know, sir, what I've provided to you is generally the, for employees, I fully recognize that the jail may have different protocols just because of it being in a correctional facility, and inmates are, of course, or can be very close to one another. And so I don't want to presume that this is exactly what they follow. And so I'd like for them to tell me what their protocols are as I consider this request. At the moment, I told you this earlier, you're not within 6 feet of anyone else in this courtroom. And I believe that provides ample protection for the other people in this courtroom as I consider this request. You've provided information to the court. You've been able to tell me the symptoms that you are reporting, your understanding of the protocols, and despite you reporting fatigue, I don't know if you're standing or sitting on the chair. I can't quite tell. It appears like you're standing, but maybe leaning over the table. Oh, knee on the chair. Okay, but you've been able to very clearly, coherently make your position known to the court at this time, and I appreciate that. Let me ask Attorney Opper if there's anything you would want to provide or state at this time regarding this request.
Yes, Your Honor, a couple of things. Number one, we believe this is nothing more than a further delay tactic by Mr. Brooks. I can advise the court, as an officer of the court and as an offer of proof, that he has.
How could that even?
Attorney Opper interrupt you when you were talking?
Well, I respectfully object to
You
that.
can object, your objection's noted, but you need to let her state what she needs to state. I will give you an opportunity to respond. I'd encourage you to use
that is
paper and a
ridiculous, Your
pen
Honor.
to write down. That's the rules of decorum in the courtroom, sir. We generally avoid interrupting one another so that, number one, the record can be clear, and perhaps most importantly, because that is a sign that we all understand that this is a place of dignity. It is a place of respect. It demonstrates that, frankly, a willingness on the participants to conduct themselves appropriately. It avoids creating disorder or disruption. So I will give you an opportunity to respond, but you need to give Attorney Opper an opportunity without interruption. Go ahead, Attorney Opper.
Thank you, Your Honor. Your Honor, again, we believe this is a delay tactic in line with the defendant's behavior since about the August 25th or 26th motion hearing. I can advise the court, as an officer of the court, that Mr. Brooks has been saying for the last several weeks in his recorded jail calls to his mother and others that he's going to get this trial delayed or adjourned or pushed back. This behavior, again, on the 11th hour is 100% consistent with that. I believe that if the court wanted more information from the jail administrator, she is present and could provide that information. I believe Mr. Brooks has waived any HIPAA privacy rights he may have in that regard and indicated that to the court. And also, I believe she would be able to provide information if the court ordered her to do so. I believe that even if he is on COVID protocol, it will have zero impact on his ability to prepare for this case. As we've learned already, and I'm prepared to make a further record, he has all of his discovery materials within the confines of his jail cell. He has a tablet made available to him in the confines of his own jail cell, and he has the ability to use a conference room in his pod. I don't believe the COVID protocol would interfere with his ability to access that conference room whatsoever. But again, I could verify that with the jail administrator if the court thinks that's an appropriate fact. The fact that he claims to have started reporting symptoms as far back as the weekend, we're probably right up against the 5 days right now. If he started this on Saturday, which I don't believe there's any record of, we're at 5 days right now. And certainly the court's offer to...
I never once said...
I never said... An opportunity momentarily.
No,
You
I
need to stay
respectfully
quiet.
object to that because that has no merit.
Mr. Brooks,
I-
it's not
she
your
said-
time
no,
to speak.
No, I respectfully object. I never reported saying what day. I never said a day. And if she's saying she has jail phone calls, well, why aren't they present? Why can't they be verified by sworn affidavit and brought into this court to be shown that this is a delay tactic, as you say it is? How come it can't be shown by sworn affidavit? Can you provide proof of that?
All right, Mr. Brooks, I've given you a little bit of
Just
leeway
like you're
because we
saying
are outside the
that I've
presence
waived
of the
something,
jury.
I haven't given consent to waive anything. I've simply told the judge that I had no issue with her verifying with the jail that this protocol is in effect and that I was in effect that I was in
waives
effect
your HIPAA
tested
rights,
for
stupid.
COVID-19. How could that be a delay tactic? If that was a delay tactic, why would I even need to be tested and placed on the protocol? Why does everybody have to have on masks to bring me down here?
That's a delay tactic because you don't want to start the trial.
Okay,
'cause
Mr.
you're-
Brooks,
there no-
I've
is there
given,
no verification?
Mr. Brooks, I'm going to warn you now that you have interrupted a couple of times. You interrupted
I have to
Attorney
be able-
Opper
I have to be
twice.
able to speak up,
You're
Your
now
Honor.
interrupting me yet again. We all were polite and had
No,
you
dumbass.
provide
That was not
information.
polite, that was
Your
abuse.
time to
That's
speak.
the
That was
third
abuse.
interruption of this court.
That was abuse by the prosecution. That was abuse.
Mr. Brooks, let me finish.
You're in abuse.
Now he's
not
outright
sit here-
refusing to listen.
I would
He's
not sit
outright
here.
talking over me
I didn't
at the
refuse
moment.
anything. I didn't refuse
Mr.
anything.
Brooks, we are at
I'm
the
not- I'm
point
not gonna-
yet
I'm not
again
gonna- I'm not
where
gonna
I
sit-
will put you in the other courtroom because
And
you
I
are
don't
not
consent. I don't
able.
consent to being removed. I have not waived the right to be present, and I don't agree with that.
Yeah, you have.
Mr. Brooks,
Does it?
Could
Does
you
the
I
please
have
record
shut
reflect-
up?
does
cited
it-
you on multiple occasions, and it's, should be in front of you,
No,
and
I
if
don't.
not,
I don't acknowledge that. I haven't agreed
you
to
have
it,
been
and I
advised
haven't
on
given
multiple
consent to it.
occasions that you need to abide by the standards of courtesy and decorum for the courts of Wisconsin. Because you are a litigant, you're both a named defendant, you are now acting as your own attorney by
I'm not a named
representing
defendant. I
yourself,
don't recognize the name
that all of the
the
rules
state
of courtesy and
put on
decorum
their
apply to
complaint. I don't
you.
recognize that name, Your Honor. That is not
Supreme
who I
Court
am.
Rule 62.02 details many of the requirements for courtesy and decorum. I've referenced a couple of them on multiple occasions, including that sub 1, sub F of 62.02, that proper conduct and attire is expected within the courthouse, and where possible, individuals, including yourself, right, are to refrain from creating disorder and disruption. Sub H, you're supposed to conduct yourself in a manner which demonstrates sensitivity to the necessity of preserving decorum and integrity of the judicial process. You have been advised multiple times, sir, of the expectation that this court has that you conduct yourself in a civil manner. You've been advised multiple times that this court will not tolerate disruptions, interruptions, that when you do that, you run the risk of forfeiting your right to be present in the courtroom. As you know, I have available the courtroom next door that's connected to the holding area. It is connected by audio and visual means. It provides you an opportunity to meaningfully participate by also giving the court the opportunity to control the decorum, to control the disruptive behavior, because primarily your disruptive behavior is repeated interruptions of this court, talking over this court, now talking over the prosecutor. I appreciate that you have not interrupted me for quite some time. So at this point, though, I need to warn you that further interruptions may very well result in you being removed to the other courtroom where you would participate by audiovisual means. At this time, I would like to hear from the court administrator, especially as it relates to the protocol. Did I say the court administrator?
That's all right.
That's okay. Okay, we're in court, and I would like to hear from the jail administrator. Thank you very much. And just to get some general information, and perhaps even some specific information regarding the what Mr. Brooks has provided, since he indicated I could verify all of this information with either the lieutenant or others who were present. So I believe we have Angela Wallenhaupt here, if she would come up to the witness stand.
Your Honor, if I don't want to mix issues, but the inmate communication form from September 28th also still needs to be addressed by the court, and I think the jail administrator may have some information relevant to that issue as well.
All right, thank you. I have a list of a bunch of things I want to go over, and I'm going to.
So, Your Honor, just so I'm clear, are we addressing the issue at hand now?
We are.
Or are we addressing something from September?
Well, I will get to the September inmate communication form at some point during this hearing, but right now I'm addressing the most recent inmate communication is dated October 5, and that addresses your request for an adjournment. So I'll have you sworn in. I'll just do it. Raise your right hand. Do you solemnly swear that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Would you please state your first and last names for the record?
Angela Wallenhaupt,
Would you spell your last name?
Wollenhaupt.
Thank you. If you could please advise us on the record again of your job title and responsibilities.
I'm the jail administrator for the Waukesha County Sheriff's Department. I am head of the division in charge of all staff and inmate issues.
Could you provide information to the court on the general COVID protocol within the jail?
Judge, I would prefer to not speak to the operational considerations with that. I can speak to the fact that there are different protocols that are put on people for different medical or management reasons, which may have modifications to them. I can speak to the protocol Mr. Brooks has placed on, that it won't affect the area he is living in, nor access to areas that are not other inmate occupied.
That seems fair. I don't want to certainly put all of your operations on display. That's not necessary. But if you could speak to the specifics as it relates to Mr. Brooks's current situation.
So he would remain in his current cell housing location. He would have access to a conference room if he needed it, access to a telephone. And we would be able to, it's a safety security measure for him as well as our staff. And we can safely produce him for court.
When I hear the phrase being on a protocol, that to me could have more than one reason. Someone could have been exposed, someone could have tested, or someone could have reported symptoms that required testing. Would I be mistaken in any of those beliefs?
You are correct, Judge.
Would there be any other reasons for someone to be placed on a protocol, a COVID-19 protocol within the Waukesha County Jail?
No.
And would you tell me which one of those three options has prompted the COVID protocol for Mr. Brooks?
Judge, I have not reviewed his medical record prior to arriving here.
All right, fair enough. Do you have an understanding of what that is?
Yes,
Based
however,
on information provided to you?
yes, however, he has not signed a release allowing me to speak to the court. So if you are ordering me to speak to the court, I can speak to what my understanding is.
Mr. Brooks, I took your statements earlier that you would not object to me asking jail staff about the current situation to verify the information you provided. Is that still correct?
I said that I wouldn't have any issue with pertaining to myself. I don't know. I'm not speaking about anybody else in the jail. I'm not speaking about everybody's situation is different.
Right, and I'm specifically referring to your situation.
Well, the question was asked in, how does it pertain to me? It was pertaining to me, all the questions, which it came up when I said that there was a lieutenant and there were officers present when I took this test from the nurse.
Right, I'd like to verify the information that you're providing to me regarding what was reported by you, what tests or tests were administered, and why you're on the protocol with the jail administrator. First of all, do you understand what I want to ask
The
her
jail
about?
administrator isn't good
Did you
enough.
hear what I said just now?
I do not understand.
But did you hear what I said?
Frankly, Your Honor, I think she would probably be the wrong person to be asking because she wasn't present.
You must understand then what I'm saying if you think she's not the person who would provide that
No, I don't
information.
understand.
So,
I didn't consent to understanding or agreeing to that. No, I do not understand.
all right. I took his statements earlier. I realize you don't have a written waiver as to be a verbal waiver of any privacy rights under HIPAA, and I'm directing you to answer the question.
Okay. It was brought to my attention shortly before the lunch hour that he had made statements that prompted the medical department to follow up. As I said before, I have not reviewed the medical record. It is my understanding he was administered a test. He was also offered another test, to which he refused.
Do you have any information regarding whether this other test would have been a rapid test?
I believe it to be.
Do you have those tests
Oh.
available in the facility to offer to an individual?
I have one available right now.
Oh. I was wrong.
Question, Your Honor,
Of me or of the witness?
of jail administration.
Go ahead, you can ask the question.
Ms. Wallenhoff, if there were different types of tests available, why wasn't I administered the correct test when I first was tested? Why would essentially I would be asked to take a test, take that test, then turn around again and be told to take a whole nother test? In my mind, that's almost like some type of ploy or something, some type of scheme. Why?
Sir, what's the question?
I asked the question, why would I not
That's
be given the
because
correct
you're
test
suspicious by
from the get-go
nature
instead of having to take two tests?
or
If I've already
distrustful.
taken one test,
You have to give her an opportunity to answer, and you
I've
gotta
already-
ask one question at a time.
I just asked the question.
Can she answer it then? Do you want her to answer it?
Yeah, shut up so she can
I
answer
presume you
it.
do since you asked the question, so you need to stop talking so that she can answer it, okay?
Limit your abuse, Your Honor.
I'm sorry?
I don't appreciate being talked to that way, Your Honor.
Your objection is noted. Go ahead and answer.
Judge, I would prefer not to answer that question. He states the wrong test. I don't know what he's speaking of. I have not reviewed the medical record with what test was administered, so I would prefer not to answer that question.
All right, fair enough.
I did not say the wrong test. I said two tests. If it was, why would I need to take two tests for the same symptom?
I object to relevance and beyond the scope of this witness's knowledge, and it also assumes a fact not in evidence.
All right, so I'll sustain the objection. I'll give both parties an opportunity to ask questions of this witness since it's Mr. Brooks's request. I know do you have any other questions for Jail Administrator Wallenhopt on this issue at this time?
I don't think I was clear, or I didn't have clarity on the answer to that question. Essentially, what I'm asking is, why would I need to take two tests for the same thing? There should, if I'm taking a COVID test, why would I need to take another one?
Lack of foundation and beyond the scope of this witness's knowledge, Your Honor.
Doesn't know.
The objection is sustained. I'll direct the witness. She does not need to answer that question. Next question, if you have one, please.
I still don't have clarity on that, Your Honor. I'm baffled.
Do you have another question? A different question?
Would it be any way to verify why I would need to take two tests for the same symptoms?
I'm not sure I understand the question, sir. I think
I'm referring to The nurse who administered the test.
The nurse isn't here, though. This is Jail Administrator Wallenhoff.
And that's why it's hard for me to wrap my head around why Mrs. Wallenhoff would be called to testify when she was not present. I think the wrong person is testifying.
Do you have any other
Because
questions
the
for
reason
her?
why I
I
say
understand
that-
what you're saying. Do you have any other questions for her, though?
Are you sure you're wrapping your head around what I'm saying, Your Honor?
Do you have any other questions for this witness?
To your knowledge, you just said that you have a rapid test available right now. When did that become available? Because I was told otherwise.
I know there is a rapid test available right now. As I stated before, it is my understanding that you were offered a rapid test and you refused.
So why was I not offered a rapid test from the get-go?
Objection, relevance.
If she knows, she may answer.
I do not know the answer to that. I have not reviewed the medical record, jail contracts with a medical provider.
Thank you. Next question, if you have one.
So there are more than one type of COVID test administered by this jail.
Again, the jail contracts, Judge, I prefer not to answer that. The jail contracts with a medical provider. I do not direct testing for medical conditions. That would be our medical contract.
I believe the record's clear that a rapid test was offered. It was declined by Mr. Brooks. The record's also clear that
I
he did
object to that,
submit.
Your Honor.
He did submit to a test, but this witness is not able to answer whether that was a rapid or not, given her role in the Waukesha County Jail as the administrator and not in charge of medical. I will find she does not need to answer that question because it's outside her scope. And to further answer it might be speculative. So, do you have another question?
So would it be fair to say, you just said it would be speculative, so would it be fair to say that it'd be speculative that the second test would be a rapid test?
I will make a determination on your motion after all of the evidence is received.
Is that an
I
answer,
can't
Your Honor?
answer.
We just said it would be speculative.
You were looking at me when you said that,
Well,
so are you, and I'm not gonna answer that question. I'm not a witness in this.
The
I
reason
make
why
the
I was-
determination
reason why I was
ultimately.
looking at Your Honor is because
What?
Do you have another question
I'm
for
still trying
Jail
to figure out
Administrator
how-
Wallenhoff?
I thought testimony was supposed to be the prosecution and the defense's time to
Sir,
ask
do you
questions.
have another question? Otherwise, I'm gonna ask the state if they have any more for this witness.
I asked the question, would it be fair to say that it's speculative about what the second test actually was?
Mr. Brooks, I don't understand your question.
What isn't to understand about it? If you were offered a test,
Objection, relevance.
it's a question.
Hold on.
I'm
You're
getting
asking a
I'm going somewhere.
I'll let you get the question out,
Not
but I would
when
just
you
note you're
use
asking
them
her a hypothetical
incorrectly.
that, given her role, she might not be
It's
qualified.
very logical. If you were offered a test and you took it, why would you need to essentially take another test that could have been done right from the beginning? If there would be any issues, if there would be
All right, Mr. Brooks, it's not relevant what she would do. So that's essentially an argumentative
Okay, so
question,
why-
and
so
it's
why would I
not
do it?
relevant. So
Why would
sit
I do it
down. You're done asking questions because you've
so
now
is that a
asked.
judicial determination?
I haven't made a judicial determination yet.
You're
Go ahead,
practicing
Attorney
law from the
Opper.
bench by being able to ask
Mr.
certain questions
Brooks,
of yourself.
Mr. Brooks, okay, here's your warning. I'm giving Attorney Opper an opportunity
So
to
you're
ask this
practicing law from
witness
the bench.
questions, and if you interrupt her, you will be removed to the next courtroom.
I don't consent to being removed to the next courtroom. I don't consent to even being at these proceedings if I'm not able to put on a proper defense, which is my constitutional right to be able to do so. I haven't agreed to any contracts. I haven't consented to any contracts, and I have
Your
not
objection
consented-
is noted. Attorney Opper, go ahead.
I have not consented
Thank you.
to.
Ms.
let this
Wallenhoff.
properly be.
Although Mr. Brooks is under a COVID protocol, is he still allowed to review his discovery materials in his jail cell?
Yes.
Jay, for relative-
To your knowledge, are those materials,
The objection is overruled.
I'm sorry. To your knowledge, if you know, are his discovery materials currently in his jail cell?
Yes, ma'am, to the best of my knowledge.
Okay.
I object
Is
to
he
that.
still
I object to
able-
that, Your Honor. I'm not allowed to
Her
keep.
answer stands. There's no question to which to
I
object.
object to that. There is.
You can't testify at the moment. If you want to provide further information after she is done testifying, I will give you that opportunity.
Will she-
Your
will she be
objection
able to-
is
Will she
overruled.
be able to stay right there so I can ask the question?
It's not your time yet. You have to wait. So this is the final warning, okay? I've given you a lot of leeway today.
You have not, Your Honor, you haven't, no.
I
you
am
haven't.
turning to Attorney Opper. It is her opportunity,
Because
her turn.
Just because you don't get what you want, that
To ask
doesn't mean
this
she
witness
didn't
a
give you
question.
leeway.
And it is my right to be able to object, just like she objected
And-
when I was asking
Right,
questions.
and when the court rules on an objection, usually the party who objects stays silent. I rule on the objection.
100%.
The parties
Ken.
don't debate the ruling. It's noted for appeal, and then we move on.
And I would like to put you on notice that I will be appealing that judicial decision that you are making.
Next question, Attorney Opper.
The judicial determination.
Ms.
that you
Molenhop,
are making.
while on COVID protocol, does Mr. Brooks have access to the tablets in his jail cell?
Yes, ma'am.
And that tablet has legal materials available for him to access if he so chooses, is that correct?
Yes, ma'am.
And while he is on COVID protocol, does he have access to the conference room, which also contains a computer with further legal materials?
Yes, ma'am.
And nothing about the protocol would restrict his access to any of those materials, is that correct?
Correct, ma'am.
And you've
I object to
indicated
that. I
previously.
object to that respectfully, Your Honor.
So, an objection goes to whether, there's lots of rules of evidence that apply, but if you're objecting to her answer, that's a different thing. You can argue the meaning of that language. Okay,
not
the
the
objection,
answer.
but then you have to say objection before she answers. You
She
objected
didn't
after
answer,
she
she didn't
answered.
answer the last
The
question.
objection is noted, it's overruled, her answer may stand. Next question.
Ms. Wolenhop, you're aware that there has been digital discovery made available to Mr. Brooks for him to view in the Waukesha County Jail,
I
correct?
respectfully object to that.
Overruled, she may answer.
Correct. He would view that digital discovery on the computer in the conference room in his pod,
I
correct?
respectfully object to that.
Overruled, you may answer.
Correct, ma'am.
And
So you're gonna
the
overrule
protocol-
everything, Your Honor?
All right, Mr. Brooks, you have got to stop. It's fine if you object. I will rule on it as I deem appropriate under the rules of evidence, which, by the way, I provided a copy for you. See that big book over there?
No, I don't
It has
see
the criminal statutes.
don't see it.
It has the traffic code. It
I
has the
don't
rules
see
of evidence. Well, it's on your table. It's behind the microphone, and it's there. I've provided it to you as a courtesy so that you have that available
You did not
to
provide
you.
anything to me.
Right, I'm
Something
directing the
that-
bailiffs to
something
remove
that
him
they
to the
have-
other courtroom.
something
I've
that-
provided ample opportunity for
I've
Mr.
never
Brooks to
taken
abide by the
anything-
simple
I've
rules
never
of
taken
decorum
anything,
and
Your Honor.
civility.
Your Honor, I don't
He is-
consent or agree to what you are doing.
Your
I
lack
don't
of
give
consent is noted for the
I
record.
don't give consent to an estoppel. I don't give
I'll make a
consent.
more full record when we
I
are
don't give
open
consent
again to
an
the public.
estoppel. I don't give consent to be removed.
Madam
being
Reporter, the
able
record
to
should
exercise
reflect,
my
the court is
constitutional
stepping
right.
off the bench. You may step off.
I
if you
move,
want.
I move for a motion to dismiss. You still haven't even ruled on the claim. There's no one that even has a claim against me here.
Oh. Okay, wasn't that fun? Okay, this should be. Now I know why it says pre-trial hearing part 2. The other playlist didn't have part 1. And we just watched. Okay, so we just watched part 1. Now, part 2 starts with him in the other courtroom. Really? Ken, I hadn't thought about that. Do you think he would have been more respectful if it had been men? Because he went off on Zach that one time, remember? When Zach pointed out that
All right, before we continue, the record to reflect that, and at the moment, Mr. Brooks is
If he had had a male judge, you don't think he would have acted out as much? Because he went off on Zach. Remember when Zach said that he was a sex offender because Erica was a minor and he was an adult when they first got together? No, maybe not. Yeah, he was, you'll hear it in the trial. He was with Erica for a long time, but it was on again, off again, because he was such a creep. He beat the crap out of her. He has kids. How many different baby mamas, though? I don't think Erica was the only mom. Yeah. Zach restrained himself. He did a really good job restraining himself because he was pissed.
muted, so I can appropriately make my record here today. I will promise to unmute him when we continue with the hearing after I make my record regarding the removal, assuming he can maintain even the simplest of civility and not interrupt other individuals in a way that is disruptive and disrespectful. And I do want to initially confirm, I know I could hear him until I muted him. I can see him. Can we please get confirmation from the other courtroom that the audio and visual is working? All right, and we do have confirmation of that as well. Prior to the court ordering Mr. Brooks removed from this courtroom to the neighboring courtroom, there were 9 interruptions. So it was on the 10th that this court ordered him to be removed to appear remotely from that other courtroom. I have cited repeatedly from Illinois versus Allen, which is the Supreme Court case from 1970, which provides this court with the authority to remove Mr. Brooks from the courtroom. Because it is a new day, I think it bears repeating much of the language that is directly on point in this decision. It is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. This is the Supreme Court stating, we believe trial judges confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. We think there are at least 3 constitutionally permissible ways for a trial judge to handle an obstreperous defendant like Mr. Brooks. In that case, they were talking about the defendant, Mr. Allen. And here are the 3 options, at least that the Supreme Court acknowledged. But I would note, as they just said in this prior quote, there are at least 3. 1, bind and gag, thereby keeping the defendant present. 2, cite the defendant for contempt. 3, take him out of the courtroom until he promises to conduct himself properly. This court has repeatedly utilized the neighboring courtroom because I believe that provides Mr. Brooks with an opportunity to meaningfully participate in these proceedings while this court maintains decorum, dignity, and respect. It is an elementary standard of proper conduct to not interrupt. Mr. Brooks repeatedly interrupts. I gave him 9 warnings before I removed him to the other courtroom. As the court did in Allen, this court decided that under the circumstances to remove Mr. Brooks from the courtroom and to continue the trial in his absence until and unless he promised to conduct himself in a manner befitting an American courtroom, that this is the proper response to his conduct. As noted in the Allen decision, the court stated, "We find nothing unconstitutional about this procedure." This is now the third day of the trial. We struggled at times through jury selection with multiple interruptions, what I would describe as disruptions. So it's with that history we came into court today. Mr. Brooks persists in his unruly conduct. I would note, just as the court in Allen did, it is not pleasant to hold or to find that Mr. Brooks be banished from this courtroom as part of his own trial to the neighboring courtroom. And this is what the Supreme Court went on to say, but our courts, palladiums of liberty as they are, cannot be treated disrespectfully with impunity, nor can the accused be permitted by his disruptive conduct indefinitely to avoid being tried on the charges brought against him. It would degrade our country and our judicial system to permit our courts insulted and humiliated, and their orderly progress thwarted and obstructed by defendants brought before them charged with crimes. As guardians of the public welfare, our state and federal judicial systems strive to administer equal justice to the rich and the poor, the good and the bad, the native and foreign born of every race, nationality, and religion. Went on to state, but if our courts are to remain what the founders intended, the citadels of justice, their proceedings cannot and must not be infected with the sort of scurrilous, abusive language and conduct demonstrated by not only Allen in that case, but by Mr. Brooks in this case. I've also cited repeatedly to SCR Chapter 62, which contains the standards of courtesy and decorum for the courts of Wisconsin. I've advised Mr. Brooks repeatedly. I've had, just as I am holding a copy of Chapter 62 on yellow paper laminated, I have it myself. I provided it to the state. I provided it to Mr. Brooks. And those standards govern what I do, what the attorneys do, what lawyers, clerks, court personnel, even witnesses, defendants, jurors, and others appearing in the court. Two of those subdivisions specifically talk about the expectation that within the courthouse, that those involved in the proceedings refrain from creating disorder and disruption. Another subdivision of that section discusses the expectation that those within the courts conduct themselves in a manner which demonstrates sensitivity to the necessity of preserving decorum and the integrity of the judicial process. Once again, it did not take Mr. Brooks very long to begin interrupting. It is 2:39 now as I go through this decision-making and put my findings on the record, but his behavior started very early on. I gave him ample opportunity to abide by the rules of decorum. I gave him ample warning before he was removed. This court, frankly, has no other option at this point other than to put him in the other courtroom so that I can continue with this very important hearing, a hearing at which he has requested an adjournment of the proceedings. With that, I will turn back to Attorney Opper. I am going to unmute Mr. Brooks, but also advise him that if he interrupts Attorney Opper or others as they are providing testimony here today, I understand he can object. However, my expectation for that objection process would be that he say, I object. He provide a basis. I oftentimes give parties, give me one word. Is it hearsay? Is it, calls for speculation? Is it irrelevant? Whatever it may be, a very either 1-2 word objection or a very short summary statement of the basis for his objection. After he does that, I will rule on the objection that I have made. If he can't do any of that, he will remain muted, and the process will then be, we've given him a sign. He's holding it up right now, demonstrating for us he has the objection sign. He will be required to write down his objections on a piece of paper that will be provided to the bailiff. The bailiff will provide it to me, and then I can rule on those, even if it's striking testimony later on. I do expect his objections to be based in law, I know,
They won't
was
be.
provided with the copy of, the selected statutes, including the rules of evidence. All right,
Oh,
go ahead,
Jennifer.
Attorney Opper, for the
They
record,
won't
the
be.
mute has been undone.
Thank you. So, Ms. Wollenhaupt, I was asking you about the digital discovery materials. You testified that you're aware there is a thumb drive available for Mr. Brooks' use that is maintained in his pod, and all he has to do is ask for it, correct?
Correct, ma'am.
And that in order for him to view the contents of the thumb drive, he'd have to use the computer in the conference room, correct?
Correct, ma'am.
And that is available to Mr. Brooks upon his request, correct?
Correct, ma'am.
And nothing
Hold on a
about,
second. Mr. Brooks, the basis for your objection at this time?
That is relevant to why I'm asking for adjournment. I was not asking for adjournment based on being able to utilize the conference room or the tablet.
Your objection is noted. It's overruled. Her answers may stand. Next, you may continue, Attorney Opper, with your next question.
the, nothing about this protocol then would limit his access to any of his discovery materials, correct, ma'am?
Objection.
Overruled. She may answer.
Correct, ma'am.
And he would have access to the telephone if he wants it.
Objection.
Overruled. She may answer.
Yes, ma'am.
And there would be nothing that would restrict his ability to come to court each day?
Objection.
Overruled.
Correct, ma'am.
And when he comes to court each day, he has the ability to bring whatever discovery materials with him that he wants. Is that correct?
Objection.
Overruled.
Correct, ma'am.
And in fact, there's a card available for him to do that if he so requests.
Objection.
Overruled.
He's just
That
gonna
is correct, ma'am.
object to
Correctional
every
officers would
question.
transport it, but yes, there's a card available.
Sure. Mr. Brooks had told this court earlier that he started feeling not well, I believe were his words, over the weekend. And is there any notice to any correctional officer or jail supervisor that you're aware of that Mr. Brooks reported that to them?
Objection.
Overruled.
I have not reviewed the jail medical record. This came to my attention shortly before the lunch hour.
Okay, I guess maybe I'm asking a question I don't know the answer to. If he were to say to one of the officers or lieutenant,
Hold on a second. Was that an objection? Or just a comment under your breath? Your objection's noted. It's overruled.
if he were to complain of illness to a correctional officer or a lieutenant, would they document that in any way?
They would give him a medical request form to fill out, which would go to the medical department where he could have contact to medical staff, or it could be documented in the jail management system.
To your knowledge, was that done by Mr. Brooks last weekend, the weekend of September 30th and October 1st?
Not to my knowledge.
And are you aware of the fact that last weekend, on or about Saturday, he requested a shower and a shave?
Yes,
Was that provided to him?
yes.
If he were on a protocol, would he still get those things? Or does it depend?
It would depend what type of a protocol.
Okay, thank you.
Those were all my questions. Thank you, Ms. Wollenhaupt.
All right, Mr. Brooks, do you have any follow-up questions for Ms. Wollenhaupt?
I do. You stated that it would depend on what type of protocol I was on, would dictate if I'm able to shower, correct?
That was not completely what I stated.
Well, that's what you just stated on the record.
Well, different management protocols, it would be in accordance with jail operations, and my preference, Judge, would not to be to speak to all of the jail operations.
Right, I'm not going to require her to speak to all the jail operations. If you wanted to ask her, for example, whether your current protocol would prohibit that, I think that would be a fair question.
So that would be the question then. Well, no, let me ask this. What specific protocols would prohibit being able to shower?
Objection, irrelevant.
I'm not going to, it's sustained. Mr. Brooks, I'm going to honor the request of the jail administrator not to talk generally about protocols, given the operations of the jail, but you may ask her if there's something specific as to you.
Well, because of my situation.
Yeah,
being a
we
little
do.
unique, with any protocol that I am on
No more
currently
guessing.
prohibit me from being able to shower and or shave
Do you speak moving forward?
as of right now.
You would be allowed to shower on the protocol you're currently on.
Would I be able to shave?
You would be able to shave.
Would that be with the clippers or a razor?
Objection, relevance.
Overruled, she may answer.
Mr. Brooks, we would monitor
Oh, she
behavior
did
and other
that to
factors
throw
in that
him
and
a
make a
bone,
determination. There's
man.
procedures operationally in the jail that you can request those items. And
That
you
would be independent of the COVID protocols.
correct, ma'am.
So, to your knowledge, are you aware that, we are only permitted, and I'm saying myself as well, being housed in the jail, that we are only permitted razors once a week and clippers only once a month?
Judge, I would prefer not to answer questions in regards to jail operations.
Right, I'll honor the request of the jail administrator. It goes beyond the scope of this hearing. She need not answer general questions about the general procedures and protocols within the Waukesha County Jail. We're a little far field, I gave you a little bit of leeway, but we had started this off about COVID protocols and your current situation, so the, from my perspective, the questions regarding the discovery materials and all of that were relevant because you claimed you weren't being allowed out to a conference room. That to me implicated your ability to prepare for your defense in this trial. So that's why I allowed those questions. Whether you shower or shave would, in my humble opinion, not be relevant to the issue of whether you can assist in your own defense.
Well, respectfully, Your Honor, that was brought up by the prosecutor. It was brought up about the whole issue of being able, me requesting to be able to shower and shave, so that's why I brought it up in my question.
I understand, and I'm under my authority under 906.11. I'm going to advise both parties that anything regarding those types of things are not relevant, and I won't allow questions from either side regarding that any further, at least today on this particular issue.
Thank you, Your Honor. I would want to make one correction for the record. I never claimed not to be able to have access to certain things. I merely claimed that I am on a protocol which limits me even more than I'm already limited. I made no reference to anything in specific, just the fact that I'm on a protocol which restricts me to my cell until the test can come back.
I appreciate that clarification, sir. Thank you. Do you have any other questions for Ms. Wollenhub?
Yes, a couple more.
Okay, go ahead.
Would you care to share with the court on record the types of protocols that I'm currently on outside of the COVID protocol?
Objection, irrelevance. Goes to jail operations.
Sustained. Next question.
Does my specific protocol change the normal time that I would be allowed out of my cell?
Judge, again, that speaks to jail operations.
Mr. Brooks, unless you have a specific question related to access to your materials, I'm gonna have her not answer that, as it goes to.
Well, that directly goes to that because as we know, I'm only on a protocol where I'm only allowed out of my cell a few hours a day as it is. Now being restricted to my cell because of the COVID protocol.
Stalling.
The question I'm asking is, does that restrict even the time that I can be able to be out to utilize the things that I need?
Stalling tactic. That's all this is.
Essentially, I'm only limited. I'm already limited.
Can I ask?
There's times.
I want to make sure I follow you, Mr. Brooks, so I'm sorry for the interruption. If I hear what you're saying correctly, you may have a belief that your access to certain things that would impact your ability to prepare for this case is impacted by the COVID protocols. Is that a fair assessment of what you're trying to convey?
I would say that would be accurate in a sense.
And so if we ask the jail administrator that specifically, is there anything about the COVID protocol that would interfere with your ability to have access to materials or a room? Is that a question you would want answered?
That would be fair, Your Honor.
All right. Do you understand what he's trying
So
to
what
ask?
I'm understanding is, obviously, Mr. Brooks is allowed to keep legal material in his cell. He will remain in his current housing location. Access to the conference room, it will not change that, which is outside of his housing unit. And access to the phone could be granted upon request in the day room area.
All right.
So I do not believe the protocol limits his access to legal material.
Thank you. Do you have any other questions?
Yes, I do. As far as she just referenced the telephone. To the best of your knowledge, are you aware that there is a certain times that the phone will be available? You have other inmates that
Let's not talk about other inmates, but again, I'm sorry for the interruption, but I want to try to get us through these questions. If you're asking,
Okay, let me ask it another way.
okay, go ahead.
Being that because of this COVID protocol, I won't have my usual time out of my cell that I would have regularly, would I be able to utilize the phone in the same manner that I would be able to use the phone had I not been placed on this protocol? Or would it be strictly by me having to just ask?
I guess I'm unclear as to the manner you speak of. What are you referring to?
I think I was very clear with
Are you trying to
you
ask
are
her?
aware, are you aware, which I know you are, that the protocol that I'm on outside
He's
of
like
the
a
COVID
toddler.
protocol,
She's trying to streamline it. Like, she's not supposed to be helping, but she's trying to help him, like, streamline his question so he can get his answer and they can get through this. But he's like a toddler. No, mommy, I want to do it myself. Let me do it. I'm a big boy. I can do it. He's like a freaking toddler.
prohibits me from being able to utilize the phone at certain times of the day. Would the COVID protocol prohibit that any further?
Mr. Brooks, are you trying to ask whether the COVID protocol impacts your phone privileges?
That's what I just said. No, not in a sense, because I think it's more accurate with the way that I asked it.
But your question assumes facts not in evidence and that are beyond the scope of this proceeding. I'm concerned about what, if any, impact the COVID protocol has on your ability to prepare for this case. So I'm going to limit your questioning in that way.
Well, can we at least make a clarification on the record that the reason why we're having this didn't have anything to do with limiting my preparation?
So
That wasn't the real issue.
I think it's related to
I just wanted that clear. I just wanted that clear.
I understand.
That's all.
I understand what you're saying. I respectfully disagree. That's why I've allowed some of the questioning. I believe it's relevant to the motion that's before me for this court to know how the COVID protocol specifically impacts you and your ability to prepare for this case. I understand you might not be claiming the latter to be an issue. You're for the court to consider those things. I heard the jail administrator indicate that the phone privileges would still be available upon request, and I guess to the extent that that's different, if at all, from the standard protocols that you're under, I would accept that as an offer of proof from you.
Well, I didn't agree to that. But the
He
reason
wants
why I
to
brought it
lay
up
up in bed and
was
play
because
sick.
I've been on outside of the COVID protocol. The protocol that I've been on for a very, very long time. So my phone use is limited to certain hours of the day, which works out.
All right, Mr. Brooks, we're getting a little far field. I need to make a determination on your request, so I'll ask you one last time.
You haven't let me finish what I was getting to.
Mr. Brooks, I will ask you one last time. Do you have any other questions for the jail administrator? Because right now you're talking more about things you would provide. So if you have a question that's relevant, please ask it.
I didn't say anything I would provide. Where did I say that?
When you provide information through just a statement about things, that's not evidence, right? The witness on the stand is providing us testimony. Testimony is evidence. Not that I wouldn't accept certain statements from you, but also understanding the state has the ability to challenge those by asking questions of the jail administrator or other individuals so that I can make a determination today on your motion. With that, Mr. Brooks, do you have any other questions for the jail administrator?
Well, everything you just said still speaks to not understanding that I have, Your Honor.
Mr. Brooks, one last time, do you have any additional questions for the jail administrator?
Your Honor, what you're doing right now is you're not being fair right now.
All right, Mr. Brooks has not answered. Mr. Brooks, I need to make a ruling right now. Please stop. He's not answered my repeated question as to whether he has any additional questions for the jail administrator. Unless there's any further questioning from the state based upon the additional questions that were asked, then I'm going to have her step down.
I just want to ask of the court if you're intending to take up his inmate communication form that was dated September 28, 2022 as well, while Ms. Wollenhoff is on the stand. I just have a few questions related to that, Your Honor.
I object to that relevancy. What does it have to do with what she's testifying to right now today? They're two separate issues.
sorry, I don't know the document. Oh, I do have the document number, 258.
Objection for relevancy.
Hold on, Mr. Brooks. I need to find the document in my record. 258, you said?
Yes.
I'm just going to print that off for ease of my reference. I am going to allow the jail administrator to be questioned regarding document 258. I don't know if Mr. Brooks has a copy of that in front of him or not, so I will print it off in that courtroom so that he has that.
So that I have this correct on the record, you're making a judicial determination to allow testimony of something that has no relevancy to what's being raised today. These are two separate issues.
The court recognizes that they're two separate issues, but I also have the authority when considering judicial administration and economies of scale, shall we say. We have the jail administrator here. It's an important housekeeping issue as we go forward. And so I'm going to address it after I address the motion to adjourn that you filed. But since we have her here, I'm going to have the parties question her on that document as well. It promotes judicial economy, and that's my decision. So go ahead.
Can I put Your Honor on notice that I intend to appeal that decision?
Your statements noted of record. All right, go ahead, Attorney Opper.
Ms. Wolenhoff, I don't believe you have the document in front of you, but
The record should reflect I'm handing your a copy of what is in the record as document 258.
thank you, Judge, I'm sorry.
That's okay. I'll print off another copy for myself.
Okay.
Can someone confirm whether that document was given to Mr. Brooks as well? I did print it to the printer over there. I have that ability. It was. All right, thank you. The record to reflect he has also been provided with a copy of docket number 258.
I'm not acknowledging that document, Your Honor. I'm not acknowledging that. I don't consent to.
All right, I'm going to mute him because he's interrupting. Mr. Brooks, it's a document you filed. So, and it's a document that was filed through the inmate communication form process. It was scanned in on October 3rd, but it's dated 9/29, and it's directed to either clerk of court / Judge Doro. So go ahead.
Thank you. Ms. Wolenhoff, you've seen a copy today, correct?
Yes, ma'am.
You're aware that it's dated September 28, 2022, correct?
Correct.
And purports to have been written by Mr. Brooks himself, correct?
Correct.
And in this communication to the court, Mr. Brooks indicates that he is on a, quote, keep separate, end quote, in the jail, correct?
Correct.
And at the conclusion of the form, near the bottom, the last two sentences, he indicates that he has no access to the materials he needs to prepare for trial because of the keep separate order, correct?
Correct. That's what he states.
Okay. Is that a truthful statement? Well, let me ask it different. That's a bad question. I strike that question. Did Mr. Brooks have access to his legal materials during the time that he was under a keep separate order?
Yes, ma'am.
Again, that would be the banker boxes of written discovery in his own jail cell?
Correct. Anything that was in his jail cell, he would have access to.
Okay.
And he would also have access to the conference room and a tablet.
And the
in
tablet.
his cell.
Okay. And that's the legal materials that are provided to him are on that tablet and on the computer in the conference room?
Correct.
And nothing about that keep separate order affected his ability to access those things, correct?
Correct.
Thank you. I don't have any other questions on this topic, Your Honor.
All right, Mr. Brooks, I will unmute you. Do you have any questions on this topic for the jail administrator?
Yes, I do. You just stated on record that I had access to all materials for trial prep during the time of this keep separate, correct?
It doesn't specifically say what you don't have access to, so yes,
No, I
what was
said,
in your cell.
Did you just say in open court on the record that I in fact had access at the time of this keep separate?
2 items in your cell, and you could have access to the conference room to view electronic legal materials.
So, am I correct in saying that when you brought over these discovery materials to the pod, that I was in fact in one of those conference rooms and I talked to you face to face, is that correct?
You were in a conference room and we spoke.
And I informed you then that I was going to keep separate, correct?
I do not recall that.
I specifically told you that I was going to keep separate with the guy that was in the cell next to me that had placed that on me, correct?
I do not recall that.
So you don't recall, you can recall that we spoke, but you can't recall what we spoke about.
I informed you at that time I was delivering the banker's boxes.
And I took the liberty to explain to you that I was going to keep separate and that that was going to hinder me being able to prepare. Is that correct?
I do not recall that.
You don't recall that, or you don't remember me bringing it up?
I do not recall us having a conversation regarding the keep separates. We had a conversation regarding me delivering your legal material.
So is there a way to verify when the keep separate went into effect?
Objection relevance. Well, hold on. Mr. Brooks, as I read this inmate communication form, and perhaps it's just a simple question, when you wrote it, did you have access to the banker's box of materials yet?
No, I did not. Ms. Wallenhoff just testified the last time that she gave testimony that she brought the discovery materials over on Thursday the 29th. She did say that in open court on the record.
Yep, she said that previously.
This inmate request was written on September the 28th. At that time, I was already on the keep separate protocol, which does not allow me to come out of my cell.
But is the issue that keep separate protocol, or that you didn't have access to the materials that we've now established through testimony you had access to once they were delivered to you?
The keep separate protocol in itself, Your Honor, restricts the two people that have to keep separate from being able to come out of their cell until one of them is moved. Whether that be to another unit in the pod or a different pod, that part I can't speak to, but neither of the parties are able to come out of their cell until someone is moved. And the reason why I wrote, initially why I wrote it was because that stops me from being able to shower in the unit, because officers would have to then take me to another part of the jail, sometimes in the pod, in a secure shower is what they call it, which is downstairs.
Sir, I'm just going to stop you because I honestly, the whether you have a shower or not is not relevant to the issue of whether you had access to the materials you need to prepare for your case. So I read this inmate communication form, especially that very last sentence. I am respectfully asking and requesting that my trial be slightly delayed as I have no access to the materials needed to prepare for trial. Thank you. So my question to you is, and I think you've already answered it, but I want to make sure. At the time you wrote this inmate communication form, the materials had not yet been delivered to you. Is that your testimony?
The boxes that were brought over had not yet been delivered. I had already had maybe 10% of the discovery materials that was provided to me by my former attorneys on this matter.
Right.
That
So
in itself was very, very voluminous in itself.
sir, we had a prior hearing related to the access provided to you and when the materials were provided. You may recall that Attorney Perry even testified over Zoom audio about that. The jail administrator testified as well. To me, that record is very clear that the materials that were provided by their discharge on your case were received by you on September 29th of 2022. That has been established. No one is disputing that. So that's the record that I have before me. I understand what you're saying about the keep separate, but also at that hearing, it was made very clear to everyone that the jail administrator gave some specific directives as it relates to you and access to certain things.
I do recall that, Your Honor. And one of the questions, if you recall, one of the questions I had about what you just said was, did all the officers know about that specific order, I guess it would be called? I don't know what it was exactly, but the information that was to be passed down from Ms. Wallenhoff to the officers.
Right, and I'm not going to revisit that because you were given ample opportunity when we first addressed that to ask questions and to provide other information, meaning statements from yourself. And the clear record from that is that the information was put into the jail management system. It was documented. and that the jail administrator had no information to suggest her employees did not have that information and honor that information. There was no testimony from anyone else to suggest that that wasn't followed. So,
I would like to say something for the record now.
go ahead.
To speak to what you just said on that, it's possible that all officers were not aware of that. I even talked about this with an officer who worked just last night that wasn't even aware. And his answer was that he had been off for a few days, so to his knowledge, he wasn't aware of that. And that issue came up because I specifically asked to utilize a tactic. So in my mind, that would say to me that I'm not trying to argue if the order went out to the officers. That's not what I'm disputing. I'm just disputing the fact that every officer that works in my pod isn't aware of that.
All right, thank you. Any questions at this point for the jail administrator? Again, not related to the shower, but related to access to materials.
Does the keep separate protocol, is why does the keep separate protocol restrict inmate movement in any way?
Objection, relevance.
Sustained, overly broad. Next question, or rephrase.
Does being on the keep separate protocol, or rather, should I refer to myself? If I am on the keep separate protocol, would that in effect limit me to only being in my cell and being able to only utilize what I would essentially have in my cell?
That's a compound question, so you have to break it down one at a time. So rephrase.
Would a keep separate protocol restrict me to cell confinement until arrangements can be made for me to be able to resume my normal activities?
Judge, I would prefer not to answer that. It's due to jail operations. We would look at each individual in each situation. I think it's overly broad.
Mr. Brooks, I'm going to honor the request of the jail administrator to not answer that because it would require her to provide information regarding jail operations. It's overly broad. You need to limit the question to how this protocol limits you, specifically as it relates to access to materials needed to prepare for trial. Not generally whether you're on any kind of restriction, whether, but how, the focus is how this impacts your ability, if at all, to access materials needed to prepare for trial. Other than we've established that you didn't have the materials from your attorneys that were provided after they were discharged by the court until September 29th. I mean, we've established there was a gap, right? I granted the motion and allowed you to represent yourself on the 28th. That was a Wednesday. And then the materials, even though they were turned over to the jail, it sounded like in the evening on the 28th, there was protocols in place to go through that. And then those were provided to you on the 29th. That is well established on the record. So I understand that. We've addressed that in part previously. So I know the state wants me to address this, and I think I know the reason why. But if there's any question you want to ask the jail administrator about what was going on the 28th or 29th, or even going forward, that would impact your ability to have access to these materials, that's the type of questions you need to ask, okay?
Well, I asked the question, and I was told that it wouldn't be answered. I asked at the time that she brought over the discovery materials, was she aware that I was going to keep separate protocol at that time?
Ask and answer.
Sustained. The answer was already provided. She doesn't need to answer it again. Next question.
What was the answer to that?
The record speaks for itself, sir. Next question,
I don't
please.
recall her answering that specific question.
Next question, please.
Can you provide for me where she answered that specific question?
Mr. Brooks, do you have another question for the jail administrator?
Is it going to be answered? Is it going to be honored?
The record speaks for itself, sir.
Well, if the record speaks for itself, then that question should be able to be answered. Were you aware, Ms. Waukesha, that at that time, I was on a keep separate protocol, that it was already in the system that I was on that protocol?
What date are you referring to, sir?
The date that you brought over the discovery materials, were you aware at that time, on that date, that I was under a keep separate protocol?
You previously asked me if I recall the discussion, you were informing me.
But that's not the question now.
I was aware.
The question is the date that you brought over the discovery material, were you aware at that time that I was on a keep separate protocol?
I can't state for certain at that moment in time. I was aware you were on a keep separate. I can't state what date that I was made aware of that. I think it was due to a complaint that you sent forward to the jail.
I sent no such complaint. The complaint was by the other party. Were you aware of that?
Judge, I prefer not to answer this. I don't understand how it impacts what he has
Mr.
had
Brooks, we're
access to.
far afield from the issue at hand, so I'm going to ask you one last time, do you have any additional questions for the jail administrator?
What
Quit asking him
What?
that.
what are you allowed and not allowed to do on a keep separate protocol?
Relevance.
Sustained. All right, then, I gave him the opportunity to ask questions. That was his last one.
I wasn't done.
Mr. Brooks, I'll give you one more opportunity then. They need to be relevant. They need to be within the bounds that I've already discussed.
That was in the bounds.
No,
I just asked this.
The issue is limited to the impact of a keep separate on your ability to have access to materials needed to prepare for trial.
But Your Honor, with all respect, every question that I asked that had relevancy to that was either overruled or she was directed not to answer that.
Mr. Brooks?
So the
Mr.
question
Brooks,
that
you
I'm
indicated you had other questions. I will give you this opportunity if you can ask a question that falls within the scope that I've previously identified. Do you have another question?
would I be allowed out of my cell on a keep separate protocol?
Vague, Your Honor. The question is, was he allowed out of his cell to access his legal materials?
That's not what I asked.
Right, the question you asked, the objection is sustained. If you'd like to ask the question suggested by Attorney Opera, that would be permissible by the court.
No, I would want to ask my own question. Thank you. Was I able to come out of my cell on the keep separate protocol?
Judge, I prefer not to answer that.
It's beyond the scope of the inquiry right now. The jail administrator need not answer that question.
Can you give me the basis why, Your Honor?
It's beyond the scope.
What does that mean? I do not understand.
Mr. Brooks, do you have any other questions?
I do
You
not
know who would
understand.
understand? A lawyer.
One last time,
A
sir.
lawyer
Do you
would
have any other
understand.
questions?
That was a direct question.
Oh,
right,
but
then
you
mute him
fired
because
your
he's
lawyer.
Now, not being responsive to the question that I asked, and that is, does he have any questions to ask the jail administrator within the scope that I've previously outlined? Any follow-up from the state?
No.
All right, thank you. You may step down. All right, does the state have any other witness or evidence you want me to consider related to either of these issues, the motion to adjourn, or the inmate communication form dated September 28 of 2022?
Nothing else from the state, Your Honor.
Mr. Brooks, do you have anything else related to the inmate communication form dated September 28 of 2022? Since we obviously included that after we took up the other issue.
Yeah, I don't understand how, any questions that I was asking, are not allowed to be answered.
Mr. Brooks, I'm asking you very clearly, do you have any other information, testimony, or evidence you want to present as it relates to the inmate communication form dated September 28 of 2022?
Yeah, I would like to, is there a way that we can verify the standards of the keep separate protocol?
Mr. Brooks?
To be able to show the
Mr.
court.
Brooks, please listen very carefully. There's a question I'm asking you, is do you have any other evidence, document? All right, then
All right,
I'm going to mute him once again. He is not answering very clear questions.
I don't consent to
I asked him
answering
if he
questions
had any
because you're not answering
information,
mine.
evidence, testimony, documents he wanted to present.
What a baby.
Instead, he asked me if I could verify, and that is not within my role. This is an adversarial system of justice here in the United States and in Wisconsin. I preside over that, but it's up to the parties to present information, evidence, testimony to the court so that the court can address the requests and make decisions. I would refer Mr. Brooks back to the waiver of attorney form that was discussed last week.
Got the objection sign back up. Stupid.
It is document number 244, scanned on the 28th day of September 2022, wherein Mr. Brooks was advised that the judge cannot be his attorney, cannot give him any legal advice. The district attorney cannot be his attorney, cannot give legal advice. The judge, district attorney, and court personnel are not required to explain court procedures or the law, among other things, and that he is required to follow all legal rules and procedures that an attorney would have to follow in court. He was also advised, and this is just one part of that form, that it may be difficult for him to present evidence, may be difficult for him to do a good job as his own attorney. We discussed at length the advantages to having an attorney, the disadvantages to representing oneself. And what he is asking this court to do is to explain the law, and could also be described as a request for legal advice. All right, with that then, I'll certainly take up any arguments from the parties as it relates to both of these issues. I'll start first, though, with the motion to adjourn. Mr. Brooks is holding up the objection that we're not taking testimony at this time, so the court does not feel compelled to acknowledge that any further, other than to say the fact that he's objecting is noted for the record. Mr. Brooks, I'm going to unmute you because it is your motion to adjourn these proceedings, and as such, I will give you the first opportunity to talk about the evidence that I've heard here today by way of testimony, and to make your specific request known to the court. I then will give the state an opportunity, and then I'll decide the motion. All right, Mr. Brooks, what is your argument as it relates to the motion to adjourn?
Well, I'm not arguing. I stated pretty clear why it should be an adjournment. I don't think I need to argue anything.
That's the way you do it.
I need to provide anything more. If it's
Put on evidence and then you
it's
argue.
It's clear to me that the wrong person was testifying. She said that she was not present for the said COVID test. So there's, to her knowledge, no way to say for sure why I wasn't provided with the test that I should have been provided with, if that becomes an issue. Honestly, Your Honor, I'm powering my way through this hearing. I feel like total crap, to be honest with you.
He feels like what?
I don't feel good at all. My reason for raising this issue, like I said, was strictly a health and safety
No,
thing.
strictly
It didn't have
a
anything to do with
delay
trial prep. It
tactic.
didn't have anything to do with access to anything. It was strictly because, like I stated before on record, I've never had this issue come up for me. Like I stated before on the record, I've had people that I know, loved ones, close people, pass away from this COVID disease. Frankly,
It's
I'm
the
terrified
flu.
because I have yet to even get the results
Where are you
back
going?
to say whether I'm positive or negative.
You just
I
got
am fully
here.
vaccinated. I've never tested positive for COVID. And frankly, to even be told that it's a possibility that I could have COVID, it makes me very afraid.
It's the
Which
flu.
is one
You'll
of the
be
reasons why
fine. I've had it
I was
twice.
so concerned about the actual protocol, because once they informed me that I would have to be essentially quarantined and isolated, the first thing I was thinking about was how would I be able to use the phone and be able to tell my family what's going on? How would I be able to reach out to my kids and things like that to let them know, hey, I got a health issue going on here that I'm worried about. That was my concern, and my intention was to at least be able to get the results back so that I know, okay, I'm good to go, let's keep the ball rolling. That was my intention.
He thinks
Like I
he's
said, I
dying?
just
Is
came
that
to
what
the
he's trying to
This
say?
morning when they called me over to do the test, I had no
He
idea
thinks
that
he's
was
dying.
what they were going to do. like I said, I didn't understand the protocol until it was explained to me. So I'm just coming into this knowledge as well. I'm still trying to wrap my head around it. With that, Your Honor, that's pretty much all I have to say. Is the intent of it is
Wrap
strictly
your head
that,
around the fact that you have the flu and you're
you know,
contagious. Okay.
not want to, if I am positive, not want to infect anyone else or put anyone else in jeopardy. And also doing the things that I may need to do if I'm found to be positive, doing the things that I need to do to be healthy. That was my concern, and that's why I raised the issue, Your Honor.
Thank you, Mr. Brooks. I'm going to turn to the state then next. As a reminder, don't interrupt them. Thank you.
Well, Judge, I'm glad to hear Mr. Brooks say this is not a trial prep issue and merely his concern for the health and safety of others. The court has already made the record that we can safely accommodate Mr. Brooks in this courtroom without risking the health and safety of other individuals, even if he should have positive results on his COVID test. We feel comfortable with that as well. The jail can still move him properly. The bailiffs in the courtroom can still respond to his needs properly. So if it's merely a health and safety issue, I believe we've easily overcome that, Your Honor. I don't put much credibility in the comments of Mr. Brooks here. As Detective Regland just advised me, he made 17 attempts for phone calls just this morning alone. So his statement to the court that he was worried about being able to call his family, I think, really is questionable. I also would like the court just to acknowledge that document 258, and perhaps that's a moot issue at this point, but I still think a record should be made that no matter what circumstances have arisen with Mr. Brooks specifically in the confines of the Waukesha County Jail, he has always had access to his legal materials, the discovery in his cell, and the necessary tablet and computer so that he can prepare for his case. So I would ask you to deny the motion to adjourn because of the COVID protocol, and to the extent that there was a prior motion to adjourn because of a keep separate order, that also is inappropriate at this time. Thank you.
Thank you. I'm just pulling up a couple of documents so that I can review them electronically as I make a decision here today.
You don't need documents. Just make your decision.
You may briefly respond. Go ahead.
If all parties will recall, one of the detectives that is sitting right behind the prosecutor's desk right now, Detective Casey, just went through something similar with COVID and was not present for a couple of hearings. I don't know how long his protocol was. I can't speak to that situation. It's not my business, frankly. But he wasn't present in the courtroom. And I think that has relevancy due to probably him feeling the same way, not wanting to infect anyone else or put anyone else at risk.
Why is he talking about Detective
where
Casey?
there's any difference in my situation. Also, very briefly, for the record, I was able to make a phone call, phone call attempts, because they were attempts, this morning after I came from getting the test because I raised the issue. I said, since I know that I'm going on this protocol and I'm already out of my cell, can I take this opportunity to try to notify my family of what's going on? That's why there were so many attempts, because I wasn't able to reach my mother, who pretty much has access to my kids. If I need to get some information to my children, she's the one that is in charge of all that. I just wanted to state that for the record.
Thank you, Mr. Brooks. Well, the court has heard from Mr. Brooks. The court has heard from the jail administrator. The DA has provided some additional information as officer of the court. Let me address Mr. Brooks' motion to adjourn. He filed an inmate communication form earlier today, raising this issue. He is on a protocol. He is not tested positive. He provided information today that he is fully vaccinated, that he'd been telling officers for days that he had not been feeling well. Test results today. He was offered a rapid test and refused. He reports symptoms of fatigue and that he can't taste. He also indicated it was a few days ago over the weekend that he started experiencing these symptoms. Now, during his time here today, Mr. Brooks, despite the disruptions, has been very clear, coherent. He has asked questions. He's made objections. I know he might not like the word argument, but that's a word that we use in the adversarial system when the court asks the parties for their positions on certain issues. We call it legal arguments, or arguments for short. Doesn't mean or have any connotation that it's unruly or disruptive or a disagreement. It's just the word that we use in the legal system. He was able to articulate his positions to the court. He had some animated. He appeared, again, to understand what the court's either questions that the court was posing to him or information the court was providing to him. He clearly was able to, Mr. Brooks, please don't interrupt me or I will mute you. He was able to follow the questioning and answering process with the one witness who is here today.
Don't interrupt me or I will mute you.
I appreciate that he clarified that he was not making this request due to trial prep or access to material issues, but it was really related to his health and safety concerns. At this point, there's insufficient information on the record to find that his concerns are anything more than speculative. And given my observations here in court today, he is very able to assist in his own defense. He's able to present arguments, etc. I've already noted. We are able to accommodate the health and safety concerns in this courtroom. We confirmed that where he sits at the table, if he's in this courtroom, there is no one around him who would be within 6 feet. That is an important consideration that has been one of the topics of guidance from the CDC, certainly one of the, or part of the guidance we have received from the county. The most recent county protocol talks about isolation for 5 days. Clearly, if he had the onset of symptoms over the weekend, which is what he reported, and he has not had any escalation in those symptoms, as has been demonstrated by his ability to participate in this hearing. The court will find that there are no present health and safety concerns other than what I've noted with the 6 feet and social distancing. I'm not going to adjourn this trial. I'd also put on the record that he has not been denied access to materials. He has full access even with this protocol. He has had access even to the phone. There's been what's been referenced by both the state and Mr. Brooks about attempted phone calls. I'm not so concerned about whether phone calls go through. It's the fact that he's been given access. Whether he connects with someone is not the issue. I'm also concerned about the fact that he would not answer the court's question directly about whether he would take a rapid test. To me, his credibility is at issue with that. If he were truly concerned about his own health and safety, he would want to know immediately. And he repeatedly would not answer that question and instead wanted to debate about what test was provided to him and why perhaps it was not. All right, you're interrupting me. I'm going to mute you. So that is my record here. Today, I agree with the state's assessment. This is nothing more than a delay tactic, given the information that this court, and once again, on the record before me, there is nothing to suggest that he is actively being impacted by COVID-19, and that any health and safety concerns he has for his own safety can, again, be met. The jail is able to get him here. The jail, of course, is responsible for his medical care. We can keep him 6 feet away from any other person. Obviously, if he's removed to the other courtroom, that provides a greater buffer as well. And for all of those reasons, I'll deny the request to adjourn. As to the issue that was raised in the inmate communication, obviously this was a form that was sent by Mr. Brooks on Wednesday, September 28th of 2022. That was the day on which this court granted his request to represent himself. We know from the record, not only from today, but previously, that on September 28th of 2022, what he would have had in his cell would have been materials previously provided to him by his attorneys. His attorneys, through Attorney Perry, dropped off 3 bankers' boxes worth of materials and a flash drive to the jail later that date. And the jail followed whatever protocols they have with regard to those materials and reviewing them, and that those materials were provided to Mr. Brooks on September 29 of 2022. He's confirmed through the most recent request to adjourn that he wasn't even making that request based on any type of access limitation to materials or things of that nature. Although not a specific statement by him, this court would take that to mean he has been able to continue with his preparations. I'd also put on the record that there's no doubt that being in trial can be exhausting. We, of course, had 2 afternoons of hearings last week. Of course, he was provided with a lot of material. From my perspective, he clearly understood the perils of self-representation and the volumes of material that he would need to review perhaps a second time because he had some of them, or for the first time. Those were things that were clearly, he was clearly advised of before I granted that request. And then, of course, we had 2 very, very long days of jury selection yesterday and the day before. Given the way this jury selection progressed, we did not start with court until today at 1:30. Frankly, part of that was done not just to provide access to the media pool and the cameras and other things that needed to be installed, but honestly, to provide a little bit of a break for myself, and I would hope for the other parties as well. Of course, everyone continued on with their preparation, but I actually understood this request. I may not have referenced it previously, but that really factored into my decision to start later today as well, and to not bring the jurors in until tomorrow. So I am satisfied that Mr. Brooks has access to his materials that he needs to prepare for trial. As I indicated earlier, I have also provided to him the Wisconsin Criminal Code and selected traffic statutes, including the Wisconsin Rules of Evidence. It's from 2018. While there might be some slight modifications to some of the substantive statutes, this would give Mr. Brooks a very good reading as it relates to the rules of evidence and the statutes that relate to the charges he is facing. I'll provide a copy of that, a photocopy of the cover, so that it's docketed in the case as well. While this court is under no obligation to do that, since I was able to locate that, I am putting that on loan to Mr. Brooks. What he also needs to understand, though, that at this point it is for use in the courtroom. I would entertain a request that it go back with him to his room on a couple of conditions. 1, it would be that he agrees to bring it to court each day. 2, that it be maintained in its current condition. And then 3, that it's returned at the conclusion of the trial. So that will be for him to decide how he wants to do that. He has been raising the sign objection at all times during my oral decision. I would note the use of an objection is when the trial is in an evidentiary phase or a motion where we're talking and addressing the receipt of testimony and evidence. It's a mechanism under the law by which a party objects. They usually state either a 1 or 2 word basis. Sometimes it might be a short sentence or 2. Sometimes the other party's given an opportunity to respond if it's self-evident to the court as to either what the objection is or the basis for a granting or denial. But the court rules on it, and then the parties move on. Those are the not only expected procedures for this case, it also comports with just the basic tenets of civility and respect, that you don't interrupt. Again, an objection is a legal basis to interrupt, but it's done in a way that's respectful. Simply holding up a sign that says objection is not does not comport with those expectations or procedures. All right, so I've addressed those 2 issues. I have a list. I'll tell the parties what's on my list, and then you can add to that as well. I do know the state filed a motion for reconsideration, so that's on my list as well. I wanted to touch base on the request for an interpreter. Again, the motion for reconsideration. I've already addressed the subpoenas. Madam Clerk, can you just confirm for me that they were signed by the clerk's office and then the 10 copies were provided to Mr. Brooks?
Correct, while he was sitting here.
While he was seated in the courtroom.
At 11:18.
At 11:18 this morning, he was also provided with copies of subpoenas. Do you know how many copies were provided? 21 this morning, an additional 10, I believe, this afternoon. So he has those available for his use. I've already addressed the statute book, so I can cross that off my list. And then, of course, preliminary jury instructions. Now, I know Mr. Brooks, I think, did not bring his with. I wanted to make a change to those before I printed off a copy for him. It's not a huge change. It's really just an addition. And it has to do with some of the language that I have been stating to
But in an auction house, you don't leave your
the
paddle
jurors
up.
if there have been disruptions. Not every time, but I do feel it's important to put some language in after jury instruction 70. But I'll get to that. We'll probably do those last. Attorney Opper, anything you would add to the list that I have?
Yes, Your Honor, I just wanted to understand some of the logistics as far as objections and cross-examination and exhibits. And I also have
You got to put your
the
paddle
state's
down when you're
witness
buying
list prepared and
everything.
filed. It filed it at the start of this hearing. I'm sorry, did I say witness list? Exhibit list, 8 pages right now with 140 items. I was going to make that available. So I guess I have a question about that, and I don't know if you want to take that up right now or not.
I have one other, give me your whole list though too, and then I have one other thing I need to add as well.
And then criminal records for state's witnesses. That was it for my list. Then that overlap, the rest overlap with your list, Your Honor.
I know Mr. Brooks appears to be talking to someone and hand gesturing. Unless he writes a note that he has a topic he wants to address for me at this moment, I'm going to assume he's just directing his commentary to the bailiff that's in there. I will unmute him momentarily to ask him a question, and that question is whether there are any housekeeping issues on his list. All right, Mr. Brooks, are there any additional issues that you believe need to be addressed? Mr. Brooks, can you hear me? Mr. Brooks? Do you have any additional issues to what I've already set forth and the state's added to the list of what I will call generally housekeeping issues, other than perhaps the motion for reconsideration? That's not housekeeping, but.
I was having a side conversation with the bailiff about something, so I didn't hear the last part of what you said.
It's my understanding that the bailiffs would not be having a conversation back with you or at you during court proceedings. I'll have to confirm or deny that with them. Becky, if you could talk to the bailiff, please.
Well, Darrell got bailiff in trouble.
All right, so it's my understanding you were asking the deputy how to pronounce a word. Did he provide a response back to you, Mr. Brooks?
A kind of a response.
What do you mean by that?
It was kind of a response.
Did he provide a response verbally?
I'd rather not say Your Honor.
I'll have to get clarification from the bailiff later on. He's coming in here. Okay, thank you. Did you provide a response to Mr. Brooks?
I just told him I didn't understand his word. He was asking me to pronounce what the pronunciation of the word was, and he spelled it to me. I said, I don't know what that is.
Okay, thank you. Mr. Brooks, I'll ask you one last time. Do you have any topics that you believe should be on the list of housekeeping items to address today, other than the ones I've provided to you?
I did not hear the ones that you are referring to with.
All right, listen to me now because I'm going to go through the list. Some of them we've already discussed, so I'm going to give you my whole list and then I'll say whether we need to address them or not. We have to address preliminary jury instructions, the state's request for an interpreter, the state's motion for reconsideration. I'll get to that momentarily. I've already addressed the subpoena request from you. I made a record of that. I already addressed the fact that I provided you with selected statutes. If you didn't hear, I'll state this part again. The book that I provided to you that was on your table when you got into court today, and that I believe is on the table, or at least was taken over when you were removed to that courtroom, is the Wisconsin Criminal Code and Selected Traffic Statutes, including the Rules of Evidence 2018. It's a State Bar of Wisconsin Pinnacle publication. It's probably about 2 inches thick or so. It has a reddish or maroon in color cover and binding. That's been provided as a courtesy to you. It's been provided to you to use in the courtroom. I would entertain a request from you if you want to take it back to your cell as you prepare on the following conditions. 1, you agree to bring it to court each day. 2, you maintain it in its condition presently. And 3, you return it at the conclusion of trial. I'm not asking you to make a request at this time. It will stay in the courtroom unless you at some point make a request. The other issues, hold on, sir, let me get through my list. The other issues are logistics regarding objections and cross-examination, the state's exhibit list, which was filed earlier, criminal records for state's witnesses, and then I have an added topic related to court TV exhibits and FCC rules, and just some things that may be impacted during the broadcasting of the proceedings because of the FCC rules, which I will claim I'm not an expert on, but I felt compelled to at least tell the parties. I'll start with that so I don't forget, and that is I have been advised that there are FCC rules that may require graphic images or videos to not be broadcast. And I know the state at one point had made a request, and we had talked a little bit about individuals who are victims appearing in a remote location and watching the live stream and seeing those exhibits. And originally, I had planned to utilize Zoom, and there's a share screen option. I'm not going to be utilizing the Zoom because of now the new mechanics for the live stream and the pool feed that Court TV has taken over and is providing to all of the other media that wants access to it. So I just wanted to make you aware of that.
Thank you, Judge, and I believe there was a workaround that was accomplished with the cooperation of Court TV and the county IT, so that the victims will be able to view whatever is being shown in the courtroom, notwithstanding what's broadcast to the general public under FCC rules.
Excellent. I'm glad to hear that.
Yeah, and I would like to know for the record that the Court TV was very accommodating and very helpful in that regard, and we appreciate that.
And as a reminder, so you'll see there are some cameras that have been installed in this courtroom and some microphones. Like I have an additional microphone next to me. There's a camera down in front of the court reporter. There's a camera in the back, and there's a camera over to my left in the clerk station work area. I've also indicated, because now we may have to use the adjoining courtroom, they're in the process of getting some equipment so that there's a camera in there as well. I know that needs to be worked through with the county facilities because of the cabling and all of that. So I just wanted the parties to be aware. I have approved of all of that. That brings me to a related topic, and that's the use of the courtroom microphones are still an audio backup, but we have really good microphones in this courtroom. The state noted it yesterday, or maybe it was the day before. At one point, Mr. Brooks appeared to be muting the microphone in front of him, but because there's microphones elsewhere, we were still able to see the audio. I'd advise the state of the same thing. You have microphones behind you through the court system that just because you mute the one in front of you, you may still be picked up. And that just whispering still comes through on the microphones, whether they're the courts or otherwise. So,
Can I ask a question about that?
sure.
During recesses, is it possible to mute all microphones so we can confer?
Absolutely.
Okay.
Remind me, right? We need the clerk to do that. But I think if we all cooperate together, we will get that done.
Thank you.
All right. Any questions about the broadcast, Mr. Brooks?
I didn't really understand the whole gist of it. So, I'll go with the part that I don't think that if you are not in the courtroom that you should be privileged to see anything. I think the word you used was graphic.
I am not responsible for Court TV's compliance with FCC regulations, but it's my understanding that they will meticulously follow whatever the regulations are. But what's in the courtroom is clearly going to be what's in the courtroom, and anyone in the courtroom will be able to see fully based upon the monitors, including the jury, including the court, and including you, whether you're in this courtroom or the next courtroom.
Yes, that would be the preference. If you're not in court, you shouldn't be able to see everything in court.
All right, moving on to the next topic then. There's a state's request for an interpreter. I wanted to address that because the form that you used, and thank you so much for doing that, requires that I sign an order. But it's my understanding that that request may be modified.
Yes, Your Honor. As to the timing, certainly it will be modified because I think I indicated October 6th or 7th. I no longer anticipate that being necessary. It would likely be one day next week. If you give me just a second here, I can maybe give you a better idea. I'm wondering if the court, I hate for the court to pay for an interpreter that we don't use. So I don't know how much notice you need to give to the interpreter, or how far in advance you have to reserve them before you have to pay them no matter what. I don't know if they have rules like that or not. Okay.
It depends. Okay. So thankfully, we have one local interpreter who is incredibly reasonable, and I know is kind of on notice, but it really depends on his schedule. And what we may have to do as the courts, because you are correct, it's the court's responsibility to do this, to pay for it. I will not make arrangements just yet unless, just based on the request that was made, because you said it's no longer a date that you would target for that interpreter. I'll decline the proposed order. And then just, if you want to resubmit, of course, we have someone in the clerk's office who is, parties work with regularity to obtain interpreters. And so the state can simply continue to work directly with that person to facilitate and hopefully keep the costs down. And we'll deal with whatever the fallout financially. Typically, we need 2 business days to cancel them. So if you can make arrangements, for example, say next Thursday or Friday for those witnesses to appear, and then you decide you don't need those witnesses, and we should be able to cancel them by Tuesday or Wednesday, depending on the day that we've selected.
Sure, I understand. That's very helpful, and we will definitely be diligent to keep the court informed. I understand, I agree, it's appropriate for the court to deny my request today, and I will renew it as needed.
You know, as I think about that, I think what I'll do is I'll approve it, but I should be able to add some language about this date may be modified through direct communication between the DA and the clerk's, the person in the clerk's office responsible. I don't need you to file again and again if it's really the same request. It's just the date is changing, and you're doing that in order to, frankly, save money for the county.
Yes, that's exactly our intention, Your Honor. Thank you.
Yeah, thank you. On that, let's go to the motion next, at least preliminarily. Did you serve that motion on Mr. Brooks?
No, Judge, I don't think I did, to be fair. I had it in my office, and I was going to ask Detective Bregman to take it over there, but I don't believe I ever actually did that.
All right, I will ask that you have that served upon him right now, and that will obviously impact the timing of when I can address it, but we'll save that near the end. But I'd ask that you, Detective Ragland, go do that right now, and I will just pause momentarily so that that can be done. Doing that, I'm going to take a short comfort break as well. So we'll be in recess. It's 4:06. Let's take about a 10-minute break.
Okay. Yay. I think we're up to opening statements, which is, I didn't watch opening statements either. Oh no, we're not done with that yet. Crap. Darn it. They're just on a break. Come on, give me my cursor back. Very long break.
Would you like to come back over to back into the courtroom if you so choose? You have been respectfully participating from the other courtroom. Of course, if you do come back in, you of course would be expected to abide by the rules of decorum and courtesy. Would you like to come back to this courtroom, sir?
I never stated that I wanted to be removed in the first place.
My question to you, sir, is would you like to come back over to this courtroom? I will ask one last time before I consider his answer to be non-responsive. Would you like to come back over to this courtroom, sir?
That is not a non-responsive answer, Your Honor.
So the answers provided were not responsive to the question that I asked, and therefore he'll remain in the other courtroom. The record speaks for itself, sir.
Your Honor, I'm very tired, so.
Mr. Brooks, Mr. Brooks, we're gonna keep going, so please don't interrupt so that we can do this as quickly as possible so you can go back to your cell.
Well, I was just really trying to make the record, which you haven't allowed me to do. As I stated at the beginning of the hearing, I would like to make an offer for my appeal. I've stated that on the record numerous of times yesterday and today as well, and I haven't been awarded that right to do so.
Mr. Brooks, I'm not going to respond to that simply because if you want to file an appeal, then you should take the necessary steps to do that. All of my decisions are on the record. You can request a transcript if you want to have a written copy of what was said in court. I can't provide legal advice on how to pursue an appeal, but I would not grant an appeal. That is not within my authority. That is a reviewing court would decide that, whether that be the Court of Appeals, the Supreme Court, or otherwise. So that's why I'm non-responsive to that, is because there's nothing for me to do as it relates to that based upon the requests that you have made. So with that, Mr. Brooks, Mr. Brooks, I'm going to mute you, okay? Mr. Brooks, you've now earned the mute button once again. Despite you saying that you're tired, you had no difficulty making objections, objecting, and once again asking for an. I need to go in this hearing, and that's what we're going to do. I would like the state to confirm on the record whether you've had an opportunity to have the motion served on Mr. Brooks.
Yes, Detective Regland personally served it on him about 10 or 12 minutes ago, Your Honor. Also at the same time served him with a copy of the state's exhibit list, which I believe we will be addressing at later this hearing.
Right. As to the motion, I would like to give him an opportunity to review that. It is a motion for reconsideration. And so I'm not going to address that today. I'll have to address that tomorrow morning. Thank you. Why don't we start with one of the latter things that you indicated, and that's the criminal records for state's witnesses. How many witnesses would this issue relate to? One. All right. And would you have a copy of that record, or I don't know how do you provide that to the defendant? How would you like to provide that to him, at least the information?
Well, I'm prepared to make an oral statement today, and then I have a CCAP entry that I would choose to provide to Mr. Brooks to verify what I'm saying.
Okay, go ahead.
Your Honor, this relates to one of the state's potential witnesses who's identified as the father of victims, who's expected to testify. He has one prior misdemeanor conviction from 2005 for a crime of entry into a locked building. I would note that it's the request of the state that, although he does have this one prior on his record, the court make a finding that it's not relevant or probative, in that he was 21 years of age at the time it occurred. It occurred 17 years ago, and there's been no further events or criminal wrongdoing in the meantime. I don't think it is probative of his truthfulness. It was not a crime of truthfulness. And we would ask that, although that record does exist, that he cannot be asked about it when he testifies. He is the only citizen witness that has any appropriate criminal record to discuss.
Again, you said it was 17 years ago, but how old was this individual at the time?
21 years of age.
You have a statute handy.
906. So 9, Your Honor.
It will unsubscribe me, but it won't take away your.
So I'm going to take this request under advisement. I'm going to advise Mr. Brooks that the relevant statute is
I don't think it'll take away your green.
906.09, impeachment by evidence of conviction of crime or adjudication of delinquency.
But why would you do that,
I have
Marty?
provided him with that selected
do that.
statutes book. So he can review this if he so chooses, and then at the appropriate
I don't
time,
want you to go. Why
I
would
can
you go?
readdress this.
You love me.
I'll remind you before this person testifies, Your Honor,
We
if not
love
before.
you.
but-
Right, I think that would be the best way to do this. Just maybe give us, if you can, a day or two notice so that he can, meaning Mr. Brooks can look at the statute again if he so chooses. So what I'm telling you, Mr. Brooks, is that I'm not going to address this request today. The state's put this information on the record. I'll require them to provide the CCAP information that they have regarding this individual. That individual would be on the witness list.
So that's a real thing.
Are
You can't
they,
get
is this
shorter?
person indicated in any way on the witness list as the father of so-and-so, or would it be?
No, but when he gets a CCAP entry, he'll see the name.
That's true.
Yeah.
All right, thank you. So that's how you'll get that information, and then I'll address whether
Good, Marty, don't.
that impeachment evidence is relevant and probative at a later point in time, but at least you're put on notice of the request.
That is a real thing. I thought that was a joke.
And again, I'm not going to
You
address
can
the
really
motion
get
for
shorter?
reconsideration because you were just served with a copy
I
of
don't wanna
that.
get
I will
shorter.
take that up tomorrow morning.
I'm already too short.
The defendant should testify. We would want to discuss his prior convictions as well. We don't have to do that right now, but I at least wanted to discuss about the state's witnesses, Your Honor.
I don't
Sure,
want to.
if you wanted to provide a little bit of information, again, he's been given the statute, he could review that. Do you have a total number of convictions for Mr. Brooks, and the number that you would ask be the number he answered the question to? Should he testify, have you been convicted of a crime, and if so, how many?
Yes, Your Honor, we believe the answer would be 12, with the first 3 coming from the state of Nevada, and then the remaining convictions all in the state of Wisconsin, mostly from
You're
Milwaukee County, but
already
also 1
subscribed,
conviction from
Marty.
Wood County and 1 conviction from Manitowoc County. And we would certainly provide Mr. Brooks with either a criminal history or CCAP printouts, whichever he would like, to support these convictions, except for the Nevada. That would be on his criminal history. We can provide him a CIDR.
All right, so, Mr. Brooks, I'm not going to address this today. The state's putting you on notice that if you elect to testify in this case, they will be seeking a ruling on whether you may be asked, have you been convicted of a crime? And then the follow-up, if that answer is yes, is how many times? And that number is really up to judicial determination under the statute and relevant case law. Again, not going to take it up here today, but you're put on notice, and the state will provide some information to you to substantiate the convictions. I'm going to unmute. Do you have any question about the use of criminal records for witnesses and impeachment, at least the mechanism for which to address those as I've outlined here today?
I think once I'm able to review things, I will have a better understanding. At this point, I don't.
That's okay. Understood.
I do want to just say one thing.
You don't know how many times you've been convicted of a crime?
And
that's something you should know?
I did inform the bailiffs that I did not wish to accept the paperwork that was brought up by the detective.
Well, don't hit the
I don't know his
dislike
name,
button
so
on
I
me,
don't want to be
Marty.
disrespectful.
Because you like me,
The
right?
information I have is Detective Ragland did
must.
personally
You're
serve
here
you
every
with
day.
that. He'll file the appropriate service if need be. Whether you take that paperwork with you or not back to your cell is your decision, sir.
Well, I just wanted to put that on record that I'm not accepting the paperwork.
Your objection to the paperwork is noted. All right, that might be a good point to talk about objections during trial. It's a good segue. We talked a little bit about that during the testimony today of the jail administrator. Sir, once again, I direct you to the rules of evidence. I actually have a large binder that I utilize
Hit the
as
little
judge
heart.
on the rules of evidence.
That's an interaction,
There
too.
are many rules as it relates to the admissibility of evidence, foundation, authenticity, et cetera, and other things. Typically during a trial, because I'd like to minimize the information that's before a jury, is I ask parties to, if they have an objection, objections, generally speaking, go to testimony or evidence. So for example, if a question is asked that you think calls for inadmissible evidence, You let the attorney asking the question fully ask it. You say objection. If it's a relevance objection, I'd like you to say relevance. If it's a hearsay objection, say hearsay. I don't mind a sentence or two, but what I try to avoid is a full legal discussion in front of the jury. If I feel it's appropriate once the objection is made, I'll either sustain it, overrule it, or I might say to the other party, so if you're making the objection, I would say to the state, any response? They might say something like, let's say you make a hearsay objection. Your Honor, it's not hearsay, it's not being offered for the truth of the matter asserted. That triggers to me, I understand what I need to decide at that moment, and I might say sustained, or I might say overruled. The witness may answer. The jury's instructed that the information or the testimony provided not being offered for. If it's a complicated issue, sometimes the state will tell me and ask me, Judge, may we have a sidebar? We don't really have sidebars in a situation like this where you're in custody, but using that phrase is still acceptable because then it prompts me to have the jury excused, so then I can have a more full discussion with the parties, hear their legal arguments and reasoning. Sometimes it requires an offer of proof. And so what I'm advising you is, because the state proof, they're going to go first, they're going to present witness. If during testimony you believe certain testimony is not admissible under the rules of evidence, you can certainly object. I'll rule on that objection. I ask that you wait till I rule on it. But once I've made my ruling, it's either going to be the witness will be allowed to testify or the witness will not. So whether you're the one making the objection or the state's making the objection for something your witness might say, I expect that you will honor the ruling and then either move on to the next question as the case may be, or, for example, if I've overruled an objection of yours, to allow that an objection was made, and that will be there for appellate purposes later on. If we get to a point in time in the proceedings where you have been removed and you are appearing from the other room and you are not able to follow this procedure, I will warn you now that I may mute and probably will mute in those circumstances. You have been given the objection sign. You can raise it. I will unmute and say the basis for the objection, sir. You'll state it. I'll mute you again. I'll rule on it, and then we'll go on. If at any time, though, that even that secondary process is very disruptive, then I will require you to write down all of your objections. And then let me rephrase that. I'll require you to write them down. If that means I have to wait for the sheet of paper to come over, I will. But at some point, sir, I'm going to keep this trial and the testimony going. I would direct your attention to 906.11, so 906.11, which concerns the order and mode of interrogation. The judge maintains the ultimate control over that. And if you intend, or if at any point in time you just simply object to every question, that is not going to be acceptable. Because also under 906.11, you can't harass a witness that way. So I want to make that clear. Attorney Opper, is that a procedure? Does that answer your questions about the procedures for objecting?
Yes, that answers our question as to objections. I did have another question about, in the event Mr. Brooks has forfeited his right to be present in the courtroom and has been removed, how will cross-examination proceed?
Well, I've reviewed the case law, and one of the possibilities is that he forfeit his right to cross-examine. If he's not in this courtroom, it can be challenging to facilitate cross-exam. And if he's able to abide by the rules of decorum and civility, and whether it be even objections, right, or cross-exam, I mean, that can be shut down, for lack of a better way of saying it.
I understand that, and I know this court has been more than patient. We would just ask the court for its continued patience. We want Mr. Brooks to be able to confront and cross-examine his accusers. He has demonstrated on the 2 occasions so far that we've had testimony, he's quite efficient at asking questions, and so if he is calm and cooperating and not rude and disrespectful, we believe he should be given the opportunity after every witness to cross-examine. Even if he's in the other courtroom, we should at least make that inquiry, unless it becomes absolutely not an option because of his conduct.
I would agree.
So just so I understand, 'cause I don't, how can I forfeit my right to actively and effectively participate in a trial if I have to constantly be put in a separate location? How will I be able to see everything that is going on in the courtroom? How will I be able to effectively put on a proper defense?
Mr. Brooks, I direct your attention to Illinois versus Allen. That's the case that I've been relying upon regarding your removal. That's found at 90 Supreme Court 1057 from 1970.
Just so I understand, the Supreme Court, the federal court,
That is the Supreme Court of the United States of America.
is that federal?
That is the Supreme Court of the United States of America, sir.
I'm just really seeking to understand, Your Honor.
Sir, that is the Supreme. Sir, I've answered the question.
You have, but I still don't understand. That's why I'm asking the question. I'm not disputing it.
Sir, I'm not going to explain the law to you. I cannot do that.
I'm not asking you to. I'm asking, is that a federal court?
All right, I'm going to move on to the next topic. Related to objections would also be to the admission of evidence. Of course, my standard practice when a party offers an exhibit is to say any objection. And so if there is an objection, of course, there needs to be a legal basis. And then once I rule on that objection, then I expect that decision to be respected and honored, and the testimony and presentation of evidence continue forward.
So, Your Honor, I still don't understand. How am I expected to do everything in a legal basis and legal manner and everything when I keep informing you, Your Honor, on record in open court that I did not understand, that I still have yet to understand the true nature and cause of the charges against me, which I don't understand. There's so many things that I do not understand that I keep explaining to you, Your Honor, that
Mr. Brooks, I'm going to refer you back to document number 244, which is the waiver of right to attorney form that you willingly, knowingly, intelligently, from my perspective, understandingly filled out. Let me make my ruling, sir. Do not interrupt, or you will be muted. All right? So from my perspective, sir, we clearly went through not only this form, but really the topics that are referenced in this form. The advantages of having an attorney represent you, the disadvantages of representing yourself. I discussed with you and advised you regarding all of the charges that you face, the penalties that you face, the exposure that you face. I advised you regarding what an attorney would do. I further advised you about the disadvantages of representing yourself. I asked you such questions about whether anyone, forced you or coerced you to waive your right to an attorney. I asked you if anyone had made any promises to you to waive your right to an attorney. I made a finding, sir, that you freely, voluntarily, intelligently made a deliberate decision to waive your right to counsel and to represent yourself. I refer you to that document, sir, because once again, I cannot give you legal advice. I cannot explain court procedures or the law. And you represent yourself at your own peril. I honored your request to represent yourself, and it's a bit disingenuous to now say you don't understand what you did. So we're going to keep going. I need to go through some other topics. You are not muted, but there's nothing for us to discuss at the moment.
I'm not trying to discuss anything. I was just letting you make the record, which I haven't been afforded the opportunity to make the record when I offered for my appeal. Again, I do not understand, and Your Honor, I think it's very unfair for you to to say that you're finding that I understand you, how can you tell me what I understand and what I don't understand? I've clearly made that very, very clear that I don't understand. And the same document that you referred to that I filled out specifically crossed out the word understand. Why did I do it like that? Because I do
All right,
not
Mr. Brooks,
understand.
I'm gonna mute you because we're off topic. We've gone over this time and time again. I understand the objection that you're raising. You, once again, are claiming that you do not understand. I make findings in this courtroom based upon the available information, the law, and my decision is all in the record for which you can appeal at a later point in time. But we are going to continue whether you claim to not understand. All right, so
He knows
I
exactly
need
what
to
he's
add
doing.
one instruction
He
to the preliminary jury
understands
instructions.
everything.
Have we provided Mr. Brooks with his another copy yet?
Not another copy, just the one from last night.
So the one from last night, my understanding is he left in his cell.
All of this is stalling. He's stalling.
So you can print off what we have thus far for him, Madam Clerk. And I'm going to just make a modification and print off a separate instruction that I have crafted regarding decorum and courtesy in the courtroom. Oh, our bailiff has, that was with the witness list?
No, I did that earlier, but I was printing a bunch of things.
So put on the record, Madam Clerk, what you believe you provided to Mr. Brooks already. All right, so he was provided with the packet of preliminary jury instructions. So let me I just need to add a line in here. I'll print this here for the state, and I'll print it in the other courtroom. There's a printer over there as soon as I do that.
You mean just this one?
Just this one, yeah.
Okay.
What are they doing now?
Off the table and set it on the floor next to him.
Brooks, for now, I sure can. All right, a copy of this should be on the printer in the other courtroom. And then I'm providing a copy to give to the state. You sure can.
Oh.
I'm going to unmute Mr. Brooks for now. I was not looking at the monitor because I was sending the email to my clerk with that document, but I'd just like to get confirmation at least it was put in front of him on the table. Whether he accepts it or not, I understand, but Mr. Brooks, was that piece of paper placed in front of you?
I don't accept or consent to any paperwork.
Judge, I did see on the monitor the bailiff set some paperwork on the table in front of Mr. Brooks, and he took it off the table and set it on the floor next to him, it appeared.
All right, thank you for making that.
Accept or consent to that. I will
Mr.
not
Brooks.
accept any more paperwork.
All right,
period.
Mr. Brooks, you made clear you're not going to accept paperwork, but we have an obligation, whether you make that statement or not, to provide you with copies of everything the court is addressing with the parties.
So what you do with them is up to you. So your objection
Is noted.
That certain things are not going to be awarded, especially when it comes to fairness.
Mr. Brooks, I need to move on to the jury instructions. Are you willing to participate in this process right now?
No, I am not, and I don't give consent
without me being present in the courtroom, like I said before I was brought over here.
Would you like to come back over?
So why would you ask me now? Why would you ask me now?
Mr. Brooks, you were put over in that courtroom because of your disruptive behavior.
I
If you
wasn't
can
being
agree to
disruptive.
abide by the rules of decorum and courtesy,
I'm not gonna
then
agree to
I will
anything.
bring you back over here at any point in time.
I'm
Did
not
you
gonna
hear
agree
me
to
advise
anything.
you of that, sir?
No, I did not.
You're advised, sir, that if you want to come back to this courtroom, you may make a request at any point in time. If you come back, the court expects you to follow the rules of decorum and courtesy that you've previously been advised about.
So this is how it's gonna be the whole trial, every time I seek to understand
Mr. Brooks, I'm
something, ask
offering
a
you the
question.
opportunity to come back to this courtroom
I
to
just
participate
wanna know,
here.
I don't wanna go over there and then essentially have to come back right over, being looked at as me intentionally trying to disrupt the court.
Mr. Brooks, I'm asking you a question. Please
I asked
answer.
you a question. I
Would
asked you a
you,
question as well, Your Honor.
would you like to
I
come
asked you a
back to
question
the
as well.
main courtroom right now? Yes or no?
I asked you a question too, Your Honor. I asked.
All right,
is
I'm
this
going
gonna
to
be
mute
how it's
him.
gonna go?
I'm going to make a finding that his decision to not answer the court with a yes or no is non-responsive. I repeatedly asked him if he would like to come back to this courtroom. He did not answer yes. Instead, he wants to debate with me about his understanding or lack thereof, and rather than discuss the topics at hand. I find that behavior to be rude, to be disrespectful. I find it to interfere with the orderly administration of justice. I want to continue with the preliminary jury instructions. Of course, it is always my preference to have Mr. Brooks in this courtroom, but as he has been advised repeatedly, in order for him to maintain his appearance in this courtroom, he needs to abide by even the most simplest of rules, and that is to not interrupt.
And you can't do that.
I will not tolerate disruptive conduct
Cannot do that.
that, from my perspective, is simply this court. All right, so I have a packet of jury instructions, and if I didn't state it, obviously the record should reflect I have muted Mr. Brooks, and he'll remain that way until he sends me a note indicating he'd like to be unmuted and that he will comply with the rules of civility and decorum. All right, so I've provided the parties with a packet of instructions. There are 68 pages. Attorney Opper, will you or Attorney Basie be addressing the preliminary jury instructions?
I will, Your Honor.
All right, do you acknowledge receipt of those? All right, I will put on the record that these 68 pages were also provided to Mr. Brooks earlier today, I believe, at the start of the hearing. And then he was also provided with the single-page proposed instruction regarding decorum and civility that the court has drafted. Has the state seen that as well?
We have.
The only thing I'm noting at the moment on page 1, Madam Clerk, is a footnote that needs to be taken out. Then, does the state have any corrections, edits, or suggestions at this time?
Your Honor, we do not. We did have a typo with regard to the name of one of the victims. I did email your clerk. I believe it has been corrected, but if not, it would be regarding, it was on page 28 of 69, specifically count 65. And the first name of the victim was, there was an S that needed to be removed.
Did you say count 65?
Correct.
There's an S in the first name that needs to be removed? All right, I must have the old copy, but I'll make a note of that.
I had to do a save as.
Okay. Anything else? My thought on the instruction that I provided to the parties, there is instruction 70, which I have an old copy, so I'm gonna just, can you email me the most recent copy, Teresa, so I'm on the same page, literally and figuratively with everyone?
Would you rather I showed it or?
Sure. Mr. Brooks is raising his objection sign. If he has an objection, he needs to write that out and provide that to the bailiff so that I can then take it up. So, no, it would be a far ahead. 70 should be right after 59, police reports.
We're at 69.
It's all the way up, 70. All right, so as the parties can see on the monitor, 70 is the instruction that is entitled in the drafts that are provided by the standard or pattern jury instructions. Preliminary instruction, defendant proceeding pro se. Now, I would note, none of these headings are read during the advisement to the jurors. It's really so we can keep an orderly list of the instructions. So my practice is to simply read, starting with the substantive. So that is the pattern instruction. It's been modified to make sure it says himself versus herself, and the name of, actually just says defendant, there is no name. And my suggestion and what I intend to do is to, right after where it says in any manner, is to start a new paragraph. So just underneath that, whether it has a heading or not, I don't think is relevant at this point in time, but to read the following. This court is tasked with ensuring the orderly administration of the case. My job includes making sure that Mr. Brooks's rights are protected, making sure that the state and the defendant can present their respective cases in a coherent and orderly fashion, and that victims, witnesses, and the public are appropriately treated in the courtroom. All parties in the courtroom, including the attorneys, the litigants, witnesses, the judge, the jurors, and those in attendance, are expected to conduct themselves appropriately and avoid creating disorder or disruption, as well as conduct themselves in a manner that demonstrates sensitivity to the necessity of preserving decorum and the integrity of the judicial process. I would not read the SCR unless there's a request to do so. That is there just for reference. That's where I pulled that from. There's a second part to the proposal that if at the time the court reads the preliminary jury instructions, Mr. Brooks is not in the courtroom, then to add the second where it says to be read only, that says at the moment Mr. Brooks is appearing from another courtroom, this must not influence your verdict in any manner. I understand Mr. Brooks is objecting. I'll give him an opportunity to make any statements regarding that. On the record, I'll ask the state first whether there's any objection to inserting this in that location.
No objection to it. Inserting that, I would just note that in all of the jury instructions, I don't think we've ever mentioned Mr. Brooks by name. I think it's always been the defendant. I don't know if the court wants to be consistent. That was my only comment.
I think it would be good to be consistent. If I read this at all at other points in time, I will use his name that I have listed on this proposal.
He knows what he's objecting to.
All right,
He just
Mr. Brooks, I'm
wants
going to
delay
unmute you
it.
so that you can
It's
put the
all
basis
delay
for your
tactics.
objection on the record.
Yeah, first of all, I'd like to state for the record that I'm pro party, not pro se. And what you just said about keeping it consistent, then it's been in this form ever since it was brought up. So why start to change the language and logistics of it now at this point to constitute me being in a separate location? If it's gonna be consistent, then it should be consistently as it was constructed. Nothing should be changed.
Sir, do you have, want to make any statement related to the jury instructions
That
that I've
doesn't even-
provided
don't
to
even
you,
know
whether
what
you
she
object,
meant then, 'cause
consent,
you're
agree,
not
or
making
otherwise?
sense, and she did.
No, I don't consent. I do not.
All right, your lack of, sorry, go
I
ahead.
just stated the reasons why.
Is that to
You
the
just
whole?
said so yourself, you just said so yourself, there need to be consistent. So why does anything need to be changed at this point?
Because it's not consistent.
As to the entire packet that was provided to you, noting I've made this change, I will,
didn't
hold on,
expect anything
hold
that
on,
was.
hold on. I will advise you that as to the added paragraph, I will make it consistent with the verbiage and the pattern instructions and refer to him as the defendant. However, if I have to read this instruction at other points in time, I will be reading it with the verbiage of Mr. Brooks. I do that frankly out of respect for him. But the pattern jury instructions are constructed in such a way that I'm going to follow that pattern when reading instructions, with the exception that I've just noted, and that is if I am in a position where I feel it important to advise the jury, whether it's just simply that he's in another location or another courtroom, this must not influence your verdict in any way, or if I feel it important to read the entire thing. I'll take out the reference to SCR 62.02 sub 1 sub F and H. That was really just so the parties understood where I obtained that language from.
What's being changed, or is it, I don't understand,
I changed where it said Mr. Brooks to the defendant. And that, I think, was in two,
Is it in the court?
He has no idea what he's doing.
yes, so right there.
None whatsoever.
We're in the process of changing it, sir. My clerk is typing as we go along.
And I also want to make
Small d.
state this on the record. You just referenced wanting to protect my rights, correct?
You have the language in front of you, sir.
Well, you just said on record that you will want to preserve my rights.
Mr. Brooks, you have the language of the jury instruction immediately on the screen in front of you. Do you have a question or a position on whether that's included?
I was getting to that. You did not let me finish. So it's not a question. Like I said, I was stating for the record. Part of protecting my rights would be the ability for me to inform the jury of the truth, their rights, and their duties under the First and Sixth Amendment.
Do you have a jury instruction that you would like me to read that would state that? Have you drafted anything, sir?
I wouldn't need to draft anything if it's already in the Constitution. I should be able
You would.
to be afforded for those rights to be protected under the First and Sixth Amendment.
I'm sorry, I mistook what you were saying. I thought you wanted me to add a jury instruction, a written jury instruction, so that I would read something to the jurors. Am I mistaken on that?
I'm not gonna consent to any questioning about that. I think it was very clear what I was asking, because I'm referring to you saying that you would like to preserve my rights. And part of my rights being preserved is to be able to inform the jury of the truth, their rights, and their duties under the First and Sixth Amendment.
So, as I understand what you're saying, sir, I think what you're asking this court is to add an instruction, because the jurors get informed. Hold on, let me finish. The jurors are informed of the law through jury instructions. These are the pattern jury instructions, with the exception of what I've just added to number 70, which I feel is appropriate in this case. If there's something additional, then tell me what it is, and do you have a draft to provide to the court for consideration?
Well, how about this? Since it's clear that you're not grasping quite what I mean by what I'm saying, how about I draft something up and get it to you as soon as possible? Would that be sufficient for your honor?
If you draft something and submit it, and we have it by tomorrow morning, I can address that on the record, and whether it will be included or not. So yes, that's acceptable. The
Record also, may I state, it is going to change the pro part.
That's not read to the
It means the
jury.
same
It's just part of the
thing.
labeling.
It means
But it is my
the
pattern,
same thing.
but it is the pattern jury instruction. That is a phrase that has meaning in Wisconsin law. It is accurate, and so your request to change it to pro per is denied.
Okay, how is that accurate?
That's my ruling, sir.
I don't understand, so I'm just seeking.
Mr. Brooks, that's my ruling. I need to finalize these, Mr. Brooks, I need to finalize these instructions. So my question to you is, oops, you can take that up.
Suggestion.
Okay.
On the second.
Hold on, Mr. Brooks, what I want to tell you is, I'm going to finalize these. The state has a suggestion for verbiage within an instruction that's already in there that I'm going to address. I'm then going to ask you whether you have any other edits or requests as it relates to them, and then ultimately ask you whether you approve of these or not. I just want you to be advised of that. So go ahead, Attorney Basie.
Thank you. On the additional language that the court is adding to jury instruction 70, I would just state on that second sentence, my job includes making sure the defendant's rights are protected. So I think that should be the.
Right there.
Yep. Or I could just read the defendant's rights, whatever.
There goes the objection sign again. Every time.
Since nobody's saying anything, part of my rights being protected would be to be able to conduct my defense pro per, free from professional restrictions imposed upon licensed attorneys. That's another right that's not being protected.
If you're requesting that language be included, the request is denied.
And is that a judicial determination that I won't have?
I do not believe that accurately
have that
states.
right preserved?
I do not believe that statement accurately reflects the law. All right, so we'll make Mr. Brooks, I'm moving on.
And you show me by.
Mr. Brooks, I'm going to mute you. I'm not required to show you verification of law. Again, I direct you to the waiver of right to attorney form, a copy of which has previously been provided to you about what this court can and cannot do. That's a very good summary. If you have any other questions about what the court can and cannot do, I also direct your attention to the Supreme Court rules. My understanding is you have access to legal materials, and there are a number of rules that apply. The Code of Judicial Conduct is SCR Chapter 60. All right, we've made that change. With that change, does the state approve of the jury instructions?
Yes.
All right, Mr. Brooks, I'm going to ask you that question. Actually, two, do you have any, and you're raising the objection. Hold on, you're raising the objection, sign. It's noted for the record.
I'm gonna continue doing it, that's the only thing I can.
No, I know, and I'm making a record of it, sir. But we're at the point in time, do you have any requests for edits? Let me finish the question, sir. You're interrupting. All right, I'm gonna have to mute him again so that I can get my question out. Mr. Brooks, my question to you, do you have any other requests as it relates to edits, other instructions, or corrections of the 69-page instructions that you were provided with? And the
ones you put on the floor.
added instruction that you were able to see on the screen. Go ahead, you are unmuted.
I wasn't looking at anything on the screen, and I already made clear on the record, and you just confirmed on the record that I would be able to draft something that would get it to you. So why can't I address anything in that draft?
Sir, I am addressing what we have now. So I will ask you now at this point, since you've not answered my question, I understand that you're going to draft something. Other than that, do you have any other edits, corrections, or requests for inclusion at this time related to these jury instructions?
Yeah, you still haven't answered if I'll be able to inform the jury of the truth, their rights, and their duties.
Sir, I have provided an answer to that. All right, I'm going to object. I'm going to not object. I'm going to mute him again. I have told you you will have the opportunity to draft a proposed jury instruction for inclusion with this packet. At this point, he hasn't answered my question directly, and by his responses, I will make a finding that he's not responding. It's a non-response type of answer, and because I've advised him as to what I intend to do, I am going to approve the jury instruction packet that has been provided to the parties and modified on the record.
Your Honor, I do have one other change I just noticed.
Go ahead.
That's with regard to the bail jumping jury instruction. And I know we had talked about this verbiage before, about the theory of that charge. The theory of that charge is that the defendant committed a crime. It was our belief that they did not have to be unanimous on the crime that was committed. As I look at the jury instruction, and it's talking about the third element, it says the state must prove by evidence, and I'm on page, 66 of 69. Your paging may be a little different because I think you have the added verbiage. Elements of the crime that the state must prove.
The number one is to each count. That one?
No, it'd be, if you go down to the third one and the paragraphs that follow.
Right.
Number 3, so the last paragraph before deciding about intent and knowledge, it indicates the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant committed the crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, hit and run resulting in death, and battery. The crimes, and then it lists those same crimes have been defined for you and should apply the same definitions here. I would just indicate, I believe it should read hit and run resulting in death or battery. I believe that they do not need to be unanimous on the crime that they select, but they do have to be unanimous that he committed a crime.
Any case law or other support for that position?
No, Your Honor, I know that's, the court had addressed the hit and run, that they don't have to agree on which ones they violated, and that would be the analogy I would make. I know we had talked about that previously. I mean, the what we could have done, it's to Mr. Brooks's benefits, that we did it this way, because it's only 2 counts of bail jumping versus doing 1 count of bail jumping for each crime that he is alleged to have committed. We put them together, I guess, to the benefits, and he may not see it that way, but to his benefits.
Why would you do anything to his benefit after what he did? That's insane.
Mr. Brooks, the state is specifically asking that I change the word "and" to "or" under the 3rd element of bail jumping based upon their theory of this case and the bail jumpings and their belief that the jurors do not need to be unanimous as it relates to which crime was committed. And they're asking that I insert the word "or" as indicated. Do you have any position as to that?
Yes, I do. And I'm gonna base my position off of what you just said, that there is no case law to support why it should be changed. I believe that it should be whatever it is right now, that the word "or," whatever, should not be omitted. It should be how it is right now, as apparently it was intended to be that way all the way up until this point, so why change it now? Let's just leave it alone and leave it where it is.
Well, actually, sir, the pattern jury instruction was modified because of the charges in this case based upon the state's proposed jury instructions that were previously filed. The pattern jury instruction basically deals with a single criminal law violation. That's not the theory of the case for the state here in this case as it relates to the bail jumping counts. So I just want to be made clear that it's not a change that they're asking to the pattern instruction in terms of what would have been there previously, because it already was modified based upon their theory in this case. To say it another way, the pattern jury instruction didn't contemplate, and they're just that, they're pattern jury instructions. Oftentimes the courts have to modify based upon the particular nature of a case. My question to the state, and then will be to Mr. Brooks, is if I adopt the request from the state, do I need to put in a similar statement like what is in the hit and run about you don't need to be unanimous as to which crime he committed, but you need to be unanimous that he committed a crime?
I think that would be helpful to them. I think the paragraph before the one I just recited says the defendant is charged with violating a condition of bond that required that he not commit any crime. So I think that verbiage would be consistent with that first sentence.
Any position on that, Mr. Brooks? Or the, sorry, go ahead, any position on that?
Yeah, I don't agree with why should it matter about a unanimous or not being unanimous if
He
that was always
understands
the case
nothing.
in the beginning, then it should have been changed at the beginning, not at this point where everything is so close to being decided.
He just wants to
I don't
go
understand why
against
it needs to be
anything
changed
the
anyway, why it needs
prosecution
to be altered
says.
anyway. I think if it was going to be that they have to be unanimous, then let it be unanimous. Let it be unanimous for everything.
All right, I agree with the state's position. I think that's the most appropriate under the law, given the violation of bail jumping. It can be a variety of different ways, but in this particular case, the state's relying upon that statutory subsection for violating any crime. So in element number 3, it needs to say the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant committed the crime of first-degree intentional homicide, use of a dangerous weapon, first-degree reckless endangering safety, use of a dangerous weapon, hit and run resulting in death or battery. And so that I actually took out, where it says crimes, I took out the S as well. I think that you would need to do that, or I would need to do that in order to be consistent with the or. So I'll make that change, and then
Can I make the suggestion that at least, that at the minimum, it would say alleged crime, as I have not been convicted of anything?
I understand what you're saying, but these are the jury instructions that tell the jury what the elements of the offense are. It's very clear when you look at the jury instructions in their totality, that elements, that the state bears the burden of proof. There's other parts of these that talk about an information, that these are that can't be used against you. I
These are
believe
the
your
forms
concern is
where they
adequately
say
addressed when
you're
you read the jury
guilty.
instructions as a whole.
May I ask Your Honor, if there's anything that I can look up myself that would help me better understand this?
You
I can't answer that for you,
shoulda
sir. I can't explain the law to you.
Fired your
I know at
lawyers,
times I've
maybe?
provided you with resources. I mean, what I have available, but I have no idea if you would have access to because it's through a publication, I believe through the state bar, are the jury instructions. I'm not even sure if what I have, to be honest, I know I get them through the Director of State Courts office. I have them available electronically, and the Jury Instruction Committee, which is, let me take that back. It's through the law school because of the Jury Instruction Committee. And it's a publication. I'll be honest, I don't even know how the public gets access to them because of how I get my access. It's just something that the Director of State Courts office provides to me through my judicial dashboard. And so, but what I wanted to say is those jury instructions come with comments. There's also special materials. I don't know how you access those outside of the way I do. It's been over 10 and a half years since I've practiced law. And the whole electronic access to these types of things have changed. So I'm just not able to answer that, sir.
And Your Honor, I think I can provide some clarification. I believe that they are accessible through list law, and the defendant would have access to that on his tablet.
Oh, thank you.
I'm sorry, on the computer in the conference room.
All right. You'll want to probably check the computer out to see if that's true, but the state has information to suggest that you would have access through WIS law to the jury instructions. The packet that I'm giving you has all of the numbers on them, so that should help you in your research of them.
So I think what the most glaring part to me of my misunderstanding is the unanimous thing. I think that's what I'm really attempting to wrap my head around at this point.
Right. I'm trying to find the language in the hit and run about the duty that I would point you to.
Is that acceptable to you, Your Honor? That's from,
61 of 69, under number 3.
Oh, right, I found it. So I'm just going to point you to, under the jury instruction for duty upon striking a person, which is instruction 2670, under element 3, there's a portion of that that says, the state is required to satisfy you beyond a reasonable doubt that the defendant violated at least one of the two duties, but you are not required to agree as to which duty was violated. The proposed language that I would have is that the state is required to satisfy you beyond a reasonable doubt that the defendant committed a crime, but you are not required to agree as to which crime was committed. And I would put that's we're talking about the bail jumping jury instruction. It's also element 3. Right after where we says that all of these crimes have been defined for you and you should apply the definitions here, I think it would make sense at that point to say the language I just proffered, which is the state is required to satisfy you beyond a reasonable. Actually, let me take that back. I'm looking further up where we're closer to the number 3. So it's my page 65. I don't know if it's 65 or 66 or 64 in yours, but where it starts with the defendant is charged with violating a condition of bond that required that he not commit any crime. And then it has a paragraph, and then there's another paragraph that starts, the state must prove by evidence would satisfy you beyond a reasonable doubt. It's before I say the crimes of have been defined, that's where I think it should be inserted. And so, Madam Clerk, where we made the change where it says or battery,
Yes.
then we'll include the following language. The state,
Before or after period.
after, it'll be its own sentence. The state is required to satisfy you beyond a reasonable doubt that the defendant committed a crime, but you are not required to agree as to which crime was committed. Mr. Brooks, when we get done here today, I think it's fair, since we've been here quite long, I don't intend to have a very lengthy discussion tomorrow, but I'll print all of these off for you so you can review them tonight. That'll also give you an opportunity to look at some of these topics. As well as if you want to draft your own instruction on some law. And then first thing tomorrow morning, we'll have a very brief discussion. It's only on these added language, not the whole packet. The other parts of the packet have been approved by this court. But that'll give you an opportunity to further look at it. And Madam Clerk's going to read it back to me to make sure it says what I want it to say. So go ahead.
So after hit and run resulting in death or battery, the state is required to satisfy beyond a reasonable doubt that the defendant committed a crime.
Hold on, you're going to need to slow down a little bit. And I think there's already a word missing. Let me just get to that. Okay, go ahead and start over.
Wait, I was just informed they couldn't hear me in the other room, so I'll speak up a little bit. After resulting in death or battery, the state is required to satisfy you beyond a reasonable doubt that the defendant committed a crime, but you do not need to agree on which one.
But you are not required to agree as to which crime was committed. And then the language will continue. The crimes of, all of them will be listed, have been defined for you. The remaining part of the instruction remains. Again, I'll give this to the parties. It's been another long afternoon. It can be a little hard to follow these things, even when they're in front of you, as you can see. There are 68 pages of instructions. I think it's reasonable to have these all printed off and give Mr. Brooks and the state one more opportunity to review them for final consideration first thing in the morning.
Just so I understand for the record, the jury instructions that you have are the ones that we're gonna use. I can't make a few of my own.
You can still, if you want to draft something, you have to submit it so that we can consider it, but it has to be in writing. And keep in mind, sir, jury instructions are read by the court, and they're statements of the law that I give to the jury so that they better understand their functions as a juror and the law that applies to this case. But you have until tomorrow morning to bring that to court in written form. If it's accepted by the court, my clerk will type it up and we'll insert it in the appropriate spot. If it's not accepted, then it won't be included. But as to what we specifically have before us today, not including the language that I just changed, so everything but the bail jumping, element 3, do you have any objection? Okay? You have to give me a legal reason, sir, or are you just stating an objection that you don't consent, which I'll note for the record if that's the case.
Well, it's still the same that I said before.
Okay.
At this point, I don't see why. I guess essentially what I'm saying is if the issue was never raised before, and there's been ample time, at least for the prosecution, to review the questionnaires, or not the questionnaire, I'm sorry, the jury instructions. What prompted the change now, all of a sudden?
Because this is the time in the proceedings for the court to finalize those and to address any modifications. That's standard protocol.
So I'm still.
All right, your objection is noted, sir. I am approving everything that's in there. The parties will still have an opportunity to look at the change to the jury instruction on bail jumping. Mr. Brooks will still have an opportunity to submit any additional proposed instructions tomorrow morning, but at least we have this packet that's been approved, again, with the one exception on the bail jumping charge under element 3.
It has to be in writing, just so I understand everything's in writing.
It does have to be in writing, sir. That is a requirement.
So would that be in the form of a motion or just a simple writing? I don't understand.
Sir, you can simply submit a proposed jury instruction, okay? But it does need to be in writing because that's how I will need to review it.
Yeah, I follow that part. I'm just, like I said, I'm just trying to understand what that it needs to be written up as a motion or just a simple writing.
It can be a simple writing. You don't have to put a motion. I'm allowing you to submit a proposed jury instruction or instructions, I guess, if that's your choice. I don't know what you have in mind, but you can submit those tomorrow.
Yeah, I don't have any, I just wanted simple clarification. That was all.
I appreciate you seeking that.
She answered it. Shut up.
All right. As to my list, other than the motion for reconsideration, did I overlook anything?
I don't know if you want to discuss exhibits, Your Honor, and I did want to say for the record, we did file what we have currently is 8 pages of exhibits, numbered 1 through 140. It's a combination of videos, photographs, and documents. I did have that 8-page list hand-delivered to Mr. Brooks earlier by Detective Reglin. That's one of the documents that he's stated he will decline to accept. However, It's an important document and one that he would be well-served to read. In addition to that, Your Honor, we've had all 140 of our exhibits saved to a thumb drive, and Detective Reglin hand-delivered that to Jail Administrator Wohlenhoff this afternoon, so that if Mr. Brooks wants to look at our exhibits tonight, he can do so. He just has to ask the correctional officers for that thumb drive with the exhibits on it, and he can see all 140 exhibits that we've prepared so far, and have a location of some of the evidence that will be presented against him during the trial. I do have a question, Your Honor. I understand from the quarter about you want digital exhibits. We have some physical evidence, not a lot. We have some physical evidence that we're going to, and it's later in the trial, so we don't necessarily have to talk about it tonight, but I want to put the court on notice. Our standard routine of presenting it to the witness on the witness stand, we'll have to work around that. We have some large poster boards that we have prepared that
Like demonstrative exhibits or something?
yes, maps. And we had those prepared, weeks ago before we got the court's order. Frankly, and I know the court's aware of this, but it's going to challenge the prosecutors greatly by our inability to move around the courtroom, and I understand the reason, but I just want to put that on the record. We are wondering, as far as the exhibits, our paralegals prepared to present them all from our table, but specifically for like photographs and documents, should we print out a copy and have that marked and received so that if the jury wants it during their deliberations, they have a printed copy? I understand with videos that won't work, but photographs and documents that may work.
I've had that done in other trials where even though it's been presented electronically, the attorney has also submitted that paper for photographs, exhibit, things of that nature, so that it's available if needed for the jury. And I think that's fine. I certainly would approve of that. We also have the ability, when the jury is deliberating, to present any electronic evidence directly to the jury room. We would all see it in this courtroom. So if it's videos that are playing, if they request a video, that's how that would be done. But even if it's a succession of photographs, that can be done, or even other exhibits, like paper exhibits, things of that nature. I personally prefer that there are the photographic copies and paper exhibits as well that have the numbers, and those are the actual exhibits, but what you're displaying is obviously a replicate of that.
Okay, so we will do that for photographs and documents. Obviously, the videos we can't. Can we burn all of our exhibits onto one thumb drive then and have that essentially entered into the court record?
I don't have any objection to that.
Okay.
CCAP might have another position on that, but that's okay.
And then, as to opening statements, I understand the court's order. You want us at our tables. Would the court reconsider that in the event Mr. Brooks is not present in this courtroom for the state's presentation of opening?
At this time, I would not reconsider because, as you know, I oftentimes invite him back in or require him to come back in, and I don't want to be in a situation where now I've let you do that, but I can't let him do that for what I think are obvious reasons to
Oh,
everyone.
I see, okay.
So,
But we can stand up at our table during
You
openings.
can stand up, yes.
And he can too.
He can stand up
yes.
as well.
Okay,
Yeah,
okay.
but no podiums. I can address poster boards and physical evidence. I will make an exception to approaching witnesses for those types of things because it's a limited exception to my rule, and I wouldn't, how else would you be able to do that, right? I mean, the poster boards, you might have those electronically in some other format that you could use. You might want to use the annotation. Just for the record, Mr. Brooks is handing up the objection sign. We're just talking generally about procedure. There's no exhibit or to specifically object to. I'm not sure if you're objecting to procedure, but I'll get to that in a moment. Certainly physical evidence, you need to make certain, there needs to be certain foundational testimony. They're going to need to see those pieces of physical evidence. I understand that.
Okay.
Anything else?
No, that's it. Thank you.
Mr. Brooks, you raised an objection or?
Know what just happened.
Try to write something and then have to send it over there. I really was raising it so you would know I wanted to say something, but still not interrupt. Just so I would understand, what the prosecution is saying by burning the exhibits onto the flash drive and then embedding them into the record. Is that then essentially when things will be admitted into evidence? Because I had that issue yesterday when I asked that question. Because I have exhibits too, and I have some things that I would like to offer into evidence as well.
So I'm not talking about like admitting things with specificity at this moment. I'm talking about some procedures. I'm trying to frankly be mindful that you're in custody, sir, and that even though when you appear before the jury, you're dressed in civilian clothing, like the suit that you wore the other day. I am taking steps to ensure they don't see the restraints that are on your ankles. And because you have that physical limitation, I now am adding or have added a limitation to the state on, for the most part, physical movement within this courtroom. That's why there's no podium. They're not going to make opening statements or closing arguments from a podium. It's really to, in my words, level the playing field, if you will, and to ensure that as the parties appear before the jury, it's
Yeah, but
on
he
as
was
level of a
asking
playing
about the
field as
zip
I
drive
can
or the
provide.
thumb drive.
So if
whatever.
you have documents, we have a thing called a document camera, and so it will be in use. It may require the assistance of the bailiff, because my understanding is, and we can talk internally to find out if I need to have court staff, whatever. My understanding is it has to be on the state's table. I'm not sure where it went. It's usually been there. And so it's possible, we'll find it. It's possible. Okay, it's been moved. We'll put it back, but it has to go on the state's table. So if you have a document, sir, it might require you to pass it to someone who then puts it under the document camera. And assuming the witness, it's appropriated, there's a proper foundation, et cetera. And if I receive it, once the phrase, the exhibit received the court, that's when it becomes an exhibit that then can use. Does that answer your question?
Not really. I think, I'm sorry, Your Honor.
That's okay.
I think what I was referring to more as, for things to be able to be offered into evidence. So was that answering that? If it was, I apologize.
Do you have the exhibits? Are they paper? Are they electronic? Are they something else?
Well, I'm sure the majority of them will be paper.
So sometimes there's something in the discovery that's electronic that a defendant wants to use at trial. And I have typically asked the state for assistance because they have all of that. At least that would be my understanding. If there's something specific, though, and they have it, you should let them know. I don't need to be involved in that conversation per se, but you could write out for them what it is, and then I'm sure they can make arrangements to display it, and so it's presented to a witness if appropriate. Go ahead.
Would I write that out? How would that be like an in-court thing? Because that's obviously the only time I would see the prosecution.
Well, sure. You would write it while you're in your cell, when you're in the conference room reviewing things, and just make some notes on what it is. And then tomorrow morning or whatever day of trial, if you think you're going to want something and it's not on their exhibit list, you just make a note, and we'll see if they cannot make arrangements during the trial to display that. I'm not speaking on whether anything's admissible at this point or not. I'm just talking procedure.
Okay. I'm not sure about that. Well, the statement or the sentence before the last one, with the exhibits, they have to be separate exhibits. The prosecution has their own exhibits, and I have my own, so that way we're not using each other's exhibits. At least that's what I took from.
Yes, but if you're going to use an exhibit that the state's...
You know, the funny thing is, we all thought that he was wearing a shock anklet through the whole thing. He was not. He kept saying he had a shock bracelet, ankle bracelet, but he didn't. Because that came up. When did that come up? It came up late. I think it came up after the verdict that he was not wearing a shock bracelet. I don't remember how it came out during a hearing after the verdict, I think. But he kept saying it all through the trial, outside the presence of the jury. He kept saying it, and we all believed it. And it wasn't true. We found out at the end that it wasn't true. Judy, do you remember when that came out that it wasn't true? I can't remember, but it was at a hearing very, very late, and I want to say it was after the verdict.
It's not one that they're not.
Right. If they have something on an exhibit list that you want to use, it's pretty standard that we only use one copy of whatever it is. And then you're able to use that once during your case because it's already been admitted. Hopefully that helps answer your question.
Yeah.
Okay. Anything else?
No, we did want to indicate that certainly we're willing to share exhibits with Mr. Brooks. If there's anything he wants displayed and it's admitted by the court, we can pull it up and be of assistance to the court and Mr. Brooks. We also want to renew our earlier offer if he needs assistance in serving subpoenas, as long as it's a relevant witness and it's a reasonable request that is limited to southeastern Wisconsin. We will give any assistance we can. We want Mr. Brooks to have a fair trial. We want him to have his relevant witnesses and evidence ready for the court. If there's something he wants, even if it's a document, we don't have the document camera, we have the entire file scanned, or he can give it to us and we can scan it in 1 minute and have it up on the screen. So we are more than willing to do that so that we can all be efficient in our presentation.
Thank you. Did you hear that, Mr. Brooks? All right. So if there are things that you,
Say too, I'm sorry.
no, go ahead.
I was going to suggest that at some point, I didn't know if I'd be able to get to it today, but now it came up. That's one thing about the subpoenas.
So the sooner you can fill those out and get them to, I can copy them for you so that the state has them and give you a copy. We'll facilitate that, right? I know you're gonna wanna keep a copy of whatever it is, but the sooner you can bring that information to court, that would be the easiest and most efficient way to get that information to the state, meaning you gotta fill out your subpoena forms and then give them to the state, who will then look at them and they'll be able to tell you yes, no, and we'll go from there, okay?
So I'm not asking for legal advice, but it would greatly benefit me if I'm able to know that I'm filling out the subpoenas correctly.
You shouldn't.
I'm able to review for completeness, so if you bring them to court,
You
I can
shouldn't
at
have
least do
fired
that.
your attorney.
Okay, because the last thing I want to do is write all these subpoenas up and then bring them in and they're incorrect. Because something's not done the way it should be done, and then
You know,
I can review for completeness.
You know who would have
and,
known if it
we
was done
can go from
correctly?
there.
Your lawyer.
And Your Honor, I just wanted to correct one statement I made before. I had indicated that the jury instructions would be available on the computer in the conference room. That is not correct. They would be available in Lexis, which I believe is on his tablet.
Do you have Lexis on the tablet?
I'm sure I can find it. I wanted to say, it's not my tablet, they're for use for everybody, so I don't have my own specific tablet.
Understood. Lexis is a legal research, legal material platform. It's actually what I use. So I know it to be very thorough, but you have to search for things, but I'm told that the jury instructions are available through Lexis through the tablet.
Yeah, I don't know exactly what the program is called itself, it just goes by the law library, that's what we
Okay.
call it. So.
All right. Is there anything else, Mr. Brooks? Okay, then that leaves tomorrow morning just the final finalization of the jury instructions and the motion for reconsideration.
Yes.
Okay, all right, thank you, everyone. We are in recess for tonight. We'll see everyone tomorrow at 8:30 a.m.
You could let him know I'm gonna print it right now, so it can be handed to him before.
Yep, and the bailiffs need to make sure they don't let, we need to print off material for him. It's coming forthwith. All right, thank you. We're in recess.
Polycom's on.
Yeah, everybody thought he had a shock anklet on. Okay. Trial day one. I don't know. I don't remember when I started watching. I did not watch opening statements. I think I didn't start watching until everybody started talking about.
Morning.
Until
by
everybody started talking
District Attorney Sue Opper.
about how insane this guy was. When I started hearing everybody talk about how crazy this guy defending himself was, that's when I started watching. I didn't see opening statements, and I, for the life of me, can't remember when I started watching. But yeah, even Peter Tragos thought he had a shock ankle bracelet on. Because we kept asking him, why aren't they shocking him? And Peter would be like, I don't know. I don't know why they put one on him. They're not using it. We all thought he had a shock thing on. And another rumor that went around, and I believed it big time, was that the judge was pregnant. You know, I don't remember who I watched this with. I think I jumped around. I think that I watched some with Mike and some with Alita. I know I watched sentencing with Alita because that's when she first started doing needle felting, because she goes, I gotta get my needle felting out so I can stab something. So she's sitting there with her needle felting, stabbing. While he was talking during sentencing, she's stabbing. So I probably did watch most of it with Law Talk with Mike. And I watched Peter's recaps. Okay, Marty, well, you gotta watch when it gets to the box fort part. We'll let you know when you gotta. That's down the line, though. But we'll let you know when the box fort part happens so you can watch. And the stare down. You'll have to watch the stare down, too, because that's quiet. Well, no. The judge talks. He stares, the judge talks. Okay, so you got, wait, why is he, this should be opening statements, right? Why isn't he in street clothes, Judy? Yeah, I don't think I started watching until like day 2 or 3. After I heard about all the nonsense and I went, ooh, this is going to be a fun trial.
All right, good morning, everyone. The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. Record should reflect that the state appears this morning by District Attorney Sue Opper, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Wichow, and the defendant Darrell Brooks appears in person in custody. I'd also like the record to reflect that he is appearing in jail attire today. He's also wearing a mask.
I object to that, Your Honor. I do not identify by that name and would like the opportunity to state that I'm here concerning this matter as third-party intervener in this matter, appearing as authorized representative for my client. I accept for value in return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and would like to now reserve my rights, if I may.
Mr. Brooks, you just interrupted me within a minute of us starting this case here today. I'm asking you to respectfully not interrupt me. That's the second time, so I can go through the list of things that I need to get through this morning.
I just wanted it stated for the record that
Mr. Brooks, it wasn't the proper time to do that. That's now the third interruption. So,
with all due respect, Your Honor, every
Mr.
time
Brooks, by saying all due respect doesn't change the fact that you're interrupting me. Your objection is noted, all right? But you need to stop interrupting me so I can get through what needs to be done.
But it is my
I have a
right
number
to-
of documents that I need to discuss this morning. Mr. Brooks, you do not have a right to interrupt the court.
No, it
I will
was-
remind
that was
you
not
once
my
again
intention.
of the Supreme Court rule. It's on a yellow laminated, double-sided piece of paper that is before you. I
did not
checked, I
recognize
verified,
that.
it
I
is.
accepted and returned it
Mr.
to
Brooks,
value,
that's
Your
yet another interruption. Let me get through this, please.
I just want, for the
You will
record,
have an opportunity when I give you an
I want
opportunity. No
to
one
state
else
it.
is speaking at the moment but me. You need to stop interrupting.
I don't identify by that name.
Mr. Brooks, I am going to keep going. You are warned. You need to follow the standards of courtesy and decorum for the courts of Wisconsin. Chapter 62, that's another
I
interruption.
intend to follow decorum.
This court comes with a history of Mr. Brooks interrupting now. This is day 4, and every day Mr. Brooks has interrupted. It has resulted in Mr. Brooks being placed in a neighboring courtroom so that this court can efficiently, effectively, and with dignity preside over this case here today. I am well aware. That's another interruption. I'm well aware. Stop
respectfully, which I have the
talking.
right to do.
I'm well aware, Mr. Brooks,
I
that
have
you
not
object to the
intended to
name that
cause any,
has
disruption.
identified on the information and all documents in
want it
this
noted
case.
for the
Your
record that I did
objection
not
is noted. It
identify
does
by
not
that
need to be
name.
repeated. I will make a record right now. The
May I
court
have the
notes
opportunity to
a
preserve my
continuing
rights, Your
objection
Honor?
by Mr. Brooks of his name and that he objects to being here. I know he's filed a number of documents previously
I never
related
objected
to
to
that.
being
Those
here. I just
documents
state-
are
I tried
of
to
record.
state
There's
that
another
for the record,
document
Your
that's
Honor.
filed. At least 2 more interruptions just now. I believe I'm up to 8. Mr. Brooks, you're advised that continued interruptions will result in you forfeiting your right to be present in this courtroom, where you'll be taken to the courtroom next door to appear by video and audio
I don't
means to
consent
participate.
being removed from the courtroom, Your Honor.
That's another
And you
interruption.
haven't shown me any lawful case
Is
law
this the
that I
day
can
he
be
took his
removed
shirt
from
off?
the
Mr.
court
Brooks?
proceedings in a trial and forced under coercion and duress to appear in the trial that I am needed, that I've tried to express that I have the right to
Mr.
be
Brooks, there's
present.
a proper manner in which you raise objections. You have not followed that proper procedure. You are unable or unwilling to abide by simple rules of civility.
You haven't
You
given me the
interrupt,
chance to
you don't wait for
state my
anyone
name.
to finish, and it will result with you being removed from the courtroom.
I
So you
respectfully
are
object to that,
once
Your Honor.
again reminded of that. I'm going to give a little slack at the moment only because we are not in the presence of the jury. I'd like to go through a couple of things, the first of which is the jail attire. Mr. Brooks, we, meaning myself and the jail, have made arrangements by allowing folks to bring in street clothing for you. You've appeared previously in a suit and tie, very appropriate for a trial. If you no longer have those clothes available, the jail has a supply of clothes that they can also lend to an inmate. The reason we make those arrangements during trial, sir, is because this court has taken a number of steps to shield from this jury that you are in custody. Your hands are not shackled. Okay, there are skirts around
feet are
each
shackled.
one of the tables. I'm aware of the feet shackles. That's yet another interruption. I'm aware of the shackles on your feet, and that's why the skirts are on your table and frankly all of the tables, right? So that it appears to be the same for anyone coming in and viewing. Again, arrangements have been made for you to appear in street clothes or civilian clothes. I would like you to appear in street clothes, and the reason why, sir, is to reduce or even eliminate even the appearance that you are in custody. And it is your choice, though. Are you willing to go back to your cell and put on your suit?
It is my right to do so or to not do so. And at this point, Your Honor, who doesn't know that I'm in custody?
Mr.
Who
Brooks,
doesn't know that?
I've had many trials with individuals who were in custody, and when I've talked to the jurors after the conclusion of the case, they had no idea. The whole point of allowing for street clothing is not only to shield jurors from the fact that you are in custody, but also you being in a suit and a tie or other street clothing, I think also lends to the dignity of the proceedings. This is a trial. Again, it is your choice. Are you willing to go back to your cell and be dressed in the street clothes that you previously appeared in?
With all due respect, I do not agree with that assessment whatsoever. There's no possible way that anybody will not know that I am in custody. I think that's a well-known fact because it's reported on every day in the media.
And they're
It's
not.
shown
They
every
haven't
day on
seen
the
it.
news
That's how they got picked
where I
for
am,
the jury.
what jail I'm housed in, and that I'm in custody. It's virtually impossible for anybody to not know that I'm in custody.
Mr. Brooks, did you hear the question that I asked you?
And I respectfully keep the position that I just put on the record.
Mr. Brooks, I will ask you again. Are you willing to go back to your cell or into the jail and put on street
I do
clothes?
not consent or agree to anything that you just stated, Your Honor.
All right, he did not provide an answer to a very direct question. Let the record be very clear that Mr. Brooks was given multiple opportunities to answer that question.
And I
And go
answered
back,
it.
Mr. Brooks, that's yet another interruption. I will advise you, sir, that at any point in time, if you wish to put street clothes on, I would give you that opportunity to do so. You've already heard it is my preference. You've already heard me advise you regarding the steps that have been taken to shield the fact that you are in custody from the jurors. You refuse to answer my question about
did not
whether
refuse.
you would
I answered it.
go
You just
back
didn't
to the
like the
jail.
answer,
That's
Your Honor.
another interruption. So based on his refusal and his
I did
choice
not
to come,
refuse.
that's
I did
another
not consent
interruption.
to saying
Based upon
a
his
refusal. I answered.
failure to answer my question directly, I will
I
take
did
that
not
as
refuse.
a non-response, but he came to court
That was
here
not a
today. That's another
non-response, Your Honor.
interruption. I will take that because he's come to court here today in his jail attire, that is a choice that he has made freely, voluntarily, and intelligently. No one has forced him to come
I
to
did not
jail in
consent
those
to that.
clothes. This court is encouraging him not to. He's appeared previously in his street clothes in what I would describe as a very nice suit and tie. But it is his choice to not do that, and we will proceed accordingly.
So while we're on the record, may I challenge the subject matter jury?
No, you may not,
Oh,
sir. You
there
need
he
to file a
goes.
motion in order to do that.
So.
Mr.
the
Brooks?
motions I filed haven't even been responded to. I gave.
Mr. Brooks, you're interrupting me
No,
yet
you
again.
just weren't
All right,
speaking, so I didn't
Mr.
interrupt.
Brooks, you are now going to be removed to the
I
other
don't
courtroom.
consent to that.
I have
I'm
had
under
a
duress
dozen
by
or
having
more interruptions.
I
We'll
have
be
shock-
off the record while we
shocks on
do
my
that.
ankle.
Thank you,
I don't
everyone.
agree to a stop. I move for a motion to dismiss for being under duress and being coerced into a contract that I did not consent or agree to. I do not. I have a right to be present for trial.
Oh yeah, this is the day he took his shirt off. Yeah, I saw this after the fact because I didn't watch the first day. Yeah, coerced. He was coerced. And he obviously was not paying attention in jury selection. Because thinks everybody knows he's in custody.
You're able to see the screen, is that right? Okay. Yes. I'll publish that as well. All right, we are back on the record. Appearances are as they were before. I need to make a record that at 8:42 a.m. this court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. This, of course, comes on the recent history with Mr. Brooks. On every day that we have been in court since Monday, he has shown a complete and utter disrespect for the simple rules of civility. He has been removed from the courtroom multiple times. This morning alone, he started interrupting this court within a minute of the court calling the case. I should also make a record at the moment he is muted because of the way that he was removed from the courtroom and his conduct since. I have been given just a bit of information about it. I will advise everyone that I have required that the Sheriff's Department file a written report with the court regarding Mr. Brooks's conduct. I'm told that he would not sit down while in this courtroom in order to have the shackles removed so that he could be taken to the other courtroom, that he was resisting, that at one point he took off a shoe and it appeared to the deputies that he was going to throw the shoe. You can see that he is seated with his back to the court or to the camera. He took his shirt off as well. I'm also told that he is threatening.
She never once put him in contempt of court because he kept saying, "You're putting me in contempt again." It was almost like he wanted to be put in contempt of court because he kept saying, "There you go, putting me in contempt again." And she said, "I've never put you in contempt of court. You are not in contempt of court." It was almost like he wanted her to do it, and she never once did it.
To throw and break items. I want to give him headphones since he has claimed in the past to be hard of hearing in one ear, but given his statement that he would throw and break things, unless he can pledge to this court that he will not do that, I'm not going to provide that information. I will advise that the audio in that courtroom should be turned up accordingly so that it is louder than it has been. I've also been advised that the audio and visual equipment is working in that courtroom. The deputies that are in there can see and hear the court through the Polycom system. Today is a little bit different in that there is no Zoom. And so, but this court, with the blessing of technology in this new building, have the ability,
which is why he wanted it,
to call in one room system to the other. That is why we're able to see and, when appropriately, hear him when unmuted. And then there are the 4 camera angles that are presently from this courtroom. I have the camera in the other courtroom on a single camera since he's the only individual in there. This court has, in essence, extended this courtroom to the neighboring courtroom. While there is ample evidence in the record, not only through the proceedings up to this point, but this morning alone, that through his conduct, he has forfeited his right to be present, I'd also make a finding that he is appearing from that courtroom, and that because of the audio and visual equipment and system that we have in place, that it is the functional equivalent of being present in this courtroom. This court has relied repeatedly on Illinois versus Allen. I've read portions of that case into the record. I don't intend to go through that at length here today, other than to indicate that Trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula exists for maintaining the appropriate courtroom atmosphere will be best in all situations. And in that case, there were at least 3 constitutionally permissible ways for a trial judge to handle a stubbornly defiant defendant, which this court would find Mr. Brooks squarely has become and has demonstrated over the course of these last few days. One option is to bind and gag him. I've already talked about at a previous hearing why I choose not to do that. Cite him for contempt. I choose not to do that either. The third is to take him out of the courtroom until he promises to conduct himself properly. Mr. Brooks today, of course, showed up in court from the jail in his jail attire. He does that by his choice. I gave him the opportunity to go back to the jail to put on his suit and tie or other street clothes. He refused to answer that question. This court will continue with this trial, as I have previously indicated. There are many resources that have been put into bringing this day to bear, and it is important for all involved that this trial continue. Again, Mr. Brooks is given the opportunity to appear from that other courtroom. At this point, I'm still in the final housekeeping matters, and so he clearly has forfeited his right to be present for that. I will advise Mr. Brooks, as I have advised him repeatedly, if at any point in time he wants to come back and he is willing to promise that he will abide by the rules of courtesy and decorum and be civil and show respect for the court proceedings for all individuals in this courtroom, including Mr. Brooks himself, then he may come back in. It's also my intention to give him that opportunity at each new stage. But again, we are in the preliminary stage prior to the jury being brought in. I would note it's a little after 9:06 a.m. At all times throughout the court's statements thus far, since going back on the record, Mr. Brooks still appears to be communicating, or at least attempting to communicate with someone else. I can see his hands moving. He has turned his back. I can tell that he can hear me because he shakes his head no at a point in time where it's clear he's disagreeing with something that I've said. I believe he can adequately hear, and that his statement earlier in the proceedings that he's hard of hearing is simply another tactic of his to disrupt, to delay, to create chaos. I will further advise Mr. Brooks that his continued behavior, whether it be appearing in court in jail attire, whether it be causing disruptions in front of the jury, that he does all of those things at his peril. But I will, of course, take appropriate steps to limit what the jury can hear if appropriate. All right, I've received a note, we need to reset the Polycom system, so I'm not sure what that means. I'll find out, and if appropriate, make a record as to why and whether that impacted anything that was happening in the other room. But at this point, while I'm not going to get off the bench, we're going to take a short recess for that resetting to take place.
I would request an opportunity to be heard. Then, Your Honor, when you go back on the record, please.
Absolutely. appreciate that. It will be my position. It's not needed for him to do that every single day because I've noted a continuing objection. With that, you wanted to make an additional record?
Yes, Your Honor, it's probably appropriate at this stage. I did want to address a topic that's maybe not been raised in the courtroom, but has been raised in the public, and it seems to kind of go hand in hand with the events of this morning, and that is the mental competency of Mr. Darrell Brooks to proceed to trial. The court is well aware that the district attorney has an obligation and a duty to raise any concerns as to the competency of any defendant to proceed to trial. Any counsel representing Mr. Brooks would have that same obligation, and the court itself, if it had a concern as to the competency of any defendant to proceed, can request an evaluation that's pursuant to 971.14 of the Wisconsin statutes. At no time has anyone involved in this case had a competency concern. And I say that based on the fact that Mr. Brooks has made multiple court appearances, most of them before Your Honor, but at least initially he appeared before two court commissioners. He's had counsel representing him up until last week on this case, and you've made a record with Attorney Perry previously as to Mr. Brooks' ability to understand what's going on and his ability to participate in his own defense. You made a thorough record last week when you went through his waiver of right to an attorney and his absolute desire that he expressed multiple times to represent himself. I would also add to
She does that a lot. She sighs an awful lot. I don't blame her. Why? What is happening?
He is coherent, he is intelligent, he knows the issues in the courtroom, he discusses what happened in court that day with these individuals he's speaking to. I am thoroughly convinced, Your Honor, that Mr. Brooks is 100% competent to proceed to trial, that his mental capacity is not reduced in any fashion. Anybody that thinks otherwise has no involvement with this case. I would reference the court to today's filing, which Mr. Brooks provided. It is extremely well written. His handwriting is immaculate. It's perfect. The punctuation, the grammar is 100% accurate. He drafted this himself in his jail cell last night, I presume. Maybe it was this morning. He has continued with the same objections that he has been making repeatedly in this case. So he clearly understands the issues. He understands the defense that he wants to pursue. He undertook the effort to have this.
She's doing this for the record because she doesn't want the case to get thrown out or anything because he was representing himself, I guess. I mean, I know if you represent yourself, then you can't appeal on the basis of ineffective assistance of counsel. But I can't think of any other reason for her to be doing this on the record other than just making a statement for appeal, you know, so that it doesn't get overturned on appeal.
Form notarized by a jail employee so that it is a signed and sworn affidavit. Absolutely no Wisconsin that Mr. Brooks has any deficiency in his competency. We are 100% convinced that these actions of Mr. Brooks are deliberate and intentional, and they have escalated, and the court has seen this since August 25th or so. As the motions were decided by the court, most of them to his detriment. His behavior became more and more difficult in the courtroom. It started out less aggressive with him sleeping and asking to be able to leave the courtroom. Then we had a toothache. Then we had situation where he didn't want to come to court, was refusing to come to court. The record will be clear, Your Honor, that each time, and the Sheriff's Department has done an absolutely fantastic job dealing with Mr. Brooks fairly, professionally, respectfully at all times. We concur 100% with the record you just made as to what happened after the recess at about 8:42 this morning as to Mr. Brooks' conduct. These are deliberate actions on his part as we get closer and closer and closer to actually presenting this case to a jury, that he is attempting to derail these proceedings and avoid the inevitable. And I want to make that record. I tell this court as an officer of the court, we have zero concerns as to the mental competency of Darrell Brooks to proceed. And we have had many, many dealings with him on the record and off the record that I base that on. I also wanted to add one other comment as to the court's record as to the need to proceed with this trial. We concur 100%. We would also note it's not just a matter of resources. It's the need to proceed to justice. It's the need to get justice for the crime
100%.
victims
And they
who have
helped him.
patiently attended every one of these hearings. They have a constitutional right.
They helped him. They served subpoenas for him. They did all kinds of things for him to help him. And they didn't have to help him.
To trial. They have a constitutional right to a speedy disposition of this case. And that doesn't mean hasty. That doesn't mean reckless. It means efficient administration of justice. And this court has provided that to the crime victims. And we think that's another reason that Mr. Brooks' antics, which is all they are, clearly speak for themselves. This is not his inability to understand what's going on by any stretch.
Thank you, Attorney Opper, and I do appreciate you raising that with the court because I share your observations that you've just noted on the record. I would adopt them fully as if they were my own and make them part of the findings that I've already made on the record. Obviously, I personally haven't listened to the jail phone calls that you referenced, but I do take your statements as an officer of the court. I look forward to further reviewing them, if need be, changing any conclusions that I've reached here today, and I would require you to file that exhibit so that that can be part of the record as well. I would also add to what you have just stated. This court has read through not one, not two, not three, but 4 evaluations related to the special plea that was withdrawn. And those are very recent evaluations where the examiners met face-to-face in the jail or in an appropriate visitation room with Mr. Brooks, either in July or August of this year. And every single one of those individuals did a mental status exam that's noted in their reports. Frankly, the behavior that we're starting to see here is no different than some of the behavior that was noted by those examiners as well. This behavior is frankly more in line with someone who's defiant, deliberate, and in line with the conclusions related to whether he suffers from a mental disease or defect that would qualify for a special plea. I've not gone into much detail, and I won't. Those documents are part of the record, but it's very clear to this court that everything that he has done as outlined by the state and as made evident on the record of these proceedings, that it is the sole intent of Mr. Brooks to make a mockery of this process. And I've stated, and I'll state it again, I'm not going to tolerate it, but there is, I believe this trial needs to continue, should continue, not only for Mr. Brooks as the accused, who also has the right to a speedy disposition. He hasn't exercised it. The victims have a right to a speedy disposition. And it's important for the justice system to go forward with this proceeding We are at the stage where we are at with Mr. Brooks muted in another courtroom because of his defiant actions. No one else. And I appreciate everyone's patience as the court goes through these things, frankly, gives Mr. Brooks time after time after time to conform his conduct to the clear expectations, but he just simply flat out refuses to do so. So what I'd like to do is finish with the approval of the jury instructions, the preliminary jury instructions. I will make a record that Mr. Brooks did not file anything in writing regarding a proposed jury instruction as he was advised to do yesterday. If he wanted me to consider something, I believe we had a very clear discussion on the record about that. He was given a full copy of the draft preliminary jury instructions. He was part of that conference that we held yesterday. There was even a discussion regarding where he could find jury instructions with the legal materials that he has access to in the jail. Although he didn't take it to his cell yesterday, he has had the selected statutes that I referenced yesterday that also have the rules of evidence. And so I wanted to make that record. I don't have anything from him this morning regarding any additional jury instructions. Has the state had an opportunity to now review the preliminary jury instructions with all the changes that were made yesterday?
We have.
Any objection to those?
No.
All right. Mr. Brooks, I'm going to unmute and ask you if you have any objection to the jury instructions that were provided to you yesterday. I'm specifically looking for a yes or no answer, and I'll address further if need be based upon that yes or no. The microphone is unmuted. Actually, we'll need to turn him up. It's not very loud on our end. Mr. Brooks, did you say one more time? Yeah, but you know what? Your volume's a little low, so we're gonna have them adjusted over there and in here. So give us a second. I think she's to turn the microphone. Where is the microphone? It looks like it's in front of the monitor.
I don't know, but they do. In fact, I think that's why he did this soft sit thing.
Mr. Brooks?
Somebody told him about it because he didn't
Try
start
again.
off this way.
Am I on the record?
You are on the record. Ooh, that's loud now. We'll turn ours down. Mr. Brooks, yes or no question, do you have any objection to the preliminary jury instructions that were provided to you yesterday? Go ahead, answer please. All right, your objection is noted for the record, and I'm just putting the mute back on. He provided that objection without any legal basis. I muted him just so I could ask this question. I'll be right with you, Captain. Mr. Brooks, do you have a legal basis to object to those preliminary jury instructions? I'm unmuting you. Hold on, the volume is not being appropriate at the moment. There needs. Try it again, sir. I apologize for the technical issue. All right, the technical, we're gonna have to figure that out. It's not appropriately working. I do appreciate that he was able to hear me because he leaned in to answer. So I just want to make that record. I'm going to go take a recess. I'll just mute while we're doing that, just so I can figure out what the audio issue is, and then we'll go from there.
Well, now you gotta let him come back in the courtroom. because there's an audio issue.
At this time, I'm not going to pause the proceedings further for him to be seen by jail medical, but at an appropriate break, that will be done.
For what?
And I also want to make a record that Mr. Brooks has put his shirt back on. He continues to sit with his back to the camera. Mr. Brooks, I want you to be advised that I believe it's important that you face the camera so that you are facing the court. You can see and hear. It's my understanding you were not willing to cooperate with being shackled, and for the moment, you are not. But at this point, given your conduct from before, I'm going to require, after we take the next break, that the Sheriff's Department put you in the chair face forward and with shackles on your ankle, as you are in custody, and that is appropriate. Now, I want to turn back to the issue with the jury instructions, Mr. Brooks. You indicated you had an objection. My next question to you is, what is the legal basis for the objection? I'm going to unmute so you can answer. Go ahead, sir. You need to turn around so I can hear you. Part of the issue is he's also not facing the microphone, and so I need to hear him, and he needs to turn around. Mr. Brooks, I'll ask you once again, what is the legal basis for
asked you if you had to go
your
out. You said you
objection to
wanted
the jury
cookie.
instructions?
Hang on a minute.
I'll ask a third and final time, sir, what is the legal basis for your objection to the jury instructions?
I wasn't loud, so I can't even hear what she's saying all the way, man.
Well, then he shouldn't have fought with the bailiffs.
Do you want your headset?
Mr. Brooks, I can hear the deputies over there. I know they can hear me. That's been confirmed. There is the headset available to use should you wish to use it. If you can't hear, I would ask that you put them on.
Jill. I'm sorry, honey. Feel better.
I'm able to hear. He said to the deputy, put them down. I don't want them. All right, I'm going to mute once again so I continue with my record. He did not answer the question, what is the legal basis for the objection? I asked that question 3 times based upon that non-response. His objection is noted for the record, and I will approve the
He's barking at his
preliminary
food.
jury
No,
instructions
he's barking at his food.
that are
I don't know
on
why he barks at his food.
file with
It's weird.
the court. Obviously, they'll be uploaded once I read them, but all parties have been
Then he'll
given
probably pee
copies
on the floor.
of
After he barks
those.
at his food, then he's probably going to pee on the floor. And I'm going to have to clean it up.
Before I turn to the motion for reconsideration, you raised this earlier, at least the topic of it. Mr. Brooks presented a filing to the court this morning. I asked the bailiffs before the case was called at 8:30 if Mr. Brooks had any paperwork and to ask him if he had any filings. He then provided this piece of paper and it was photocopied. Actually, it was date stamped, then photocopied for the parties. It may have already been scanned in, I'm not sure, but it certainly will be. I've had an opportunity to review this document. Based upon my review, I don't believe any response is even required. It's his affidavit. He's providing certain disclosures, but there's nothing about that that requests any relief from the court. Certainly no legal statutes or constitutional provisions are referenced. To me, it just looks like an objection that he's filing, and that will be, of course, noted for the record. Attorney Opper, anything you would want to add to the record on this, any position you are taking?
No, I also viewed this as, because he labeled it objection by affidavit, I think my interpretation is he was trying to make a record for appeal that he objects to the court's previous ruling. I don't think there's anything the court needs to do with this document at this time.
All right, thank you. Then we'll move on to the motion for reconsideration. And again, I'm keeping Mr. Brooks muted so that I can get through this process orderly, efficiently. When necessary, I will unmute him if the court has questions. All right, Attorney Opera, I have read through the motion. Is there anything you want to add to what you have put in your
What is the
filing?
reconsideration for?
Only
what?
one other observation, Your Honor, that since I filed that the events of the last couple days, I think further support my request, not that the defendant's behavior in the courtroom has anything to do with the broadcasting of victims and witnesses, but I think the stress that is going to be placed upon them potentially by Mr. Brooks' behavior will be additional challenge to them as they testify, and so not having their faces displayed, I think, would help ease some of that tension for those individuals.
Oh, that reconsideration. She's not gonna do it,
Mr.
Sue.
Brooks, my first question to
Give it
you
up.
is,
She ain't gonna do it.
do you have a position on the state's request in their motion for reconsideration? I'm looking for a yes or no answer. If you, I'll unmute and provide that to me. Go
I
ahead.
didn't hear what they said. I just put the headphones on, so I didn't even hear what she said.
Sir,
That's
it's a
on
written
you.
document that was filed, and you were provided a copy of that yesterday. We took a recess yesterday, so it could be served upon you. If you haven't read it, that's your choice. What I'm asking you is, do you have any position on their request for this court to reconsider the denial of the state's request to prohibit the photography and video recording of victims and witnesses, and specifically their faces, while they testify?
A ruling was already, we already talked about that. You already ruled that
Yeah, this is a
the
reconsideration.
victims and
It's a
witnesses
big
will be
word.
shown. That was already ruled on.
You are correct, but they filed a motion for reconsideration. That's the document that was provided to you yesterday.
Yeah, it's a big
I'm asking if you have any
Darrell. Big word.
position on the request that I
That
reconsider
means
my
please
ruling.
change your mind.
Yeah, it was, everything's supposed to be public. This is a public trial. I don't understand why there would be even the need to reconsider what you already ruled on at this point, as far as to that particular issue.
I take your.
It's a public trial. It's a public trial. Anybody can essentially watch the trial. And like I said, as far as with the technology that we're in now, if they have to be sworn in by name, that in itself makes them easy to, if somebody wanted to pull them up or find them or find out who was testifying at any given time testimony is given, it'd be pretty
right,
easy
Darrell,
for them to
shut
be
up.
found and to be seen. So, I mean, that's just the age we're in anyway, as far as with social media and Google and all these
right.
different
Shut
things.
up.
We got all this technology basically at our fingertips. So I don't understand how it needs to be changed at this point when it was already ruled that this is a public trial. There's going to be a lot of things that are going to be shown. Why not keep everything public the way that it's intended to be? And because of the fact that you've already ruled on it, made that on the record,
Yes, Darrell.
let's keep it the way it is.
That's all you had
Thank you,
to say.
Mr. Brooks. I appreciate your legal analysis of that and your factual analysis of the prior ruling that this court gave. I thought you did an excellent job making some very good points, many of which I relied upon previously. There is a mechanism in the law for a party to bring a motion for
What the heck?
Essentially, it requires that the party bringing the motion provide some new information or rely on an argument that the court aired as a matter of law in its prior ruling. The decision that I made previously and the decision that I make here today is one that is vested with the sound discretion of the court. I would note the state does rely upon a case. The case is not new, so it's clearly something that was in existence at the time of the prior motion. That's Estes versus State of Texas. It's 381 U.S. 532, but I would note it's from 1965. In 1965, I would say even in the 1980s here in Waukesha County, there was really a presumption that cameras not be allowed in courtrooms at all. We have moved vastly away from that over the course of the last couple decades, and certainly since 1965. I am certainly mindful of the potential stress that it may cause for victims and other witnesses to come into court and testify and to have their images broadcast as this trial is broadcast, not just locally, but nationally, and frankly, anywhere in the world anyone with a computer would want to watch. I would note, though, that prior to the point in time when this case came to trial, this court took significant efforts to keep victims' names private. There's a victim key that is on file. This court signed an order and even required Mr. Brooks to not disclose that information. That was one of the conditions set when bond was initially set. Now, that was by a court commissioner, of course, but that's still a ruling that this court adopts. In addition, I believe I've done, up to this point, everything that I could to preserve their privacy. I don't frankly want to create an issue that could be an appellate issue. I think this potentially could be that if I limit the capturing of victim and witnesses' images. I'm aware of Marcy's law, certainly aware of the provisions that the state cites. But the fact remains, the time has now come for this trial to be conducted. This is a public trial. The right to a public trial is not only for the defendant, but the state, but the public. All of the names are a matter of public record. This court obviously went through all of the names of the witnesses during the jury selection process. In the jury instruction, the names of all the victims will be read. The state agreed that it was time to put that information in a public document and on the record because the time for trial has come. The cameras in the courtroom not only facilitate the viewing of a public trial where anyone could walk in to this courtroom, space permitted, to watch, but it facilitates victim rights as well. And that is because there are a large number of victims in this case. This court could not have all the victims and the public and the media who wanted to be here present. Frankly, I think it's because of how this court has allowed the proceedings to be live streamed that we don't have even a full courtroom here today. There is no doubt this case has received great public interest, but this is a case that the state brought charges, and rightly so. I understand it won't be easy, it may be messy, it may even be stressful, but it's important to the integrity of these proceedings, the perception of how things are conducted in this courtroom, that all witnesses, that all victims, with the exception of the one thing I accepted previously, be viewed in its fullness to the public. I maintain the exception for juvenile witnesses. They are in a special category as minors, and they, of course, if and when a juvenile witness testifies, may only be captured from the shoulders down. Their faces are not to be broadcast. Again, I am not unmindful of the impact, but in my humble opinion, the right to a public trial supersedes the other provisions, and especially in a case such as this, it's important. I would add to the record some of the points Mr. Brooks made. Not only are these names all a matter of public record, the technology that we have at our fingertips, there's Google, there's social media. It's very easily to identify these individuals and search for them in other ways. I'd also add that there have been a number of news reports, media accounts, newspaper articles about victims, naming them. I'm aware of one such broadcast this morning on Channel 4. I cannot presume that all victims, all witnesses want this. And I want to keep this trial going, and that's what we will do. So the request is denied. All right, I believe, let me just get back to my first note that I had for this morning, that we've covered all of the outstanding issues.
Your Honor, if I may, I don't want to interrupt, but I did not hear if you, I was kind of overhearing that you addressed the filing that I filed this morning. I didn't hear exactly what was said. I'm just making sure that you know that I'm not trying to interrupt. I just want clarification on what I may have missed.
I'll tell you what I ruled previously. I've reviewed the filing. It's entitled Objection by Affidavit to the state's response and the court's opinion and order and defendant's disclosure statement by affidavit. It's an affidavit. It does not request any relief from the court. I have interpreted what you have filed as an objection to be noted on the record. It has been accepted, it has been filed, and that your objection is noted. The court need not take any specific action as it relates to it. I further indicated that, again, no relief was requested, but also there's no statutory or constitutional or law that you cite to that I could even interpret as a request for relief. So that's how I'm going to address that filing, sir. It's noted for the record.
Can I say one thing about that?
Quickly, sir. I need to keep going.
I was filing that paperwork, I would say pursuant to the federal rules of criminal procedure under Rule 12.4 about the disclosure statement.
All right, I'll note
so
that for the record, sir, but it was not in your filing.
So that's a judicial determination, Your Honor?
I believe I had one other thing. Oh, I did want to put on the record, and that is when we were testing the audio, I did advise the Sheriff's Department to let Mr. Brooks know, to ask him on my behalf if he wanted to come back into this courtroom. My understanding is he declined.
No, that is not accurate, Your Honor.
Mr. Brooks?
The reason?
Mr. Brooks?
I would just want it.
Hold on, I'm going to mute you for a second unless you stop and listen to me.
I just heard what you said, but
I'm not asking for a response, sir. Mr. Brooks?
It's not.
Okay, you're
accurate,
interrupting. Hold on. You're interrupting me, sir. I wasn't looking for a response. I'm happy to ask you the question myself on the record for you to answer it. I will give you the opportunity to come back into this courtroom. You have demonstrated that you can make cogent, coherent, articulate arguments on the record. You just did that. You've been respectful for the time being. I will ask you, sir, do you want to come back into this courtroom? You've been unmuted to answer that question.
Not until I can receive medical treatment for the bruise that I have on my arm and the cut. You just said a while ago on the record that you cannot see blood. That's because I wiped it on my pants and you can still see the blood in the cut and a big bruise right here on my arm. I was told that the nurse would be coming in to see me, and then I was told, no, she's gonna come at the next recess, which we just took it. I know it was technical difficulties why you called the recess, but that was more than enough time for me to at least be seen, at least get the cut cleaned out and get it bandaged, at least at minimum that, and for somebody to look at this bruise. That was my position on why I was not yet ready to come back into the court, because I feel like this needs to be addressed.
All right, Mr. Brooks, I understand your request. I'm denying the request to take an adjournment, or I'm sorry, to take a break at this time.
I'm not asking for a break. I didn't ask for a break. I was just saying that at the time that there was the technical difficulty recess, before you even called that, Your Honor, I was told that a nurse was coming in at that time, but then when you called the recess for the technical difficulty, I was then told that I would have to wait until another recess to be able to be seen by the nurse, which my thing was, I
Mr.
wanted
Brooks,
to
you've
get
made
seen
your
by the
record,
nurse.
okay? I don't need you to go further with that. You've made your record. I'm gonna mute you for the time being.
like a
I want you to be aware,
petulant child. He
sir,
just
I was
keeps
advised
arguing
regarding
when
the
he doesn't
cut,
get his
the bruise
way.
is new information. I made a determination that you would be seen at the next
So
appropriate
what?
break.
It's a bruise. You're not
From my
gonna
perspective,
die.
a small cut and a bruise is not going to hold up the start of bringing the jurors in and advising them of the preliminary jury instructions. If that means the next break we take is for lunch, and that's when you are seen, then that's what will happen. So I don't think I've overlooked anything, Attorney Opper, but anything you had on your list?
Nothing else on my list, but we want to give Mr. Brooks one more opportunity to change out of his orange jail uniform, excuse me.
That I would give him an opportunity to do. Mr. Brooks, would you like to go back and change into your suit?
My position has not changed whatsoever, and it will not change, as it is my right to come into court how I would like to. Just like I should be awarded the right to be present for every proceedings in this trial.
You are present,
I'm
stupid.
muting him again. I note your objection. I will take that as a clear indication you do not want to go back to the jail to change into street or civilian clothing, that you are exercising your right to dress in the jail attire. All right, then with that, I am going to just take a short recess just to have the jurors brought in.
I think Mr. Brooks needs his objection sign.
We'll make sure he has it.
Thank you.
Let me actually go back on the record for a second. Mr. Brooks, when the jury comes in, I am going to read through the preliminary jury instructions. Since those have been approved by the court, if you happen to raise your sign, I'll note it for the record, but I'm not going to ask you for any type of argument on that because we've already had that opportunity to do so. It will take me some time to read through the instructions. I don't know if that will take us to the lunch hour or not. The state should be potentially prepared to go through its opening. Mr. Brooks, if we do get to that point where the state is giving its opening, and you have an objection, you need to write down the objection in addition to raising your hand, and I will rule on the objections after the closing statement. So you must write down the basis for the objection and what you're objecting to, in addition to holding up your sign. That's the procedure that we will follow. All right, now we're on a short break until the jury comes in.
Hey, you're holding it backwards, stupid.
as a juror and how you should conduct yourself during the trial. Your duty is to decide the case based only on the evidence presented at trial and the law given to you by the court. Anything you may see or hear outside the courtroom is not evidence. All people deserve fair treatment in our justice system, regardless of their race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. People make assumptions and form opinions from their own personal backgrounds and experiences. Generally, we are aware of these things, but you should consider the possibility that you have biases of which you may not be aware, which can affect how you evaluate information and make decisions. You must carefully evaluate the evidence and resist any urge to reach a verdict that is influenced by any bias for or against any party, witness, or attorney. Personal opinions, preferences, or biases have no place in the courtroom, where our goal is to treat all parties equally and to arrive at a just and proper verdict based on the evidence. Do not begin your deliberations and discussion of the case until all the evidence is presented and I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging or social networking sites to send or receive any information about this case or your experience as a juror. We will stop or recess from time to time during the trial. You may be excused from the courtroom when it is necessary for me to hear legal arguments from the parties. If you come in contact with the parties, lawyers, or witnesses, do not speak with them. For their part, the parties, lawyers, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene, either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics, applications, or tools with communication capabilities to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by other means. If anyone does so despite you telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After the trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report it to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. You are not required to, but you may take notes during the trial, except during the opening statements and closing arguments. The court will provide you with the materials. In making notes, you must be careful that it does not distract you from carefully listening to and observing the witnesses. You may rely on your notes to refresh your memory during your deliberations. Otherwise, keep them confidential. After the trial, the notes will be collected and destroyed. You will not have a copy of the written transcript of the trial testimony available for use during your deliberations. You should pay careful attention to all the testimony because you must rely primarily on your memory of the evidence and testimony introduced at trial. During the course of a trial, the parties may refer to or use police reports with witnesses. Normally, these police reports will not be provided to you. If you are not provided with a police report, you should use your collective memory regarding any reference to police reports. The defendant has a constitutional right to represent himself. I have advised the defendant that the same rules apply whether a lawyer acts for him or he acts for himself. The defendant has decided to represent himself, and this decision must not influence your verdict in any manner. This court is tasked with ensuring the orderly administration of the case. My job includes making sure that the defendant's rights are protected, making sure that the state and the defendant can present their respective cases in a coherent and orderly fashion, and that victims, witnesses, and the public are appropriately treated in the courtroom. All parties in the courtroom, including the attorneys, the litigants, witnesses, the judge, the jurors, and those in attendance are expected to conduct themselves appropriately and in a manner that avoids creating disorder or disruption, as well as conduct themselves in a manner that demonstrates sensitivity to the necessity of preserving decorum and the integrity of the judicial process. At the moment, Mr. Brooks is appearing from another courtroom. This must not influence your verdict in any manner. Evidence is defined as, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offenses before you may find the defendant guilty. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. Parties for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence, which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of a party, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and of the weight of the evidence. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Remarks of the parties are not evidence. If the remarks suggest certain facts not in evidence, disregard the suggestion. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. In your determination of credibility, you must avoid any and all bias based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. There's no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. The defendant is charged with 6 separate counts of first-degree intentional homicide, use of a dangerous weapon. The first count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Virginia Sorensen with intent to kill that person and while using a dangerous weapon. Contrary to sections 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The second count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Leanna Owen with intent to kill that person and while using a dangerous weapon, contrary to Sections 940.01, sub 1, sub A, 939.50, sub 3, sub A, and 939.63, sub 1, sub B of the Wisconsin statutes. The third count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Tamara Durand with intent to kill that person and while using a dangerous weapon, contrary to Sections 940.01, sub 1, sub A, 939.50, sub 3, sub A, and 939.63, sub 1, sub B of the Wisconsin statutes. The fourth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Jane Coolidge with intent to kill that person and while using a dangerous weapon, contrary to Sections 940.01, sub 1, sub A, 939.50, sub 3, sub A, and 939.63, sub 1, sub B of the Wisconsin statutes. The fifth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Wilhelm Hospital with intent to kill that person and while using a dangerous weapon, contrary to Sections 940.01, sub 1, sub A, 939.50, sub 3, sub A, and 939.63, sub 1, sub B of the Wisconsin statutes. The sixth count of the information in this case charges that Darrell E. Brooks.
He had been in jail for running over his girlfriend. He ran over her leg, right, Judy? I think, right? He had a fight with her, got in the car, ran over her leg. So he was in jail for that, got out on bail. His mom paid his bail. Then he was not supposed to be there. She was in a sober living house, and he went over to where she was. He was not supposed to be there. So that's why he's charged with the bail jumping. Because this was a different town, so he was not supposed to be over there. And I forgot why he went over there to see her. To get money from her or something, I think. It was Abuse House. I thought it was a sober living house. Anyway. So he went over there to talk to her. They got in a fight. He got mad. Okay, battered woman shelter. He got mad because she wouldn't give him the money or whatever it was that he wanted. And they had barricades up for the parade that was ongoing. And instead of trying to go another way, he was pissed off and he just drove right through the barricades and through the parade intentionally and did not stop and just plowed people down. And you will hear in the trial, he keeps asking people, but didn't you hear a horn honking? Doesn't that usually mean that the person sees you and wants you to get out of their way? So, that's what he wanted? Oh my God! I didn't know that's what he wanted her to pay his mom back the bail money. I didn't know that. Oh my God. The audacity. Why am I surprised? Oh my God, the audacity. He was in jail for running her over, and he wanted her to pay the bailment. Oh my God. And then he got to question her on the stand. No, he wasn't after certain people. He was just so pissed off that he wanted to drive down the road he wanted to drive down and didn't care who he hit. But it was intentional. He intentionally hit people. So that's why it was intentional. And he said, but I was honking my horn. I was warning them to get out of my way. No, that's not how that works. When there's a parade and the street is blocked off, that means you cannot drive. So honking your horn doesn't count. Like, I don't know how many cops tried to stop him. They shot at the car, even, I think, if I remember correctly. So, no. You can't just honk your horn and drive wherever you want to. So if you're going the wrong way down the street, do you get to honk your horn and say, watch out for me? No, that's not how that
On or
works.
about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Jackson Sparks with intent to kill that person and while using a dangerous weapon, contrary to section 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The defendant has entered a plea of not guilty to each one of these charges, which means the state must prove every element of each offense charge beyond a reasonable doubt.
I didn't watch the videos.
First degree intentional homicide, as defined in section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of any count of first degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present with respect to that count. One, as to each count, the defendant caused the death of the victim named in that count. Cause means that the defendant's acts was a substantial factor in producing the death. Two, as to each count, the defendant acted with the intent to kill the victim named in that count. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a...
You know, I think he's so stupid. I don't think he intended to kill anybody. I think he's just that stupid. I'm not saying he shouldn't be in prison. I just think he's that stupid that he thought he could drive with all those people there and they would get out of his way. I just think he's that stupid.
A week, a day, an hour, or for even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found. If found...
But after he hit the first person, he should have stopped instead of continuing on and hitting more people. Like, if he was a good okay, let's play devil's advocate and say, okay, he was blind with rage and he just thought he was gonna swerve around people and go through the parade. And then he hit the first person and realized, oh crap, what have I done? He would have stopped and then got out and been like, oh my God, I'm so sorry, and helped or whatever. No more people would have died. But no, he kept going and plowed through, and it wasn't like 60 something people. Well, the thing was, I think, I don't know for sure because I didn't watch any of the videos. Didn't he come up behind the parade, Judy? So they didn't see him coming. I think. He came up behind the parade though, right? So they didn't see him coming? Or was he going towards them? Yeah, that's what I thought. He was coming behind them. And yeah, that's what he keeps saying. But I was honking my horn. So? You weren't supposed to be there. It was a parade. They weren't looking for a car honking their horn to move out of the way for.
At all from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction,
Trying to get the
proof
bailiffs
of
to go
motive
tell her?
is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. The information alleges not only that the defendant committed the crimes of first-degree intentional homicide.
Oh, and sorry to keep pausing, but I just remember this. If this had happened in Florida, his mom would have been charged too because it was her car.
But also that the defendant did so while using a dangerous weapon. Dangerous weapon means any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. Great bodily harm means serious bodily injury. If you find the defendant guilty of a count of first-degree intentional homicide, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime of first-degree intentional homicide while using a dangerous weapon. If you are not so satisfied, you must answer the question, no. If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count one, you should find the defendant guilty of first-degree intentional homicide as charged in count one. If you are not so satisfied, you must find the defendant not guilty as to count one. If you find the defendant guilty of count one, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count two, you should find the defendant guilty of first-degree intentional homicide as charged in count two. If you are not so satisfied, you must find the defendant not guilty as to count two. If you find the defendant guilty of count two, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 3, you should find the defendant guilty of first-degree intentional homicide as charged in count 3. If you are not so satisfied, you must find the defendant not guilty as to count 3. If you find the defendant guilty of count 3, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 4, you should find the defendant guilty of first-degree intentional homicide as charged in count 4. If you are not so satisfied, you must find the defendant not guilty as to count 4. If you find the defendant guilty of count 4, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 5, you should find the defendant guilty of first-degree intentional homicide as charged in count 5. If you are not so satisfied, you must find the defendant not guilty as to count 5. If you find the defendant guilty of count 5, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 6, you should find the defendant guilty of first-degree intentional homicide as charged in count 6. If you are not so satisfied, you must find the defendant not guilty as to count 6. If you find the defendant guilty of count 6, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? The defendant is charged with 61 separate counts of first-degree recklessly endangering safety, use of a dangerous weapon. The 7th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Nicole White under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes.
Hey, John.
The 8th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Eleanor Anders under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 9th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Sasha Catalan Castillo under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 10th count
What?
of the
He's putting it
information
in his
this
pants?
case charges
What
that
the heck?
Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main
was
Street
gonna fast
in the
forward
city
through
of
this,
Waukesha,
but I don't think I am
Waukesha
now.
County, Wisconsin, did recklessly endanger the safety of Maura Gilchrist under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to Section 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 11th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Justin Gullickson under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to Section 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 12th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Harry Guilfoyle under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to Section 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 13th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Aiden Loughran under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to Section 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 14th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Theo Mazza under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to Sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 15th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Tyler Pudliner under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to Sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 16th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Connor Tank under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to Sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 17th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Eric Teagues under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to Section 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 18th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Adelia Mathioli under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to Section 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes.
Is he going to sleep?
The 19th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Kelly Graybow under circumstances which show utter disregard for life and while using a dangerous weapon, contrary to Sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 20th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Josh Craner under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to Sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 21st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Riley Rogers under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to Sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 22nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Caden Rogers under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to Sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 23rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Tucker Sparks under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to Sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 24th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21, 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Isabella Bartelt under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to Section 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 25th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Yuritsa Becerra Montez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to Section 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 26th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Samantha Colo under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 27th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Madison Hollingsworth under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 28th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Mackenzie Hollingsworth under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 29th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Mitchell Lampine under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 30th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Kathleen Pielmeyer under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 31st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Julia Shulikau under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 32nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Olivia Stover under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 33rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Jennifer Stover under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 34th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did endanger the safety of Jesselyn Torres under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 35th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Alice Uriel under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 36th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Charlotte Uriel under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 37th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Vivian Uriel under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 38th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Grayson Uriel under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 39th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Lola Hospital under circumstances which show utter disregard for human life and while using a dangerous
I thought it would be funny to watch. I was going to skip it and then he put the objection sign in his pants.
939.50 sub 3 sub F, and this weapon, contrary to sections 941.30, not guilty as to count 14. If you find the defendant guilty of count 14, you must answer the following question, yes or no. Did the defendant commit the crime of satisfied beyond a reasonable doubt that all three elements of first degree that we are in recess.
Thank you.
Now we're in recess. For how long? Did that go all the way up to the lunch break? So is he gonna change clothes and come back and make a? Did he make an opening statement? Oh no, he's still in his orange. He makes an opening statement in his prison clothes.
Mr. Brooks know that he certainly could take the opportunity during the lunch hour to put on street clothes. So it's his choice. He is here in the jail attire. He's at the table, continues to be masked. Welcome back, Mr. Brooks.
They never asked me during the break because I had so much other stuff going on. I'm not sure. I'm not saying it was intentional on their part, but I was never asked. I just want to make that clear for the record.
Thank you. I appreciate that clarification. Nonetheless, I provided you with that opportunity, and here you are. Please be mindful, sir, that the right to be here can, of course, be lost if you engage in disruptful, discourteous behavior, if you interrupt the decorum and do not show respect for the judicial proceedings, you would, of course, be subject to removal and forfeiting your right to be present in this courtroom. All right, I'd like to bring the jury out, Mr. Brooks. I am still going through the preliminary jury instructions. I know you filed some objections. Those have been noted for the record, as I advised earlier this morning. Because I've approved of them, there should be no objections. You had ample opportunity to do that. So I'm instructing you at this point not to object, because I will consider whether that's being done for disruption. If you have an objection, write it down on a piece of paper, pass it to the bailiff, and I'll take it up outside the presence of the jury.
Just so I'm clear, are we talking about objections to strictly jury instructions, or the filings that I filed on the 3rd?
I'm not addressing those at this point, sir.
I was just asking for clarification. I didn't know which one you were speaking on as far as the objections.
I'm talking about objections during this court hearing to the court going through the preliminary jury instructions.
Okay, I was just asking for clarification.
I'm not addressing any of those filings. I previously addressed those. It may not be to your satisfaction, but
Remember what you said, to be honest about those.
and I'm not going to repeat myself. So the record speaks for itself. Your objections in those filings, to the extent, whatever they are noted. They're part of the record, and they will be available for you at a later point in time should you be convicted and on appeal to make whatever arguments that you need to or want to regarding those. But from my perspective, that is something I'm not going to take up any further. And any attempt by you to do that, I will have to consider whether that's being done to disrupt the proceedings and not for legitimate reasons.
My only reason for bringing it up was to make sure that they are offered into evidence.
Sir, we're not at the evidentiary phase. They're part of the record. They've been received. So at this point, there's no evidence to be taken. We're not at that stage of the proceedings. So you will have an opportunity after the state presents their case in chief and they rest, to then present your case and to present evidence that's relevant to the issues before the court and the jury. So I'm not going to go through any further on what that means. That would be for me to provide you with an explanation of the law or procedure, but I expect you to not bring that up at this point in time or going forward.
I don't understand, though, Your Honor.
Mr. Brooks, I've already addressed them. I'm going to bring the jury out. Please do not disrupt as the jury comes in and as I complete reading the preliminary instructions. I am, just for reference for everyone, I've read through 44 pages of 69, and so I still have a ways to go. My intention would be to finish with the preliminary jury instructions, take a short break for all, including the jurors, and then come back with opening statements. And that's, you have a choice, sir, at that point, whether you want to give one, but the state goes first because they obviously have the burden of proof. And then you would have an opportunity to give an opening statement as well. But that's my plan, at least for the afternoon.
Over there, Your Honor.
You would like to, you're asking that to voluntarily be taken to that courtroom.
I'm trying to seek to understand how the testimony evidence that was given could be
Mr.
considered
Brooks, I've already
evidence.
dealt with that. I'm not going to deal with it. If you want to go to that courtroom, are you waiving your right to be present right now?
Can I at least raise the issue of subject matter jurisdiction? That's still
No, there's no lawful motion before the court. You may not.
Are you making a judicial determination that I cannot?
Mr.
bring
Brooks,
that?
I'm going to bring the jury out. I'd like you to stay. That's my preference that you stay. You've certainly demonstrated throughout these proceedings that you have the capacity to follow the rules, that you have the intellect to make cogent, coherent, articulate, responsive arguments when you so choose. But when you start doing what you're starting to do right now, going back to filings I've already addressed, and start talking about subject matter jurisdiction, that is a tactic by you that I believe is to disrupt and to delay the proceedings.
That is not accurate, Your Honor. I
Your
respectfully-
objection to my characterization of that is noted.
I would like to make a motion for finding the fact then.
Your request is denied.
On what basis?
Your request is denied, sir.
Your Honor, I'm merely seeking to understand on what.
Mr. Brooks, I refer you once again to document 244 that you signed, that you acknowledged, dealing with the right to, waiver of right to attorney. We went through all of the advantages, the disadvantages. You were advised of things, including the charges that you face, the penalties that go along with them. We discussed the difficulty of representing yourself. You made a deliberate choice to waive your right to an attorney, which this court honored and granted.
That is inaccurate
And
because
you,
I
Mr.
altered
Brooks,
the
don't
contract.
interrupt me. Okay, now that's at least the second time. So don't interrupt me. I'm going to continue with these proceedings. Even though you're mild-mannered, even though you're speaking in a soft tone of voice, the conduct still has the same effect. And that's to disrupt, to delay, and to show disrespect for the court proceedings.
It is not. It is not my
Mr.
intent.
Brooks,
It is not my
please,
intent.
I'm not going to force you to sit down. You're welcome to sit down, but I am instructing the jury to come out. You, at your peril, run the risk of me admonishing you in front of them at this point. I don't want to do that, sir.
I'm seeking to merely understand.
Sir, I cannot give you legal advice. I cannot give you the understanding that you want.
I'm
All
not
right?
asking for legal advice.
I cannot explain court procedures or the law to you. So with that, Mr. Brooks, that's another interruption. You keep going. Stop.
I'm seeking merely to understand, Your Honor. I don't understand the nature and cause of the charges.
Mr. Brooks, I've already dealt with these.
I'm trying to bring up the subject matter
Mr. Brooks,
jurisdiction.
if you keep interrupting me, then you will forfeit your right to be present because you're showing through your conduct that you will not follow the most simplest rule of civility in a courtroom, and that's by not interrupting. You continue to interrupt. It's been a couple of minutes since we've been on the record, and there's been a number of times you've already interrupted me. You claiming to not understand and you wanting to discuss subject matter jurisdiction, do not, it's just a tactic by you. The fact that you are doing that demonstrates to me that you came back over here, right, with absolutely no intention of following the rules.
If that's what you want to say, that's your assessment. It's not accurate.
Well, my assessment will stand on the record, sir. It's based on my observations.
And
So
I
at this point, Mr. Brooks,
I respectfully object
stop
to that.
interrupting me, please.
I merely
Stop
just seek to
interrupting me,
understand.
sir.
I'm not. I was
If
in
you
the middle
have
of
an
saying
objection, write it down.
something. I thought that applied to me being.
It's
from
applying right
another-
now since you keep interrupting me while
So
I'm talking.
so what is the purpose of me being present if I'm not able to ask simple questions that I do not understand? I'm
Mr.
just
Brooks,
seeking.
I've been
I'm not
more
asking for
than
legal
patient
advice.
with you. And the issues that you keep trying to raise every time we're in here are not issues I'm going to raise at this juncture or address at this juncture in the proceedings.
Is
All
there a
right,
reason
I'm
why?
not giving you advice. I'm not explaining the law. I don't need to do any of that, sir. All right, you filed what you needed to file. I've addressed every single filing on the record. It may not be to your satisfaction,
That's inaccurate.
but I have addressed them.
That's
All
inaccurate,
right,
Your Honor.
some of your
With all
filings,
respect.
sir, you're interrupting me yet again because you're not letting me finish with my explanation. Some of your filings do not require a specific line-by-line response by the court. I've addressed them in the way that I believe the law requires me
can't
to
believe
do.
7
Again,
months
that may not
already.
be to your satisfaction, and that is simply the way that it's going to be.
It doesn't
But
have
we
to
are
be.
continuing on with the reading of jury instructions. It's important. They're going to come in, and it will be up to you whether you can demonstrate respect and courtesy, not only for these proceedings, but for the jurors that have been selected to hear this case.
Your
Madam
Honor.
Clerk, have the jurors brought in,
What
please.
you're doing is judicial misconduct. You're making the judicial determination that I'm not allowed to ask questions, and I'm not allowed to question Your Honor, which is my right. I've merely brought up subject matter jurisdiction because it has merit. I've merely tried to seek to understand the proceedings that I do not understand. You're rushing me to judgment by constantly removing me from the court when I should be present for all proceedings and I should be able to understand, which I do not. Once again, I do not understand the charges, the nature of the charges against me. I do not understand why Your Honor will not answer mere questions that would give me clarification on understanding. I'm not attempting purposely to be disruptive, disrespectful in any manner. But if I don't understand something, it benefits me to ask so that I can have clarity. The waiver that you speak of with the attorney, I gave the right the waiver back in the way that I felt that it should be altered. And you said so yourself on the record that the word understanding was taken off of that paperwork that I sent back to you. That should have let you know right there further that I did not understand the proceedings, and that is some of the issues that I'm bringing up now. It's merely just clarification, Your Honor. I don't understand what is going on. It's not to be disrespectful. It is not
Mr.
to
Brooks,
prolong the
Do
proceedings.
you
It is not to.
understand when I tell you not to interrupt me?
No,
Do you
no, I do not.
understand when I tell you you need to follow the rules of decorum? I believe you do. Please sit down. The jury's coming in.
I still would like to ask
Mr.
questions.
Brooks?
Your Honor.
Stop talking. We are proceeding with the continued advisement to the jury of these preliminary jury instructions. Do not interrupt me. The record should reflect that the jurors are entering the courtroom.
Your Honor, with all due respect. I
Mr.
still-
Brooks, stop talking. It's not appropriate at this point in time. You'll have opportunity
I disagree.
later to raise other issues, but the issues that you seek to engage with this court are issues I've already addressed.
You have not. You have not shown proof.
Mr.
that
Brooks,
you have
the
not
jury
shown.
is in the courtroom.
I understand that,
You
Your Honor.
continue to talk despite being told to sit down and to pay respect to this court, to these jurors, to the process.
It is my right to stand or to sit, Your Honor. It's my right.
Mr.
I'm
Brooks,
merely
you
exercising
can
my right.
stand, you need to be quiet. Thank
Your
you.
Honor, Your
Mr.
Honor.
Brooks, please stop. I'm going to continue with the instructions. If you interrupt me, you will run the risk of being taken to the courtroom next door.
I'm seeking to understand, Your Honor.
Mr. Brooks, final warning.
I'm seeking to understand, Your Honor. It must be some clarification.
Mr. Brooks, I want you here.
I want to
Stop interrupting me.
be here. You were quiet. I didn't.
Mr. Brooks, stop talking so I can read through the instructions.
Your Honor, can I?
Ladies and gentlemen of the jury, I'm going to continue with the jury instructions. I'm on count 38. If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 38, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 38. If you are not so satisfied, you must find the defendant not guilty as to count 38. If you find the defendant guilty of count 38, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 39, you should find the defendant guilty of first degree reckless endangering safety as charged in count 39. If you are not so satisfied, you must find the defendant not guilty as to count 39. If you find the defendant guilty of count 39, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 40, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 40. If you are not so satisfied, you must find the defendant not guilty as to count 40. If you find the defendant guilty of count 40, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 41, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 41. If you are not so satisfied, you must find the defendant not guilty as to count 41. If you find the defendant guilty of count 41, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 42, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 42. If you are not so satisfied, you must find the defendant not guilty as to count 42. If you find the defendant guilty of count 42, you must answer the following question, yes or no. Did the defendant commit the crime of first degree reckless endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 43, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 43. If you are not so satisfied, you must find the defendant not guilty as to count 43. If you find the defendant guilty of count 43, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 44, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 44. If you are not so satisfied, you must find the defendant not guilty as to count 44. If you find the defendant guilty of count 44, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 45, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 45. If you are not so satisfied, you must find the defendant not guilty as to count 45. If you find the defendant guilty of count 45, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 46, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 46. If you are not so satisfied, you must find the defendant not guilty as to count 46. If you find the defendant guilty of count 46, you must answer the following question, yes or no. Did the defendant commit the crime of first degree reckless endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 47, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 47. If you are not so satisfied, you must find the defendant not guilty as to count 47. If you find the defendant guilty of count 47, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 48, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 48. If you are not so satisfied, you must find the defendant not guilty as to count 48. If you find the defendant guilty of count 48, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 49, you should find the defendant guilty of first degree reckless safety as charged in count 49. Or no, did the defendant commit the crime of first degree recklessly endangering safety while using or death of a person and failed to stop the vehicle he was at, contrary to sections 940.19 sub. The next piece of paper filed at 1:52 p.m. says, are you making a judicial determination? I'm not allow my right under the First Amendment to freedom of speech in this courtroom. Mr. Brooks, we have rules of decorum and courtesy. They have been provided to you multiple times. They are part of the materials that you have before you.
Do they fall under the First Amendment?
SCR Chapter 62 discusses just the standards of courtesy and decorum for the courts of Wisconsin.
Jury still in the room while this is...
Whoa. Incident involved death to Jackson Sparks. The defendant is charged with two separate counts of bail jumping. The 74th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, having been charged with a felony and having been released from custody under Chapter 969 of the Wisconsin statutes, did intentionally fail to comply with the terms of his bond, contrary to section 946.49 sub 1 sub
Oh,
B
yeah, I hate
and
double negatives.
939.50 sub 3 sub H of the Wisconsin statutes. The 75th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, having been charged with a felony and having been released from custody under Chapter 969 of the Wisconsin statutes, did intentionally fail to comply with the terms of his bond, contrary to sections 946.49 sub 1 sub B and 939.50 sub 3 sub H of the Wisconsin statutes. Bail jumping, as defined in section 946.49 sub 1 of the Criminal Code of Wisconsin, is committed by one who has been released from custody on bond and intentionally fails to comply with the terms of that bond. Before you may find the defendant guilty of any count of bail jumping, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present with respect to that count. 1, as to each count, the defendant was charged with a felony. A felony is a crime punishable by imprisonment in the Wisconsin state prisons. 2, as to each count, first degree recklessly endangering safety, use of a dangerous weapon. Cause means that the defendant's act was a substantial factor in producing the bodily harm. We'll let you know when we bring you back in. Cause means that the defendant's act was a substantial factor in producing the bodily harm. Bodily harm means physical pain or injury, illness, or any impairment of physical condition. 2, the defendant intended to cause bodily harm to Erica Patterson. Intent to cause bodily harm means that the defendant had the mental purpose to cause bodily harm to another human being or was aware that his conduct was practically certain to cause bodily harm to another human being. 3, the defendant caused bodily harm without the consent of Erica Patterson. 4, the defendant knew that Erica Patterson did not consent. You cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent and knowledge. If you are satisfied beyond a reasonable doubt that all 4 elements of battery have been proved as to count 76, you should find the defendant guilty of battery as charged in count 76. If you are not so satisfied, you must find the defendant not guilty. An information is nothing more than a written, formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. The parties will make opening statements. The purpose of an opening statement is to give the parties an opportunity to tell you what they expect the evidence will show you so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. Before we have the parties before I give them the opportunity to make opening statements, I am going to excuse the jurors to address a few legal matters, give you an opportunity as well for a short comfort break. We'll let you know when we bring you back in.
Oh, I thought he said something before I said them out. Okay, I guess not.
think you'd be seated.
We'll go over these later. All right, how many pieces of paper do I have?
One got a little closer, that was.
A number of pieces of paper that Mr. Brooks wrote on. I'm gonna have them copied so the state can be aware of that and respond if necessary. So we'll just take a moment while those papers are copied.
We did call maintenance, did it not work?
I called them, but, all right, I'll call again.
We will follow up.
How many copies are you making? 2? Yep, okay. We'll make sure you have copies of the filings as well, so you know what will be discussed, or at least addressed in some fashion. But I need to provide copies to the state. Go ahead, sir.
I noticed that one of the jurors, the lady in the black that's closest to the screen in that corner chair over there, I recognize her from my initial appearance. She flipped me off coming in to my initial appearance and coming out. I know it's her for a fact. I've seen her about like I'm looking at you right now, so I know for a fact that's her. I don't want that to end up being an issue. Is this some type of way that could be addressed by Your Honor?
Mr. Brooks, you had an opportunity to exercise preemptory strikes and even to question jurors about that. You chose not to. So at this point, any issue you have with that juror is waived.
Okay, you do remember that I was not present in the courtroom. I couldn't see. All I can see from that courtroom in there is just you, Your Honor, and the prosecution's table. I can't even see the bailiffs. So it was no way for me to even see who the jury was. Obviously, I wouldn't know them by name. If I would have been able to see the jurors, I would have immediately addressed that.
I will make this one indulgence. I'll have the civilian bailiff ask that juror if she was in attendance at your initial appearance out of an abundance of caution. These are jurors, though, who with the jury questionnaires were also asked what knowledge they had about proceedings they watched or even attended. And no one, to my knowledge, has disclosed anything like that, but out of an abundance of caution, we will ask that juror if she was in attendance at your initial appearance. So for now, that's how I'll address it. I'll advise you of what her answer is later.
Do we know the number?
Do you know the number of the jurors, sir? They have numbers.
I just know that I can't see the number from here. I just know the chair she was sitting in.
Which chair, sir? Top row or the top or the bottom row?
The bottom row, the last black chair. Black shirt. She had the black shirt
They're all
on.
black chairs, sir. So
The last
chair
black
closest-
chair closest to the television.
Thank you, sir, because there are two sides, right? So it's the last chair on both sides. So I wanted to make clear. You're saying the chair closest to the television. Thank you.
I said that at the beginning, Your Honor.
Front row.
Quit being a
All
butthead.
right.
You ever heard
State have copies of the filings.
Yes.
flies with honey than with vinegar?
I will take these in order The first is a note from Mr. Brooks that was handed to Deputy Wittig at about 12:05. It says, "I would like my filings addressed, parenthesis, notice of special appearance, statement of particulars, both are by affidavit filed 10/3/22, which today is deadline to respond." Thank you, Mr. Brooks. I'm respectfully declining to respond to those filings. That's my decision, sir. Next.
Are you making a judicial determination that those have no merit?
Mr. Brooks, I have indicated to you on the record what I will or will not do.
I would like to motion for finding of fact.
Your request is denied. The next,
May Your Honor explain why it
Mr.
is
Brooks,
denied.
I'm gonna go through these one by one. If I feel the need to make more of a record, I will do so. The record will be available later on. If you think I've made an error, you can then raise that on appeal.
I know you're making an error, Your Honor.
Mr.
You wanna
Brooks,
explain
I'm
to
not
me
gonna
why?
have a debate with you right now. We
I'm
are
not-
continuing on. I'm giving you the courtesy to respond to each one of these things. That's how I've responded. I expect that you will, even if you disagree with my decision, sir, that you will respect it and we'll move forward. The next piece of paper filed at 1:52
I still would
p.m.
like a judicial, are you making a
says,
judicial
are you making a
determination?
judicial determination? I'm not allow my right under the First Amendment to freedom of speech in this courtroom. Mr. Brooks, we have rules of decorum and courtesy. They have been provided to you multiple times. They are part of the materials that you have before you.
Do they fall under the First Amendment?
SCR Chapter 62 discusses just the standards of courtesy and decorum for the courts of Wisconsin. In addition, sir, parties are able to file requests with the court. It's called a motion. A motion, however, is based in law. There is a citation to not only that law, but relevant facts, and there's a request for relief. While you have the right to present a defense, you do not have a right to disrupt the proceedings.
That was not direct,
And
disruption.
Mr. Brooks.
I was asking, will my First Amendment right, which is freedom of speech and the right to be heard in court, will that be honored by Your Honor? That's a valid question.
Mr.
Because
Brooks,
that's a constitutional
I have
right.
given you ample opportunity to present information, evidence, to question when we've had witnesses on the stand, but I expect you to follow the rules of procedure, the rules of evidence when presenting your requests.
I can't even
So-
get these admitted into evidence.
That's, Mr. Brooks, I cannot explain to you if you don't understand the basis and law for the denial.
You're right, I don't understand. But
So,
I was
but that
following-
doesn't mean we're going to have a
I was
discussion
following-
or
no,
a
I'm not
debate
trying to debate
about
with you,
what
but I
it
was
means, because we're
following-
not
I
going
was
to do
following
that.
the rules that you set
So the bottom
by
line is, I
writing
don't
and
feel,
sending-
Mr. Brooks, stop talking. I do
No,
not
I was
feel,
right. I was following the rules when you said that I had to make all
and you
objections
did, and I'm going through
in
them, so
writing.
let me, give me the courtesy of replying or responding to these. And please give me the courtesy that even when you disagree with how I answer them, that you will not interrupt me.
It's not about me trying to interrupt you, Your Honor.
Mr.
All I'm
Brooks,
saying
I'm
is,
going to address the next one,
what
so
you-
please pay
what you
attention.
were saying about decorum, I was asking, does that fall under the First Amendment? Because the First Amendment, which is my constitutional right, says that I have the right to freedom of speech and to be heard in this court.
Mr.
That's all I'm
Brooks,
really-
again, you have the right to present a defense, but that right is not unfettered.
But that's
That
the Sixth
right,
Amendment.
Mr.
I'm talking
Brooks,
about the First
you
Amendment.
are interrupting me. Stop.
Because you're talking about
No, because you're
talking about an
purposely
amendment that I'm
doing
not
this,
referring
so
to,
I
Your Honor.
can't get my reasoning
But
out.
I'm
You
not
make it
referring to the
incredibly
Sixth
difficult.
Amendment. I'm not referring to the Sixth Amendment.
Mr.
I'm referring
Brooks.
to the First Amendment, which clearly says that I have the right to freedom of speech and to be heard in the courtroom. Are you not going to honor my constitutional right, Your Honor? If not, that is judicial misconduct, and you're making a judicial determination to not honor my constitutional right. I just want to be treated fairly, like anyone else, which you said on the record that you will be fair and impartial. What
Mr.
you're
Brooks,
doing
you
is
also
not
have
fair
an
and impartial.
obligation to treat this court fairly, and you have an obligation to follow the rules of courtesy and decorum, the rules of procedure, the rules of evidence.
Your Honor, I did
That's
not-
the playing field that you willingly entered into and made a deliberate
did not.
decision to waive your right to an attorney
I
and
cons-
to appear
I
in this
consented-
case
I
as your own
consented
attorney.
to represent myself pro per. The same paperwork that you gave me, you have, and I also have a copy of the same one where I scratched out what I did not agree or consent to. We both know that, Your Honor.
Mr. Brooks, I made findings regarding that, and those findings stand, that despite you scratching out some of those words on
But-
there, I
but
made
you-
very specific findings about your waiver of right to an attorney. So we're not going to relitigate that here right
You also
now.
accepted the terms of the paperwork that I
Mr.
filed out.
Brooks, I'm not going to engage with you about whether you and I have entered into some type of a contract.
We did not.
Or engage
We
in
did
any
not.
type of
We
that
did not
kind of
enter into
dialogue.
any
Because
contract.
that's what you're claiming through some
No,
of these
I'm not.
filings,
I'm
and
not
you've
claiming-
said that
I
previously.
am not claiming that, Your Honor.
So,
In any way, shape,
Mr.
or
Brooks,
form,
I am
do not
giving you
consent to
some
any
leeway.
contract.
You continue to talk over me. I'm asking you to follow the rules of civility. Simple rule, sir. Don't interrupt me.
Did I not just let you read the whole jury instructions and follow the rules that you said I have to write down?
You did.
Anything that I object to and then hand it in.
Except now that we're discussing them, it seems to me that the rules don't quite matter to you, sir.
No, that is not what's
So,
being asserted on my
here's what's
end.
happening, sir.
All
I'm
I'm-
telling you,
all
I'm
I'm asking
advising
for-
you to respect the rules. I'm advising you that if you continue to interrupt, you risk forfeiting your right to be present in this courtroom.
Are you,
Because I still need to continue with these proceedings, sir. I need to go through all of the documents that you filed, and you're not letting me do that.
because we didn't
So
get
I'm
past
gonna,
the
if I
issue.
need to, I'll remove you to the other courtroom so that I can do this.
This is-
And yes, exercise the mute button, sir.
This
But,
is-
and
this
then
is
I'll bring
something
you
that was
back on the
filed, though.
jury's back.
This was filed though, Your Honor, and it's a valid.
Mr. Brooks is
it's valid.
clearly not, following the simple rule of civility that I have established.
That's
He
inaccurate,
continues
Your
to
Honor.
interrupt. He's not providing this court with
inaccurate, Your
ability to make rulings on the record without interruption. So this is your final warning, or you will be removed to the other courtroom.
Will Your honor my First Amendment right?
I'm
Or are
not
you
answering
making
that
it- or are
question,
you
sir,
making
because
it-
I've already addressed
So
it.
you're making a judicial determination to deprive me of my constitutional
I am not
right.
making any such determination,
So
sir.
you just said you're not gonna answer the question about my First Amendment right, which says
Sir,
that
I've
I have
already
freedom of
answered the
speech.
question that you have a right to present a defense.
That is the
You have
Sixth
a right
Amendment,
to
not
be
the First.
present.
You're trying to
You
twist up the
have
amendments.
a right to present your defense, but your rights are not unfettered.
Yes, they
Your
are, Your Honor.
rights-
You're citing the Sixth Amendment, which I am not
Mr. Brooks,
questioning.
your First Amendment in some respects is circumscribed by the rules of evidence and the rules of procedure.
Does it say that I have
So that
freedom
doesn't
of
mean you
speech?
get to say anything that you want in
No,
front of a
I'm-
jury.
Your
And it
Honor.
doesn't mean you get to put forth any kind of evidence that you want in
Your
front
Honor,
of a
am I-
jury.
am I
What it
being-
means, sir,
am I
is
being
that you
disrespectful?
must
Am I
follow,
calling you
yes,
out
you're
your
being
name? Am I threatening
disrespectful because
anybody?
you're
I'm
not.
not doing anything that
All right, he is continuously talking over me. So at this point, I'm gonna find that he's forfeit his right to be
I have
present
not
as I
forfeited
go
my right,
through
Your Honor. I have
his
not consented to any, I'm
his
simply trying to
paperwork. He's to be
understand
removed to the other courtroom
I'm
until
simply
such
trying to
time as he
understand
can pledge to
why we're
follow
not
the
talking
rules
about
of
the First
decorum and
Amendment. I'm not
civility.
talking about the
We'll be
Sixth
in
Amendment.
recess until we have
Your Honor, I
everything
do
set
not
up.
agree to a
The record
stop.
to reflect, I'm stepping off. The
Stupid.
A second one, 1:52 p.m., today's date, October 6th. And then there's another 1:58 p.m., October 6th. 2:03 p.m. October 6th, and then looks like the time is 14:28, so 2:28. The other one was received. Mr. Brooks, I'm going to make a record first as to why you've been removed, and then I will hopefully get to the filings. I need you to not interrupt me at the moment. You are unmuted. But after the court completed the preliminary jury instructions and the reading that is to the jurors, I excused the jurors so that they could take a break, but also because I knew there were a number of what I will loosely refer to as objections that were raised by Mr. Brooks. I wanted to take an opportunity to address those first before moving on to opening statements. As I attempted to address those with Mr. Brooks, there was, from my observation and opinion, and I'll make a finding that it was pretty much a consistent talking over me by Mr. Brooks. I wasn't able to really go through any of these filings with any specificity. I attempted to go through the first one, which I did. I mean, I did tell him I wasn't going to address that. And then we were talking about his second one when really it kind of devolved from there. The record is very clear that Mr. Brooks has been advised on multiple occasions of my expectation regarding courtesy and decorum in this courtroom. I've referred to at many times that there's a very simple rule of civility I expect him to follow at a minimum, and that is to not interrupt. It shows a complete and utter lack of respect for the court process, the court proceedings. It interrupts the court as the court is attempting to make a record of what is happening and decisions that I am making. And after repeated warnings to him, the court made a determination that he had forfeited his right to be present in the courtroom while we discuss his filings. The record will reflect that Mr. Brooks did not give consent. I am still continuing with my findings, sir, so I'd ask that you not interrupt me. Mr. Brooks, I'm not done. I'm going to mute him because frankly, can be difficult to keep one's train of thought when you are consistently interrupted, which is why I believe he engages in the conduct that he does, because it's plain and simple. It is disruptive. It disrupts my thought process. It disrupts the proceedings. I was so pleased, Mr. Brooks, when you were able to follow the simple rules when the jury was here and I was going through the jury instructions. I know you had some objections. You wrote them all down. You followed that procedure. I told you I would take those up after I got through the jury instructions. I was attempting to do that, but then you started in with your antics, with your interruptions. It doesn't matter to this court if you're mild-mannered, if your tone of voice is a normal tone of voice, meaning it doesn't matter to me that you're not raising your voice, you're not making any threats or anything like that. That certainly would take things to the next level, in my opinion, but it's not necessary for this court to make a finding that your behavior is disruptive. And this obviously comes on the heels of your conduct this morning, where you spent the vast majority of the morning in the other courtroom based upon your conduct. And I'll once again rely on the decision in Illinois versus Allen, 397 U.S. 337, a U.S. Supreme Court case from 1970 on the options the court has constitutionally when faced with a disruptive defendant, someone like Mr. Brooks, who cannot conduct himself consistently with the decorum and respect that is inherent in the concept of courts and judicial proceedings. The consistent interruptions are not only disruptions, but it interferes with the proper administration of this trial. It disrupts the dignity, order, and decorum of this court. Those are the hallmarks of all court proceedings. I'll make a finding that he flagrantly disregards in the courtroom elementary standards of proper conduct by repeatedly interrupting this court.
I love Firefly.
And therefore, he has forfeited his right to be present while we discuss all of these filings. I'll also make a finding that the technology that we are utilizing here today, we are Polycom to Polycom. The audio and video have been working very well this afternoon. No issues with that, and that it's the functional equivalent of Mr. Brooks being in this courtroom. It gives him the opportunity and the ability to meaningfully participate while the court is still able to control his behavior by exercising the mute button, as I have repeatedly throughout these proceedings. I believe all of the documents speak for themselves, I should say, but what I will do is go through them one by one from the beginning. Since they're Mr. Brooks's filings, his position has been made known. I'll ask the state to respond. If I feel any additional follow-up is needed from Mr. Brooks, I'll ask him for that, and then I'll make a decision. So even if that's backtracking a little bit, it's a little bit easier to do that with him in the other courtroom. So the first one that I will deal with is the one that's got today's date and 12:05. I addressed it earlier in terms of that I did not believe it was a filing that required any court response, and I'll ask the state if the state sees any of that differently.
No, Your Honor, and I would cite the court's United States versus Benabe, B-E-N-A-B-E, at 654 Fed 3rd 753. It's a Seventh Circuit case from 2011. Specifically, there's very instructive language on page 767. This case involved a defendant who identified himself as a sovereign citizen. The court goes into a nice discussion as to such claims having no merit whatsoever. The quote is, the proposed sovereign citizen defense has, quote, no conceivable validity in American law. I think that's applicable to several of these filings here, Your Honor, and I think that's relevant authority throughout the remainder of this trial, that these sovereign citizen defenses have been attempted. There's a lot of cases on this. That's the most recent from the Seventh Circuit that I could find. In no way have any of these defenses, such as his name, the jurisdiction of the court, the fact that the state's an entity, any of these efforts that Mr. Brooks has tried to put forth have been soundly rejected by the courts, and there's significant case law on point, but that's the most recent and appears to fit really well with the facts of this case.
I would note the documents he refers to in this particular piece of paper references the notice of special appearance, the statement of particulars, both are by affidavit. Those are two of the common sovereign tactics, and I believe Benabe and the language that you cited is directly on point, and that is why I can simply deny the request to address those filings without any further discussion or hearing on them, even without giving Mr. Brooks an opportunity to further respond. The second statement, and I note he's raising the objection, and I'll indicate for the record he's objecting to what's being ruled upon. then the second filing, we heard him discuss at length, so I'll just have the state respond to that, and that was his claim that his First Amendment rights to freedom of speech are not being honored in this courtroom.
So the court has been abundantly patient in allowing Mr. Brooks to make appropriate, relevant legal arguments. The court is 100% accurate that no constitutional rights is absolute, and there is, they can be fettered under appropriate situations, and you've made an excellent record as to why that is appropriate in this case.
Mr. Brooks is raising his objection sign. Since he was given an opportunity to address this previously, I'm not going to give him further opportunity and simply indicate that he will be allowed at appropriate times under the rules of evidence, under the, to present his defense. It appears to me at times he may confuse the ability to file something into the record with the ability to present evidence. We have yet to start the evidentiary phase of this trial. In addition, any of his specific objections should be brought by motion, even if that's an oral motion at specific relief. His filings make claims that have no underpinning in law or fact. It's really conclusory. This court is under no obligation to address, conclusory statements by him that are not properly made, both in form and in substance. This record's replete references, instances of Mr. Brooks just simply spouting various amendments or theories without those fully being established in the record. And again, no constitutional right is absolute. The First Amendment rights of an individual can certainly be fettered. That is especially true in a court of law where there are rules of evidence, rules of procedure, where we have the standards of courtesy and decorum. He can present his defense. He has a right to present a defense, but his rights to do that must comport with the law, and that law is what I've already pointed out. So I'm not sure really how to address, are you making a judicial determination? Everything that I do when I rule on something is a decision that is made by this court. So I've answered this. We'll move on to the next one. That is and he is raising his objection, and that's fine. He can do that. His objection will be noted for the record. He also raises in the next filing at 158, I still motion to prove jurisdiction, please. Also motion to dismiss for no proof of jurisdiction. Also motion for finding of fact. Again, none of these things cite to any legal authority or any factual basis, nor do they request any specific relief. Here's what I will rely upon the Beneby decision from the Seventh Circuit, that these are just various arguments raised by sovereigns that have been debunked and have been addressed that have no place in our justice system. And therefore, I will deny the requests in that piece of paper summarily without further consideration. I know he makes repeated objection to either how I say his name or how it's referenced in the caption. There's a continuing objection that I will note. His filings speak for themselves, how he wishes to be addressed. This court will refer to the name that is on the information in this case. That is the official charging document. And that is what I will do. If I mispronounce his first name at times, my apologies. I know I said his name repeatedly throughout those jury instructions. I know when I first had hearings on this case, even his own attorneys referred to him as Darrell. And it was only after I viewed his recorded interview that I learned it was Darrell. I asked him at one hearing, how do I say your name? Is it Darrell? And he said, that's right, or words to that effect. I may not have the exact quote, and I'm not quoting him, but he confirmed for me on the record, at least at that point, what his first name was. So his continuing objection about his name is so noted. It's preserved in the record based upon his filings, and I'm not going to address it further. I frankly, his last document, which says a plea is to argue facts. I don't intend to do that, and I never agreed to or consented to a quote not guilty quote plea. My attorneys never got my consent for a not guilty plea. I don't understand. The law is very clear that a plea of not guilty, even when a defendant stands mute, is what the court proceeds with. It is true in this particular case that plea was entered on his behalf, but the fact also remains that in order for that plea to be changed to something else, meaning a guilty plea or a no contest plea, their waiver of rights form and have to knowingly, freely, voluntarily, and intelligently waive all of the rights that go along with that. In other words, this court is simply constrained by the law to proceed as if not guilty pleas were entered on his behalf. So I've addressed that. I don't need any further argument from the parties. I will note Mr. Brooks continues to have the objection sign raised. The other thing I want to make a record of, we did have the civilian jury bailiffs check with the juror that was identified by Mr. Brooks, and that juror confirmed she has not attended any proceedings. So that issue is addressed now. He's holding up his objection sign. Mr. Brooks, you know, I frankly did that for your benefit. You raised what really is an important issue, and I appreciate that. I was a little surprised by it, but then when I heard you explain further, I thought, you know, he's got a point there. He had been removed for some of those proceedings. You may not have seen her. I'm not making a finding on that, and so that's why I backtracked a little bit, said I would look into it. So I'm not sure why you're objecting at this point. I took an important piece of information that you were relaying, and we had it, in this case, it was confirmed that the juror did not attend any proceedings, and so that will address your issue with her. All right, now the next step would be opening statements. So, Mr. Brooks, you have demonstrated in the past, and I'm going to unmute you, that when the jury is present, you are able to maintain civility, show them respect, show the courts and the process respect and dignity. I certainly am willing to have you brought back over while the state gives their opening statement, and certainly if you choose to make an opening statement, for you to do that in this courtroom in the presence of the jury. I know you're holding up your objection sign, sir, but I am giving you the opportunity to come back over here. Would you like to come back to this courtroom? Record to reflect, he's holding up his objection sign. It appears that he's writing, I don't know what, of course. Mr. Brooks, I'm going to ask you again. Would you like to come back to this courtroom for opening statements?
This trial could have been so much shorter.
So I'm on the record.
But all
You are.
this crap.
If you would please address my question.
So you want me to come back over there just to get brought back over here?
That's not what I asked you, sir. I told you, I advised you I would like you back here. It's always my preference that you're here. You demonstrated previously that you can follow some rules. When the jury is present, the jury is going to be brought back in shortly for opening statements. The state will go first as they bear the burden of proof, and then you will be given an opportunity to also present an opening statement. So my question to you is, do you want to come back to this courtroom, sir?
So I can get sent back over here, because as soon as I say something, I'm gonna get sent out.
Mr. Brooks, it's your conduct in this courtroom. It is what dictates the court's response. If you follow the rules of decorum and courtesy and civility, you will remain. But if you choose to
You're
not
saying
do that, then you run the risk of once again forfeiting your right to be present.
You say that even though I never consented to being taken out. You say that everything is about the decorum and all this. That's what you say. But when I'm raising issues of understanding, which I keep telling you I don't understand, then it's looked at as being
Fired your lawyer.
disruptive. It's looked at as intentionally trying to be disruptive.
You are intentionally
And
being
I don't
disruptive.
understand why everything I say has to have some type of disruption title to it. It's even been put on record numerous times with inaccuracy. Even what happened today. Nobody reported on record about me being bruised up and having to get bandaged up and all these things, but it was put on me, laid at my feet as if me, quote unquote, being disruptive was deserving of what happened to me. I'm simply trying to have a fair trial. And if I don't, forgive me for being this way, Your Honor, but if I don't understand, I'm going to ask questions. That's the only way I can have clarity is by asking questions. And you have refused to answer anything, but I have to answer everything you ask me. Where's the give and take? It should be fair.
There is no give and take.
I'm not
It's a
asking for legal
trial.
advice. I'm not asking for nothing like that. I'm
Yeah, you
asking to
are.
simply have clarification so that I can understand. I cannot put on an adequate defense if I don't understand something.
You still can't put on adequate.
Do you see these
adequate
boxes I got right here? Do you think I was able to go through everything in those
Mr.
boxes?
Brooks, I'm not gonna go through this with you again, where you attempt to put on the record all of these issues that you have when we're in the middle of a trial. All right? You willingly waived your right to an attorney. I made all of those findings,
We
so
haven't
we
even
will go
got
You
forward.
made those findings,
I
but
am
the-
not
statements
obligated
yet.
to answer questions.
made
When you
those
ask me
filings.
questions, I'm gonna mute him.
Yeah.
I am not obligated to answer questions that explain procedure or the law. I am obligated to address motions to address that are based in law and fact. I'm obligated to address objections, for example, whether it be to testimony or evidence or questions posed to witnesses. But I'm not obligated, sir, to provide you with an explanation of the law, of the procedure. And with that, since I gave him two opportunities to answer a very direct question, and that was, do you want to come back to this courtroom? And he chose not to answer it, but instead ask a question and then start making statements about his lack of understanding. I will find that his non-response, that he has not answered directly, which to me says he's not willing to follow the rules of decorum and courtesy and civility, and without such a pledge, he will remain in that courtroom. He's muted. The record should reflect. It appears he's talking as well. He's making hand gestures. His lips are moving behind the mask. And I just wanted to make a record of that. All right. Then we will have the jurors brought in, and then the state can then proceed with its opening statement. That's a multi-count instruction, and so that's why you gotta look back way along the way. Oh, okay. Mr. Wichel's doing the opening. Okay, thank you. Thank you, Trish. Sure.
I know, I love her hair. She cut her hair though, Jill. It's like, I don't know if she let it grow back out, but it was like, she cut it off, it's like chin length and straightened. My hair used to be like that till I got old and it thinned. Now I have old lady hair. There's this hairstylist on YouTube that he recommends this. It's minoxidil, which is the hair growth stuff, which is actually thank you, Marty. It's actually a medication. Darn it, I forgot what it was originally meant for. But we had a patient when I worked in Pete's, a little boy that was on it, and he was covered in hair. He looked like the little Munster boy.
Be seated, everyone.
But this is a low dose of minoxidil, so you don't get hair everywhere else. It just puts it back on your head. I might try it. I don't know.
All right, at this time, we
My
will
doctor
give
told
the
me to
parties
take
the
B
opportunity
vitamins, and I'm
to
taking
make
B
opening
vitamins.
statements. Does the state have an opening statement?
It's not falling out anymore, but
And
it
just
doesn't
for the
seem to be
record,
getting thicker.
Mr. Brooks is appearing from the other courtroom. That should not influence your verdict in any way, ladies and gentlemen of the jury. Go ahead, Attorney Wichow.
Middle.
When we do that, make sure we confirm it should transmit, but we'll make sure it's transmitting over there as well. And if that's okay, if it happens, we may lose video of Mr. Brooks for the time being, as the state is using what appears to be a PowerPoint. Just confirm with me, Deputy Wittig, that when it starts, that it is able to be viewed and heard over there. Go ahead.
It was a cold.
They can't see it? All right, hold on. I may have to utilize this in my background, so it's... All right, let me do this. No one needs to leave. We're gonna go off the record though, so that I can set up another way to do this so that there's a share screen capability. Okay.
Yep.
Six people. He injured dozens more and left a permanent scar on this community. We are going to present evidence to you over the next several days in chronological phases, in order of events, from start to end. I'm going to take a few minutes. I'm going to lay out for you the table of contents of this story. We're going to set the scene with Sergeant Dave Warner from the City of Waukesha Police Department. Sergeant Warner was the highest-ranking police official working at the parade that day. He was the incident commander for the Waukesha Christmas Parade, and we are going to, with Sergeant Warner's help, take you through this, which is the first of 3 maps that we will refer to repeatedly throughout this trial. This map depicts the area that we're going to be talking about over the next couple of days, the parade route. Now, for those of you not entirely familiar with downtown Waukesha, this is going to look like a bunch of gibberish, but once we get going and we repeatedly refer to these street names and the business names and the groups that were involved in this parade, I think it'll become like a second language to you. Sergeant Warner will describe for you how the parade route ran from, if you look closely at the screens in front of you, the intersection of Main Street and White Rock Avenue. White Rock was a staging area for the parade groups and floats. And they made their way southeast on White Rock until they came to Main Street, and then they would make a right turn and head southeast down Main Street through the parade route until the very end as it wraps around to the south and runs into Wisconsin Avenue. The parade route then would continue to the east, making a left-hand turn on Wisconsin, but nothing really happens on Wisconsin Avenue. You're not going to hear any testimony about that. As you can see from this map, it depicts or represents each intersection where a squad car or a police officer was stationed. They're denoted by the little badge shields in the intersections. If you look closely, you can see little red lines, and Sergeant Warner will describe how those represent the barricades that were placed at each intersection for security and safety purposes. Once we've got that established, we're going to move into the first chapter of this story, and you're going to hear about the origin of Mr. Brooks' rage that day. A violent domestic argument with Erica Patterson, his former girlfriend and the mother of his child. Erica Patterson is going to testify either today or tomorrow, hopefully today. She's going to tell you that in November of 2021, she was staying at the Women's Center, which is a shelter here in Waukesha. And on the day in question, November 21st of 2021, in his red Ford Escape, and he argued with her. And he harassed her. And he punched her in the face. And the thing about a swollen eye is it's tough to fake. You're going to hear evidence about how after, let me back up. You're going to hear evidence about how the defendant took Erica Patterson all over town that afternoon. From Frame Park, across the river, up Barstow Hill, back down to Frame Park. And at some point, after she was struck, after she sustained that injury, Erica called her friends because she needed help. And she had no one else to call. One of those friends is Corey Runkle. You're going to hear from Corey on the witness stand in this trial. Corey's going to say that she was Erica's roommate at the Women's Center. She had known Erica for a few weeks and they had grown close. And when she got the call from Erica that Erica needed help, Corey immediately responded to help. And she ended up finding Erica and Darrell Brooks in front of the White Rock School. If we go back, the White Rock School is on White Rock Avenue. It's on near the top right portion of the map. It's just south of Frame Park. And Corey is going to talk about how she found Erica and the defendant at this location, and she got into both a physical and a verbal altercation with Mr. Brooks. That altercation is captured on surveillance video, 2 surveillance videos actually. You're going to see both of them. You're going to see how the defendant was reacting that day. You're going to see what he looked like, what he was wearing, the red Ford Escape that he was driving. You're going to see how the defendant reacted once Erica's friends showed up and he lost his physical advantage over a woman. Erica and Corey will also testify that at some point during this scuffle, the police were called. And you're going to see a separate video, squad video, from the responding officer that shows just down the block there was a marked squad car with its lights flashing, marking the entrance to the parade. Something that people in front of White Rock School would have seen. So the evidence is going to show that the defendant must have known, once things got loud and once there was more than just him and Erica on scene, the police were going to show up. So he took the coward's way out. You're going to see him in the video get into the driver's seat of that red SUV. Corey and Erica will tell you that no one else was in the car. And you're going to see him pull off on White Rock towards Main Street. You're going to hear from law enforcement officers who were positioned along the parade route. The officers who made their initial contact with the defendant, the first ones who tried to stop him. And the first one is Detective Tom Casey, the lead detective in this case. He's sitting at the state's prosecution table right behind me. He's going to tell you that he was working that day as security for the parade. He was working at Main and White Rock. He's the first law enforcement officer to come into contact with the defendant during this incident, face to face, or I think better describe it as face to windshield. He tried to stop the defendant, but there's only so much a man can do against an SUV. But he's going to tell you that he got so close, he got such a good look at Darrell Brooks's face that from that witness stand, he'll be able to say to you definitively, Darrell Brooks, the man in orange on the video screen, is the man who was driving the red SUV in this case. You're going to hear from a few more officers. Officer Bryce Butcher and Officer Sonia Schneider. They were positioned at the intersection of Main Street and East Avenue, just a little bit further southwest in that map. You're going to hear them describe how they saw this red SUV approaching. They quickly realized it was not part of the parade. They quickly realized this was a problem. There are people, children, in the street, lining the street. And so they jumped into action. They tried to stop it. As the SUV started barreling towards them, Officer Butcher, and again, tried to get in the way. He put himself at risk trying to get in front of the vehicle. Couldn't stop it. Officer Schneider tried to redirect the vehicle up Buckley Street, making a right-hand turn. She'll tell you, and you'll see in the video, there was room. There was space. She couldn't do it. The defendant blew past her. And that's when the screams in the police radio start. You're going to hear from Jim Hawkinson, a battalion chief for the Waukesha Fire Department. He's going to tell you about the massive scope of the emergency response to this tragedy. He was in charge of the fire department that day. He's going to tell you about all of the units that had to respond to the scene, the massive amount of resources needed to triage and treat and transport all the victims. He's going to tell you about the response from other communities in southeast Wisconsin, the mutual aid call that went out, and all the other communities that came to help out. He's going to tell you about how Waukesha Memorial Hospital, just up the hill from the parade route, quickly reached capacity, and so everybody had to be diverted to other medical facilities. We'll transition then into the next chapter of this story, and you're going to hear from some of the people whose lives were forever changed by the defendant's terrible decisions that day. But I'll tell you right now, you're not going to hear from all of them. It wouldn't make sense. It's not necessary. We intend to present the evidence to you in an efficient and streamlined way. We will elicit testimony and introduce exhibits that cover every element of every single criminal charge in this case. But our goal is to avoid duplication of evidence and to avoid undue hardship on the victims and the witnesses who have already suffered so much. So the first witness in this part of the trial that you're going to hear from is Nicole White. She's the very first person, aside from Detective Casey, who was struck by the defendant on that day. She's going to tell you, as we look at this second of the three maps that we're going to repeatedly refer to, that she was marching with her co-workers and friends with Remax. You'll recognize the float, I think, in the videos, because just like the commercials for Remax, there's a giant hot air balloon that shoots fire out of the basket, which is pretty cool. And she's going to tell you she was marching with her friends and her co-workers when, without any warning, she was hit from behind and knocked over. You're going to see video of that. Nicole White has a special significance in this case because, as the first person who was struck, she represents the point in time when Mr. Brooks was legally required to stop. You heard the judge read the hit and run jury instructions, and to summarize, in Wisconsin, anybody who's operating a motor vehicle who's involved in some kind of accident, they have a duty to stop, to investigate, to exchange information. Not only did Darrell Brooks not stop, the evidence will show that he sped up. The evidence will show that as his body count increased, so did his motive to get away. Nicole White, I think, is a good point here for me to explain to you, or to summarize for you, the charge of first-degree recklessly endangering safety. Now, again, the judge read the law to you all morning and a lot of the afternoon, and she's going to read it to you again at the end of the case, and you're going to have a binder with all these instructions written down for you, so you do not need to memorize them, okay? But we're going to talk about first-degree recklessly endangering safety. It's a crime where it's committed by someone who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. Let's talk about what the state's not required to prove with recklessly endangering safety. Not required to prove injury. This was a conscious decision in our charging decision. We're not going to get into medical records. We're not going to talk about the details of witnesses' injuries because it's not relevant, except to the extent that it proves that they were endangered and resulted in injury. But we don't need to get into who was hit or how hard or how long they've suffered. We just are going to prove to you that their safety was endangered. So, after Nicole White, we are going to talk, you're going to hear evidence about the first of the larger groups that was affected by this incident, the Waukesha South High School Marching Band. 10 kids in that band got either hit or run over. Here's the first example of our efficient presentation of evidence. You're not going to hear from any one of them. High school-aged kids, there's a video showing each and every one of them getting run over. So instead, you're going to hear from their band director, Sarah Waymire Aparicio. She's going to come in and she's going to look at some still shots of the video. She's going to identify each of the 10 kids for you. You're then going to watch and listen to the video, and it'll be clear as day who's getting run over or hit. It'll be clear as day whose safety was endangered by Mr. Brooks that day. As we move further down the parade route, you'll hear evidence about the Burris Logistics Group. You'll hear testimony from Kelly Grabo about how she was marching with that group along with her young daughter. You'll see video of them. They're dressed up like the Who's from Whoville. You'll see them get hit. As we move further down the parade route, you'll hear testimony about the Green family. They're spectators along the parade route. Charles Green is going to come in and talk about how he was there with his family. He was sitting on the southeast corner of Main and Gasper across the street from Martha Merrill's Books. He'll talk about how his kids were seated on a portable bench, something that you bring to a parade to sit on, and how they got knocked off that bench when the defendant ran into them. The next point in the presentation of evidence will involve the Waukesha Blazers. I think it's important to point out you can't consider this evidence of each crime in a vacuum. You need to consider the entire incident. Because at this point, by the time we get to the Blazers, the defendant will have already hit or run over 15 people. You'll see in the video that at this point the defendant has actually increased his speed, and you'll hear from Detective Mike Carpenter with the Waukesha Police Department. He's going to come in and talk about speed analysis. He'll tell you that he's certified to use a software program that basically takes surveillance video, measures the amount of time it takes to travel a certain distance in that video, and calculates an average speed over that distance. And he'll tell you that in video obtained from Bosco's Social Club, which is right in front of where the Blazers got hit, he'll tell you that that video in that area right before the Blazers got hit, the defendant was traveling in excess of 33 miles an hour. There were 5 victims in the Blazers. That includes Jackson Sparks, who was walking with his big brother Tucker. Cut down in the road before he had a chance to put any miles on his soul. Jackson was 8. He died 2 days later in the hospital. I think this is a good point to talk about the law of first-degree intentional homicide. Again, the judge provided the law to you. It'll be provided to you again at the conclusion of the trial. I want you to take a look at that second element. I don't know what the defense in this case is going to be. In fact, the defendant isn't required to put one on at all. He can sit there and not say a word throughout this trial, and that's perfectly within his right, and you can't hold that against him. And in fact, if he does that and we don't prove each and every one of these counts to you beyond a reasonable doubt, you must find him not guilty. That's the law. But if he does choose to present a defense, if he does raise any issues, I expect that he will likely claim that he didn't mean to kill these people. Take a look at that second bullet point. Keep that in mind as you're watching these videos, as you're learning about how this parade unfolded. Consider whether the defendant was aware that his conduct was practically certain to cause the death of another human being. We're going to move further down the parade route, and the next group after the Blazers is the extreme dance group. There were girls of really all ages in this group, from toddlers being pulled in strollers up to high school age teenage dancers. 15 victims, 15 people associated with this group either got hit or were very close to getting hit. That doesn't include 2 additional spectators who were watching the parade from the south side of Main Street near the 5 Points intersection, right in front of the extreme dance team as the defendant drove through. Girls in this dance group suffered catastrophic injuries. The group of victims also includes parents, grandparents, siblings, people marching with the group, but not necessarily as dancers. You're not going to hear from everybody who got hit. You're going to hear from the 2 instructors, the 2 young ladies who were tasked with teaching these girls these routines and marching with them and encouraging them and comforting them after the fact. And they're going to, in the video, identify for you where all these girls are positioned, and it'll be very clear the path of travel of the vehicle as it goes through that group of young ladies, who was hit and who was nearly hit. The next group down the parade route is Citizens Bank. And here we reach the second count of intentional homicide. Jane Kulik was marching with Citizens Bank with her friends, with her co-workers. This is the only count of homicide for which there is no clear video depicting how she died. So instead of watching video, you're going to hear evidence from her co-worker and from the man who was driving the truck pulling this float. And they're really the ones who are in the best position to observe exactly what happened to Jane Kulik as the defendant plowed through that parade route. And they're going to describe for you how she was struck, how she was run over. A medical examiner will explain that Jane Kulik's cause of death was multiple blunt force traumatic injuries.
Somebody crying?
We'll move further down southwest along the parade route, and we'll learn about a group that was standing in front of the steaming cup, spectators again. Innocent people have nothing to do with anything. You're going to hear about 3 kids who were standing along with a bunch of others along the curb in front of steaming cup. And as the defendant swerved from the left side of the street as he hit Jane, back to the right side of the street as he was avoiding the vehicle that was ahead of him, clipped the curb and hit these 3 kids. Then we're going to move in to the next group in the parade route, which is the dancing grannies. This is the deadliest point in the parade. 7 people in this group were struck. 4 of them died. You're going to hear from witnesses, members of the dancing grannies group, who will come in and they will describe being completely caught off guard. They will describe seeing pom-poms in the air, and the next thing they knew, there were bodies on the ground before the pom-poms hit the ground. You will learn about Bill Ospel, who was marching in a support capacity. He was there to support his wife Lola and their friends, the rest of the dancing grannies, just walking along the parade route trying to be helpful. And as the defendant swerved around the dancing granny's vehicle, which is a white SUV, you'll see it in the video, swerved around the right side, he hits Bill. And the medical examiner is going to tell you that Bill Ospel cause of death was multiple blunt force traumatic injuries. You'll learn about Tamara Durand, marching with the grannies. This is her first parade. You'll see a diagram of where she was positioned. You'll see video of her getting struck. The medical examiner will tell you that Tamara Durand, cause of death, multiple blunt force traumatic injuries. You'll hear about Lee Owen, another dancing granny, positioned right next to Tamara, who had just begun one of her favorite routines, walking in a winter wonderland, when she got hit. You'll learn about Ginny Sorensen. You'll learn that Ginny was walking at the front of the group carrying the banner. You'll learn that Ginny was normally a coach for the group. Normally she rode in the vehicle in the back so that she could provide feedback and critique to her dance mates. But she filled in at the last moment today and helped carry the banner. You'll see video of Ginny getting struck. The medical examiner will tell you that Ginny Sorensen's cause of death was multiple blunt force traumatic injuries. You'll hear more speed analysis testimony at this point. You're going to hear from Mike Smith with the Wisconsin State Patrol, who's going to testify very similarly to how Detective Carpenter is going to testify about speed analysis. Basically, he takes surveillance video, this time from Curry Insurance, which is on the south side of Main Street. It shows the grannies getting struck. They measure point to point and measure the time between those 2 points and calculate an average speed over that distance, which is roughly from Clinton Street up until the camera cuts out. He'll tell you that at that point, where the defendant crashed through the dancing grannies group, he was traveling at approximately 32 miles an hour. The eighth and final group that was struck by the defendant in this case is the Catholic Communities of Waukesha. This is a faith-based organization. It consists of members of multiple local Catholic churches who got together that Sunday afternoon to spread a little Christmas cheer. There is not great video, and perhaps that's for the best, of this group getting struck. In total, there were 19 victims in this group. In what little you can see from the video, you can see the defendant's taillights swerving from the left side of the street to the right. You can see them bouncing up and down. There are no speed bumps in that section of the road. The next phase of the evidence will involve the manhunt. How authorities found the defendant, took him into custody, and the statements he made after he was placed under arrest. You will hear from Officer Bryce Skolton, who was positioned, if you look at this third of the three maps I referenced, on the very top of this map, at the intersection of Main Street and Wisconsin. Officer Skolton was positioned at that point to direct the parade route to make a left-hand turn from Main Street onto Wisconsin, to stop any traffic coming from the other directions. He saw the defendant come around that corner. He saw the defendant drive right at him as he's standing in the middle of the road. And as the defendant went around him to the left and went south, Officer Skolton fired 3 rounds from his service weapon. All 3 rounds hit the car. None of them hit the defendant. you will hear from another police officer who was not on duty that day. He just happens to be a police officer. His name is Officer Ralph Salyers. He's from the Waukesha Police Department. If you take a look at that map, he's going to describe to you being on the sidewalk, leaving the parade. He was walking past Les Paul Middle School. He's going to describe hearing a loud commotion. He's going to describe seeing a red SUV with just utterly total front end damage coming to rest in a driveway at 338 Maple Avenue. You're going to see video of the defendant in the red SUV pulling into the alley behind 338 Maple. And then a few moments later, you'll see what appears to be the defendant coming back onto the screen and running away from the vehicle, apparently in a hurry, apparently aware that he had done something terribly wrong. You're going to hear from a series of witnesses between that point and the defendant's arrest, where they will describe the defendant approaching them, contacting them, asking them to use their phone. Because he was in such a rush when he ditched his SUV, he left his phones behind. Then you're going to hear from Daniel Ryder, and I think the evidence will show Daniel Ryder really is a good embodiment of the spirit of Waukesha. Not knowing what Mr. Brooks had done, Daniel Ryder opened his home to the defendant. The defendant showed up at his front door without any shoes on, with a t-shirt, said he was cold, said he needed to use the phone. Daniel Ryder let him inside, gave him a sandwich, let him use the phone, and then gave him a coat. And a few minutes later, the police showed up. You're going to see body cam video of that arrest. You're going to hear from Officer Rebecca Carpenter that she responded to that area around where Daniel Ryder lives because of reports of a man knocking on doors. She takes him into custody. He identifies himself on the body cam video. They search him, and in his pocket they find a key to the red Ford Escape used in this attack. You're going to hear from a series of officers who retraced the defendant's steps that night, recovered surveillance video showing the path that he took, the path that's depicted here in the third map that I'm showing you. You're going to hear how they recovered his sandal, his sweatshirt along the escape route. You're going to hear from Detective Jay Carpenter with the City of Waukesha Police Department, and he's going to talk to you about the defendant's statements after he was taken into custody. I'm going to let that interview speak for itself, other than pointing out for you that you will, I think, quickly learn a few main points about the defendant on the night that this happened. He was lucid. He was aware. He was intelligent. He was probing for information. And he was deceptive. We're going to then wrap up with testimony from people who plugged any of the remaining holes in the investigation. You'll hear from crime lab analysts about DNA evidence, about finding the defendant's DNA on the steering wheel of the red Ford Escape. You're going to hear from Wisconsin State Patrol Inspector Ryan Schultz. He's going to testify about the mechanical inspection that he did on this vehicle. In case you were wondering if there were any issues that would have prevented Mr. Brooks from stopping or from pulling over, he's going to quickly put those concerns to bed. He conducted that mechanical inspection. No problem with the brakes. The accelerator didn't stick. There were no mechanical problems that would have prevented Mr. Brooks from stopping. Finally, we're going to close our presentation of the evidence, not with a witness, but with an experience for you. You are going to go to a secure location, and you're going to have a chance to see the murder weapon with your own eyes. You'll be able to see that red Ford Escape. I want to close now with a few points about how the evidence relates to the law in this case. There are, obviously, we've gone through the 6 counts of first-degree intentional homicide, but in addition to those homicide counts, there are 6 counts of hit and run involving death. Those are separate charges. The evidence will support convictions on all of them, all 12 counts of homicide. But they involve the same 6 victims. Another point I want to bring to your attention is that for each count of first-degree intentional homicide and each count of first-degree recklessly endangering safety, if you find the defendant guilty of any of those counts, you have to answer a second question. Did he commit that crime while using a dangerous weapon? And here the evidence will show that he didn't use a gun or a knife to commit these crimes. He used 3,500 pounds of steel, rubber, and glass. The defendant's also charged with 2 counts of felony bail jumping. You'll hear evidence to support those charges, which includes the fact that the defendant was charged with a felony offense in a case in Milwaukee County and released from custody subject to conditions of bail. And then he was charged with another felony offense in a separate case in Milwaukee County and released from custody subject to conditions of bail. And those conditions of bail included requirements that he not commit any new crime. And those conditions of bail were in effect on November 21st of 2021. We have dozens of video clips to show you. You're going to have notebooks and writing utensils while we present this evidence to you. It's a lot to keep track of. And when you go back into the deliberation room, it might be difficult while you're deliberating to remember which video was about which victim or which incident or which group. And so my suggestion to you is that as we go through these videos, you're free to do whatever you want with your notes, but my suggestion would be as we go through these videos, they each will be labeled with an exhibit number. And so I recommend that you keep track of which exhibit number corresponds with which video. That way, while you're deliberating, if you want to see those videos again, you can ask for them by exhibit number. Can't guarantee that you'll be able to see any or all of them, but you can ask. I'm done now. I want to close on one final point, and that is, on behalf of the state of Wisconsin, I want to say thank you. You're serving in what is the greatest criminal justice system in the history of the world, and that's because of the 16 of you. It's because a group of citizens, randomly selected, come in and make the final, ultimate determination between guilty and not guilty. That's unique in this world. It's special. And so we're going to go through this evidence. We're going to be mindful of your time. We know how valuable it is. We're going to be efficient, but we have a lot to get through. A lot. And at the conclusion of all that evidence, District Attorney Opper is going to stand up here and she's going to ask you to render verdicts consistent with the evidence, to find the defendant guilty of each and every count. Thank you.
Mr. Brooks, my first question to you is, will you be making an opening statement at this point or deferring until your case, meaning the defense portion of the case?
I will be deferring at this time, Your Honor. I need a little more adequate time to make sure I go over the points that I need to make.
All right, then the court will honor that request, advise the jury he's deferring his opening statement until a later point in the proceedings. I am going to just take a short break so I can talk some logistics with the parties to determine whether it makes sense to start with a witness tonight yet. It's 4 o'clock, a little bit after, or wait until tomorrow. So either way, you'll come back because you'll either hear testimony or I'll read an instruction for you. But at this point, the jury may be excused. Let me ask it this way, sir. You may reclaim objections. The idea behind that is that you give me just a little bit of information so that I can either make a determination or, if appropriate, send the jury back out so that I can then hear arguments from the parties. Some objections really are one word, hearsay, maybe 3 words, calls for speculation, things of that nature. So if you're willing to abide by that procedure, then you can come back to this courtroom.
I can't really definitively give an answer right now to that.
So you're not willing to follow the rules of courtesy and decorum and procedure and evidence?
That's not what I said.
That's why I'm asking the clarification question, sir.
I was clear in what I said. I don't think I can make that determination right now.
Let me ask it this way, sir. You may reclaim your right to be present if you are willing to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. Are you able to do that, sir?
I thought I have.
Sir, it's I think, a fairly simple question. I'm asking you if you are willing to conduct yourself appropriately. I'll shorten it to that. Are you willing to conduct yourself appropriately, sir?
I have, to the best of my ability.
Sir, please answer my question directly. Are you willing to conduct yourself appropriately?
I have conducted myself appropriately.
I'm not asking about your past behavior. I'm asking if you're willing from this point forward, for the purposes of the testimony of 2 witnesses, to conduct yourself appropriately.
I have.
That's not my question. That's not the answer I'm looking for. I'm not asking if you have. I'm asking if you're willing, going forward, to conduct yourself appropriately during the questioning of these 2 witnesses. Yes or no?
I'm going to end up getting put back over here eventually if I come over there.
Mr. Brooks, I'm further advising you, I'm looking for a direct answer of yes or no, and that your failure to give me a yes or no answer will be considered by this court to be non-responsive. So let me ask you the question one more time. Are you willing to conduct yourself appropriately during the questioning of these 2 witnesses?
To be 100% honest, I cannot answer that.
All right, then based on that answer, which is non-responsive to the question that I asked, he has not given me a pledge or indication of a willingness to conduct himself appropriately going forward, and based on that, he'll remain where he is. You will remain unmuted, and so if you have an objection, you can lodge that objection within accordance or according to the rules of evidence, sir. All right, with that, let's have the jurors brought back in, and we'll start with the taking of testimony.
One quick second to put this up, then you're on.
Go ahead.
Thank you. I don't think it'll take long if you want to call for him. I'm difficult.
Let's
Non-responsive.
You did not answer yes or no.
Yeah.
All right, do we need to back out? Do I need, I wanted to see if the camera angle, so have them wait for a sec, please. Sorry.
So many times they would be coming in the door and he would start his crap. And
Not
she'd
going
have
to answer
say,
any other questions at
"Take
this
them back
point.
out."
The state's setting up a map for use with a witness. I want to make sure that it's something that is viewable on the witness camera that is being transmitted into the courtroom where you are seated. So let me back up.
The whole thing.
Let me back up, zoom out a bit. Attorney Opry, you want to look at the screen above and tell me if you think that accurately depicts what you're going to go over on that map? Do I need to back out a little bit?
Just a little, yeah, because the top of my hand's not showing here. Just a little.
Hold on. I'll go up. Do you think with where that chair is, the witness will
I would ask the witnesses to have to stand where I am so that everybody can see.
Oh, that would be a good idea.
Okay.
No, you're not muted yet. Mr. Brooks, if you're asking me to make a judicial determination, I've already rendered a decision about where you're going to be.
Because I didn't answer your question the way you wanted to.
All right, I'm going to mute you, sir. Now we're moving on to that part of the procedure since you are you're not following the protocol that I've set in place, that you are back to one of these sovereign tactics about have I made a judicial determination. The record speaks for itself, sir. I'm not going to make a further record on that, nor will I answer the question about am I making a judicial determination. I've made a decision, and that decision is you will remain in the other courtroom. Once the jury is brought back in, I will unmute so that you can lodge objections, but if you interrupt without making an objection and just start talking or start talking about a judicial determination, then I'm going to mute you once again. And the procedure for objecting will require that you raise your sign, write it out, and provide it to the bailiff, who will provide it to the court so that I can.
That's a good point. That's a really good point, because I have a problem with people who are disrespectful. I was taught to be respectful to people in authority. And I don't know if it was because my dad was a cop or because it's just the right thing to do. I don't know. But like watching body cam footage with Biggin, like the way these people talk to cops, that's just appalling to me. I would never, ever in a million years talk to a cop like that. It wouldn't even cross my mind to speak to a cop like that. My stepdaughter, one time we were at the county fair, and a friend of mine had pulled up into the parking lot, and she texted me that she was there. So I went out there to meet her, and I had a drink in my hand, and my stepdaughter kind of just like walked right outside the gate of the fair. I had walked out all the way out to my friend's car to get her and her granddaughter, because she was little, you know, to help her bring in like diaper bag and all that stuff. So I had my drink, and my stepdaughter like just walked like just right past the entrance, not like out to the car or anything, just past the entrance. And the guy said, "Oh, you can't take your drink back in there," because they didn't want people like going out to the parking lot and getting booze out of their car and pouring it in their drink and coming back in and getting smashed and, you know, and behaving badly. I got it, you know, and I was like, okay, well, I'll stand here and finish my drink and then go back in. So he said the same thing to Casey. Casey she didn't go out to the car. She just like stepped over the line, whatever. And he wouldn't let her go back in. So I said, "Give me your drink." 'Cause she like had walked back over. I'm like, "Give me your drink." And she snatched it out of my hand and said, "No, I didn't go out there," and turned around and walked off. And I was so embarrassed. Because, you know, as far as this guy knows, she's my kid. And I just wanted to say, I did not raise her. And he looked at me and goes, she'd be awful sad if she got kicked out of the fair, wouldn't she? And I was like, yeah, she would. I didn't know what to do. But there are rules for a reason. And yeah, she didn't go out to the car, but that doesn't matter. The authority was telling her she couldn't take her drink back in. Anyways, I'm getting off the subject. Anyway, I would have a really hard time if, now he's guilty, absolutely guilty, but what if he wasn't? That would prejudice my view of the man because he's so disrespectful and disruptive. That would prejudice me against him right there because he's such a pain in the butt. And he doesn't even seem to care. He knows he's guilty, and he knows he's going to go to prison for the rest of his life, and this is his, he's stalling. This he knows. After this, he's done. And he just wants to stay as free as possible, and to him, this is free. This is his last little, I'm not in a jail cell. So he's going to make it last as long as he can. And it's awful. And I feel so bad for Judge Darrow. And can you imagine? He's already behaved badly already before when he had attorneys. Can you imagine? I can't imagine the trepidation she must have felt when she realized she had to let him defend himself. Can you imagine? But she had to. Like, she had no choice. He has a right to defend himself. He has a right to represent himself. But can you know she didn't want to do it. But she had no choice.
Rule on it. If that slows things down, then so be it. But that's the procedure that I'm going to follow. All right, the jurors can be brought in then. As a reminder, I'm not requiring an all rise even for the jurors. I understand you may do it, but there's a reason why I'm not requiring it, so.
Well, can they see him? Can the jurors see him in this other courtroom? If they can't see him,
Will
then
he have the notebooks?
make everybody rise.
Oh, excellent. Thank you. You can start passing them out.
This guy. Judy, who is this guy? He sat there next to them through the whole trial. He works for the state. Excuse me, doesn't he? Oh, they can see him?
Ladies and gentlemen, you may have a seat, and the writing materials will be passed out. Our intent is to have the state call its first two witnesses. And then once that is done, I have an instruction to read, and then we'll break for the day, and I'll consult with the parties before I let you know what time you should report tomorrow.
I am going to speed this up.
And keep in mind,
I
my
think we're
time
gonna
I say
get-
we start for court might be different than your report time.
Okay,
All right.
I don't think we're going to get through the rest of this video today because it's already after 4:30. Do you want to quit now? You want to try to get through... He didn't do an opening, Ken. He deferred. Do you guys want to try to get through at least part of... Let's try to get through part of the first witness. I don't know how long the first witness is. Maybe we can get through all of it. I'm going to speed it up a little bit. If they talk too fast and we can't make it through the whole, I mean, if they're talking too fast and we can't understand them, I can slow it back down. But I'd like to get through a little bit more today. Because mainly all we've got today so far is his shenanigans. We haven't even got through any of the trial except for state opening. And we've been here 8.5 hours.
All the materials passed out? Very well. Then the state may call its first witness.
Thank you, Judge. State call Sergeant Dave Warner.
Good afternoon, Sergeant. If you would please make your way to the witness stand. When you get there, please remain standing. Raise your right hand, and my clerk, Teresa, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat, at least initially, or do you want him to stay standing?
No, actually, you can start out seated, please.
Very well. Sir, would you please state your first and last names for the record and spell each?
Yes. My name is Sergeant David, David Warner, Wanner.
Thank you. Go ahead, Attorney Opper, your witness.
Thank you. Sir, how are you employed?
I'm a patrol sergeant with the City of Waukesha Police Department.
How long have you worked in law enforcement?
18 years.
And as patrol sergeant, what are your general duties and responsibilities?
I oversee officers across all shifts that are assigned to the patrol division.
I want to direct your attention to the date of November 21, 2021. Did you work that day?
Yes.
Yeah, it would have been a quick case.
Were there any events occurring in the city of Waukesha that afternoon?
The Waukesha Christmas Parade was that afternoon.
Has the Christmas parade been held in years prior to 2021?
Yes, every year that I've been employed at the police department, we've had a Christmas parade.
And is it typically that third week in November before Thanksgiving?
Yes, every year that I can remember it has been.
Okay. Is there any planning or preparation that goes into holding a parade in Waukesha?
Yes, there are meetings with the group that's putting on the parade in advance. There's also a group of individuals that prior to the parade, usually the Friday before, will post no parking signs along the parade route. There's a group from our city garage or Department of Public Works that will put out barricades at the designated intersections where we request them to put them out.
And what about manpower? What type of manpower would you devote to an event like this, sir?
It's rather significant given the large area that a parade like this encompasses, the estimated amount of attendance at the parade between detectives, police officers, supervisors, reserve officers, community service officers. I would say we have in excess of 30 additional bodies planned that day just to handle the parade itself.
You mentioned the use of individuals such as reserve officers and community service officers, I think you said. Is that correct?
Yes.
Are those sworn law enforcement officers?
They are not sworn, no.
What is their role or function?
The reserve officer group is a group of people who volunteer their time to help with events like parades. They're given training in directing traffic and closing streets down. A community service officer is a paid position. They're part-time employees, usually younger individuals looking to learn more about a career in law enforcement.
And you said also parking attendants would be assisting in this endeavor?
Correct. We're usually looking to get as many extra bodies as we can, and the assistance from our parking agents is usually required for this event as well.
And this would be in addition to the sworn law enforcement officers that are assigned to work the parade?
Correct.
And obviously you still need other officers to patrol the city, correct?
Yes.
Where is the parade held?
The parade takes up a large portion of our downtown area, area along White Rock Avenue, between Niagara Street and Main Street. And that's about a 3-hour process of getting all the parade participants into that area and lined up accordingly. The parade itself runs along Main Street from White Rock westbound to the Veterans Park area, where it makes a turn and then heads up Wisconsin Avenue and ends near the Waukesha Public Library.
Sir, if I could ask you to stand up and refer to the diagram behind you. This is a map that's been marked as State Exhibit number 1. Do you see that sticker in the bottom right-hand corner?
Yes.
Okay, I'm sorry, it's a little tight up there, but if you could start in the upper right-hand corner of the map, and if we put up the digital copy of the map as well, I know it's hard to see, but then we'd have to do the screen share again. Is that correct?
Yes, that's my understanding.
Okay, I'm going to ask the paralegal to please put up State's Exhibit number 1 on the digital copy as well.
Is that right?
Sorry, we got the wrong one.
think that guy in the corner there is a private investigator, but
All right,
for
Madam
the
Clerk, thank you.
state.
Right here.
As you present that, you know you can hit that little arrow, that will get rid of those extra
He
things.
sat there the whole case, but he
Go ahead.
never.
All right,
spoke
and,
anything.
Ms. Gussie, if you could zoom in on the upper right-hand corner, please. There you go. All right, sir, if you can use the map, the big map in front of you, please, and the jury can follow along with the digital copy if they want. So starting in the upper right-hand corner. Yes. What's up there, please?
That is Frame Park.
And what's at Frame Park?
Frame Park has a lot of, it's got a playground for children. There's a very large baseball diamond, different shelters. There's a formal garden. There's a boat launch. It's a very large park in our city that encompasses a lot of different activities.
Is the boat launch shown on Exhibit 1?
Yes, right here.
Okay. And the waterway that's shown on the exhibit, what is that waterway?
That is the Fox River.
Now, is the parade route shown on Exhibit 1?
Sorry, Attorney Upper, can you give me 1 second? Mr. Brooks, just a reminder, you're not muted. All right, I'm sorry for the interruption. Go ahead.
I'm sorry too. I thought I was muted. I apologize.
That's okay. Thank you so much.
Go ahead and point out the parade route, please.
So the parade route in this map is essentially this purple line. This area here is what I referred to earlier as a staging area. And then actually at this corner right here, westbound is where the parade route would follow. Down to the corner here, I refer to this as Veterans Park. That's that area there. And then it would turn up Wisconsin Avenue and end around the library right here, which is that green area.
Okay, we're just putting that up on the digital display too right now. Now, on this map, sir, we've designated several points along the parade route to reflect where various officers were positioned. Is that correct?
Yes.
Could you just briefly walk us through it? I don't need you to name every officer, but just point out the intersections and what was located at each intersection using Exhibit 1.
Sure. I was here at the intersection of Hartwell and White Rock. I had a police SUV, an unmarked police vehicle, trying to maintain the integrity of the route and keeping the road shut down. Here we had various officers. It's kind of a mixed use of barricades, marked police vehicles, police tape, just in an order to keep the streets shut down and make sure that there's a visible representation that the streets are not open.
Okay, please keep going down, westbound down Main Street, please.
Sure. So we come to Buckley and East Avenue here. Both sides of the intersection shut down with barricades. We come down further on West Main Street to Martin Street. The red line here signifies a barricade was in place there. At Main Street and North Barstow Street, again, barricades on both sides of the intersection there. Gaspar and East Main Street, a barricade. We also had a marked police fleet, as we did at other places where the yellow is signifying that. This is our 5 points area, as we call it, kind of a larger intersection with roads in different directions here. So at this intersection, we had a use of barricades, police tape, police vehicles, just a very large intersection to be able to shut down just with one of those things. So it kind of becomes a mixed use of different tools that are available to us. We have Clinton Street and Main Street here. Again, barricades on both sides of the intersections, along with officers. Maple Avenue and East Main Street, barricades and reserve officers. And then we come around toward the Veterans Park area, again, another very large intersection where we had an officer and multiple barricades shutting off the traffic. And then along Wisconsin Avenue here, we had one point at Maple Avenue where we had a CSO along with a barricade.
And right now you're pointing at the very bottom edge of the map, correct?
Very bottom here. And then from that point east, the parade kind of disassembles with floats going different ways depending upon their size and maneuverability at the end of the parade route.
This map, Exhibit number 1, is oriented north, correct?
Yes.
Okay. The items, and I know this is like a vision test for everybody, but on the map, the yellow boxes represent what, please?
The yellow boxes on this map represent police vehicles that were utilized in the parade.
Okay, and what about the blue boxes?
The blue boxes are the names of personnel assigned, where you see an RO that would be a reserve officer, PA would be a parking agent, CSO would be our community service officer, OFC would be an officer.
All right. The reserve officers and non-sworn officers, would they be wearing a police uniform or some type of designation?
Yes, they all have.
Hold on.
There's an objection. It's overruled. He may answer.
All personnel on the parade route are in uniforms. Additionally, everyone, it's part of our policy that they are required to wear traffic vests, which would have been a yellow and could have been blue and yellow or orange and yellow traffic vest that says police on it.
Okay. I'd like to go back to the area on White Rock where you were located, where the units were staging, correct?
Yes.
Now, can you describe for us where the road was actually shut off by police so that no motorist could actually travel down the road?
Sure. I mean, this actually further north than here, it's off the map, is where we had our first point of shutdown. It was at White Rock Avenue and Niagara Street. We used Niagara Street to divert any traffic that would have come that direction. So then along here, they were shut down at Niagara. There was another street called Perkins where it was shut down. And then
Yeah, there is. It's
right
called
here is
Disney.
Baxter Street.
That's not
Where we had
naughty.
the street shut down.
Disney.
Additionally, here along the staging route, North Hartwell Avenue here was shut down on both sides of it to ensure no traffic entered into the staging area while that space was occupied.
Exactly. That's why I pointed
All right,
him
and
out.
before I have you sit down, there's two other areas designated on the map I'd like to ask you about. This is on the left, upper left quadrant of the map. On the north side of the Fox River, there's something indicated as the Barstow Hill. Do you see that on the map, sir?
Yeah, it's right here by the green line.
What's the Barstow Hill?
The Barstow Hill is just a very steep hill that more or less connects our downtown to a neighborhood and is a thoroughfare of traffic coming and going from the downtown area.
Okay, that's Barstow Road there?
Correct.
Okay. And then just to the right of that, there's something marked as a mobile gas station. Is that correct?
Yes.
Objection.
Overruled.
And there is a gas station at that intersection, sir?
Yes, there's a mobile gas station at the bottom of the Barstow Hill.
Okay.
Why
All right,
would you
please
check
have a seat,
that,
sir.
Dummy. I don't think she said Viagra.
Sending officers out to their locations along the route here.
At 1 p.m. is when the initial few officers head out to secure the staging area. So they're out there from 1 o'clock until about 3:30. Between 3 and 3:30 is when the rest of the personnel assigned to the parade would have arrived at their locations along the route.
All right. And I assume you're in some, Your Honor, we just lost part of the Polycom.
Well, we'll pause. It won't happen otherwise.
And we can take that down for now. We don't need the state cable displayed at the moment.
Mr. So we lost you for a second. As soon as we knew it was down, we stopped. We didn't take any additional testimony. I just want to confirm you can see and hear me.
Yeah, I can hear.
And you can see the 4 cameras, so the witness as well?
Yeah.
All right, thank you.
Okay, so there's somebody that's running the parade as far as lining up the participants and making sure everybody that's walking in the parade is where they're supposed to be, correct?
Correct.
Is there a title for that person?
Boy, I wouldn't know what.
Your objection's noted. It's overruled. He may testify about the question asked.
Or is there somebody that you were dealing with directly that was kind of responsible for the units of the parade and you're responsible for the security of the parade?
Yes, there was a
Overruled. He may answer.
What'd he say?
lady from the Chamber of Commerce who put on the parade that just prior to the parade starting, I had face-to-face contact with to inform her that the route was ready for the parade.
Now, how do you know that? How do you know that the route was ready to go?
Between 3:30 and 4 o'clock, I had driven the route several times within the parade route on the street that was shut down. It was my duty as the incident commander of the parade to make sure that the officers or personnel assigned to the parade were all in their location, that all the barricades were in place, that there was no holes in the parade route that we missed in the planning, and as a final security sweep of the route just to ensure everything was in place as we had planned for it to be.
Can you estimate how many spectators were present?
Objection.
At what time?
I'm sorry, at the start of the parade.
Thousands. Once the parade had started, I was not on the route anymore. I think the last time I drove the route itself would have been just before 4 o'clock as my final lap through.
Okay. And there's spectators on both sides of the road, north and south sides of Main Street?
Correct.
And all the way from Hartwell, all the way down to Veterans Park at the end there near Wisconsin Avenue?
Yes, I'd say the majority of this.
Hold on, there's been an objection. Go ahead. What's your objection?
That is hearsay. We can't know sure where everybody was at.
The objection is noted. It is overruled based upon the foundation previously laid by the witness. Go ahead.
The spectators are primarily
He has no idea.
from the
He
intersection of
just
White Rock
knows
and Main
it.
Street westbound.
Stick his nose in. He doesn't know
So
what he's doing.
you were satisfied it was appropriately safe to start the parade, is that right, sir?
Yes.
What did you do?
I had face-to-face contact with the organizer of the parade. I indicated to her that I checked the route and from the police side of things that we were ready for the parade to proceed, and let her know that she could begin whenever she was ready.
About what time of day was that?
It was right about 4 p.m.
And you had mentioned the units were staging on White Rock near where you were posted, is that right?
Yes.
And did you see, as the units would enter the parade route, then they all kind of move forward, I'm assuming?
Yes,
Overruled.
the parade participants are set up on either side of White Rock Avenue, and they're kind of funneled together into almost a zipper type fashion as they enter the parade route.
And as they march forward towards the parade route, then at some point, is the road behind them vacant?
Correct.
And what do you do when that happens?
We try to cause as little disruption in the city. Shutting down White Rock Avenue, it's a very major thoroughfare in the city, and having it shut down for that extended period of time causes some pretty significant traffic problems. So as the road is no longer occupied by parade participants, we try to open up the road from behind them, keeping the back of the parade shut down, always taking into account a street for a car to turn off onto. So.
Did you remain in that same position near White Rock and Hartwell?
Yes.
And do you remember how you had your squad positioned?
Objection, that's hearsay.
Overruled.
That's not hearsay.
I had my squad positioned across White Rock Avenue in an east-west fashion, essentially in the middle of the roadway. The road is much wider than the SUV squad I was driving is. I positioned it that way to give a visual representation to motorists that the road wasn't open.
And is your squad marked or unmarked?
It is unmarked.
Objection, irrelevant.
It's relevant. The answer may stand. Make sure if you hear an objection, sir, that you wait till I rule on it. Thank you.
Are there red and blue lights on your squad car, sir?
Yes.
Objection, irrelevant.
Overruled. The answer may stand.
Did you have your red and blue lights activated as it was parked across the roadway?
Objection, irrelevant.
Overruled.
Yes. Yes.
You remember hearing something about a disturbance near the boat launch?
Yes.
Objection, hearsay.
Are you offering it for the?
Foundational, Your Honor.
All right, it's not being offered for the truth of the matter asserted. The objection is overruled. He may answer. I believe he answered yes, and it may stand.
All right. What do you remember hearing about an incident at the boat launch?
When I was near my position on Hartwell and White Rock, I was speaking with one of our reserve officers. We were discussing the proper timing of the opening of the road. And I overheard actually on his police radio that he was wearing squads that were not assigned to the parade being sent to a fight at Frame Park that involved knives.
Were you aware of any vehicles being associated with that fight?
Objection, irrelevant.
Overruled. He may answer.
I did not hear of any vehicles associated.
What do you remember next, sir?
I remember seeing and hearing squads responding to this fight at Frame Park. And at that time, we were still focused on opening up the roadway, and I made my way back toward my unmarked police vehicle, and I looked to my right or to the north down White Rock Avenue, and I saw a red SUV traveling toward me at a high rate of speed.
What do you mean by high rate of speed, sir?
Objection, that's hearsay.
No,
Overruled.
it's
He may
not.
answer.
I believe the vehicle was traveling in excess of 40 miles per hour.
Man, know what
What's the
hearsay
posted
means.
speed limit there on White Rock Avenue?
It's a 25 mile per hour zone.
What about Main Street in downtown Waukesha? What's the posted speed limit there, sir?
The speed limit
Irrelevant.
Overruled. It's relevant.
the speed limit throughout the parade route is 25 miles per hour.
What did you do when you saw this red SUV traveling at a high rate of speed?
Objection, leading the witness.
The objection is noted. It's overruled.
When I saw the red SUV traveling toward me at a high rate of speed, I used both hands and waved them overhead like this in an attempt to catch the attention of the driver.
Were you dressed in a police uniform, sir?
Yes.
And just put on the record when the witness, so that's clear, placed both hands over his head in what I would describe as a waving kind of back and forth at a diagonal gesture. Thank you. Go ahead.
Did the car continue in your direction, or the SUV?
Yes, it did.
What did you observe the path of travel for the SUV to be?
Objection, that's hearsay.
Mr. Brooks, it's not hearsay. Your objection is overruled. Can we answer?
Could you state the question one more time?
Sure, where did you see the SUV go? Better question.
Objection, irrelevant.
Overruled.
The SUV entered the parade route.
I want you to describe what you remember seeing as it passed your location, please.
As I was waving my hands overhead, I was approximately 6 feet from where the SUV was driving. As the driver passed essentially in front of me by about 6 feet, I could see the operator of the vehicle and just a dazed, straight, focused look straight ahead, not looking at anyone.
Did the driver appear to respond to your efforts to stop the vehicle?
There was absolutely no response.
Did you notice the car slow down in any fashion?
No, in fact,
Hearsay.
It's not hearsay. It's overruled. He may answer.
as the SUV passed me, I looked over the hood of, or the top of the police vehicle that I had positioned on the road there, fully expecting that as it passed, that I would see the car slam on its brakes as it realized it had entered the parade route, figuring it was a lost motorist. I didn't see that happen. It continued into the parade route at a high rate of speed.
What did you do?
Upon seeing that, I got on my radio in an attempt to notify other personnel assigned to the parade route. I stated that a red SUV had just blown by me.
Do you remember using those exact words, sir?
And that's irrelevant.
Overruled. He may answer.
I don't know if I said a red or maroon SUV, but I remember saying that it had blown by me.
Were there parade units still on White Rock attempting to get onto the parade route at that point?
Yes.
Objection.
Were you able to see the vehicle clearly as it went? I'm sorry.
He objected. It's overruled. Go ahead.
From where you were standing there, were you able to turn and watch the SUV as it traveled past you down White Rock towards Main Street?
Objection.
Overruled.
Just access.
I only watched it for a short period of time before returning to my squad car, knowing that some sort of police action was going to need to be taken.
What did you do once you got to your squad?
I got in my squad car. It was bombarded with the most terrible
Check now, jackass.
It's the most terrible thing I ever heard.
The sounds. Yes. You didn't see anything at that point as far as people getting hit?
No.
Okay. I want to show you a video clip, sir. This is State's Exhibit number 2. Madam Clerk, if you could please turn on the State's table. Yep, I'll tell you. Okay.
Just show it to the witness.
I'll show it to you first. So, Sergeant Warner, if you look at the screen in front of you, we're going to play a video clip. It's pretty short in duration. I want you to watch it first before we show it to the jury. I'm going to ask you some questions, okay?
Okay.
Did you see that clip, sir?
Yes.
Is that a video clip you've seen before?
I have seen that, yes.
Okay. Do you believe that's a true and accurate representation of the SUV traveling on White Rock Avenue, near the start of the parade at Main Street?
Yes.
Move for admission and permission to publish, Your Honor.
Any objection, Mr. Brooks?
Can you repeat that? I'm sorry.
The state just moved admission of Exhibit 2.
No, I object to that. Keep it.
All right, the objection's noted. It's overruled. Exhibit 2, ladies and gentlemen, the jury is received. Permission to publish is granted.
Thank you. Please hit play. Sergeant Warner, is that consistent with the vehicle you saw traveling away from you past the parade floats that were about to enter the route?
Yes,
And is that consistent with the approximate speed you saw it traveling?
yes.
After you became aware that something terrible was happening on the parade route, your incident commander, what do you do?
I drove in my police vehicle down toward the area that I just heard repeated over and over on the radio where the casualties had taken place. And that would have been at Main and Gaspar. And once I got to that position, I parked my vehicle as it was impossible to drive any further.
Was there a call made for assistance?
Yes, I don't know who said it, but an officer used a code over the police radio, basically requesting police assistance from any officer in the county that would be listening.
Did multiple officers respond
Yes.
from within Waukesha County?
From
Relevant.
Overruled.
Waukesha County and far beyond.
Thank you, sir. I don't have any other questions at this time.
Mr. Brooks, do you have any questions for this witness?
Yes, I do. Good afternoon, officer, first off.
Good afternoon.
I'll say this is very emotional, so I'm going to try my best not to keep you up there any longer than you would like to be. My first question is, I noticed that you are in uniform today. Is it fair to say that if you weren't here testifying that you would have been on duty today? Is it fair to ask that or say that?
Not have been at work today.
So did you feel the testimony that you would be giving at trial today warranted you to be in uniform?
Objection, relevance, Your Honor.
Sustained. You do not need to answer that, sir. Next question, Mr. Brooks.
You said you've been in duty for 18 years, correct?
Yes.
In any of those 18 years, have you ever come across or had any interaction with the plaintiff in this matter?
Objection, vague.
Sustained. You do not need to answer that, sir.
Next question, Mr. Brooks.
How long have you known the plaintiff?
Objection, vague and irrelevant.
Sustained. You do not need to answer that, sir. Next question, Mr. Brooks.
known the plaintiff?
Do you see the plaintiff in court today?
Objection, vague and irrelevant.
Sustained. Next question.
Do you have any knowledge of the plaintiff?
Objection,
Sustained.
Have you ever even seen the plaintiff in this
Go
matter?
with the plaintiff.
same objection.
Sustained.
I want to go to the clip that was just shown.
Would you like it shown to the witness again and published to the jury?
I'm sure would he prefer for it to be so again?
I just want to know if that's what you were asking. You can certainly question him about it, and if need be, it can be shown again.
Okay, can you show the witness the video clip again?
Sure. All right, I can tell from my monitor and the witness monitor it is up, but it's not being projected to the courtroom other than that. You can go ahead and play it. All right, your question, sir?
In that clip, is it fair to say that you can see that there are people walking in the street and on the sidewalk? Would that be fair to say?
Yes, I could see that in the video clip.
Yeah, it's a parade.
Do you see anybody being targeted or being in a panic to get away from the vehicle?
No.
Do you see the said driver of that vehicle intentionally trying to hit anyone in that video?
No.
So,
Stop while you're
again,
ahead, Brooks.
I would ask, were you brought here today to testify on behalf of the plaintiff?
Objection, asked and answered.
Sustained. He already answered that he was why he's here.
Again, I would ask just one more time for the record.
Do you see the plaintiff in court today?
Objection.
Sustained. Do you have any other questions, Mr. Brooks?
Do you know of the plaintiff at all whatsoever?
Objection.
Sustained.
No further questions.
All right, thank you. Any redirect?
No.
All right, thank you, Sergeant. You may step down. Is he released from his subpoena?
Yes, please.
All right, thank you. He's released.
Really quick on the record, if I may.
We're going to call the next witness. We have the jury in the courtroom. Do you have a question, sir?
I have a oral tennis motion I would like to be put on the record.
If you have a motion, you'll have to wait until after the next witness is called. Write it down, submit it on paper, and I'll review whether it's appropriate for this court to address. All right, the state may call the next witness.
Okay. We will stop after the first witness, if I can write. What did I say? 8:27:36. Okay. Yeah. So, we will start there in the morning. What an idiot. Yeah, I didn't see this part before. Man. The poor cop. Oh my God. But police forces have, like, mandatory grief counselors and stuff like that, so he got help, I'm sure. But, man. Okay, guys. I gotta go clean up poop now. Ugh. Dog. Okay, guys. Thank you again, Judy, for the gifted memberships. Welcome to the new members. And I will see you guys in the morning at 8 o'clock for more of Brooks Shenanigans. And remember, be kind to people, love your family, and Jesus loves you, and so do I. Bye, guys. Have a great evening. I will see you in the morning. Bye.